Good morning and welcome to Truth and Transparency. Merry Christmas, everybody. Merry Christmas. Let's get hyped for the truth.
University of Idaho murders. Episode 1.
We're starting to win over Bonner's.
Some very interesting details about why investigators have linked him to these murders. One, the biggest clue so far is a tan leather knife sheath that was found next to one of the victims. They found DNA on that knife sheath. And as they were investigating a 2015 white Hyundai Elantra, they linked it to Kohberger, and that's when they really started surveilling him. They found some trash at his parents' house and they took some DNA from that, and that's how they were able to get a match to link him based upon the fact that cell phone records, the forensic evidence there, the several they're saying that there were 12 different times that his cell phone pinged near that residence before the murders, and they say that that's usually an indication that someone is staking out a crime scene before they actually commit those murders. Vicki, Savannah?
Dana, these clues coming out of the affidavit showing why he was arrested. We know that he is going to make, or has made, his first court appearance back. There in Idaho. Walk us through what happens next.
Question. Have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Question. Have you read, seen, or heard that DNA found on the knife sheath was later matched to Bryan Kohberger?
The damage has been done. We've been working very, very hard to keep the sort of noise out of the case. And now it's been injected, at least to these 400 people.
Nobody's injecting anything into the case. A random small percentage of the population is contacted. Have you read, seen, or heard things that are lifted straight out of the media?
Walked into a courtroom today. He's charged in the stabbing deaths of 4 University of Idaho students last November. The defense today questioned the validity of the DNA found in the knife sheath allegedly connecting Kohberger to the murders. They are demanding more information about that DNA from the prosecutors.
They have provided full discovery for the sheath, the DNA found on the knife sheath, but not the other 3 unidentified male DNA samples.
Prosecutors say they've handed over what they have.
We have given the defense everything that we received from the lab. They've asked for DNA workups on other people to the extent that they don't have them. They weren't done. We can't produce something that doesn't exist.
Police arrested Kohberger at his family's Pennsylvania home back in December, more than 6 weeks after the gruesome murders set off panic on the Idaho College campus. His attorneys argue he's innocent and was out driving alone at the time of the murders.
Is that a strong alibi?
No, it is not.
Criminal defense attorney Joe Tamburino, who is not part of this case, says it's a weak argument.
But an alibi defense is not, I simply wasn't there at the time. It's you must provide specifically where you were, time, place. Also, if you have any witnesses.
The defense had also been trying to delay the trial. Just moments ago, the judge ruled the trial will continue as scheduled in October. The victims' families were inside the courtroom and said they are optimistic.
College student killings. New documents just unsealed show that prosecutors say DNA left on a knife sheath was used to link Bryan Kohberger to the murders. And one of the surviving roommates came face to face with him that night. News Force Chris Glorioso has been looking at it. He's in the newsroom with details. Chris?
David, police believe Bryan Kohberger was a sophisticated killer using his advanced knowledge of criminology to try and outsmart investigators. But the court documents released today say he made a monumental blunder, leaving that knife sheath next to one of the victims. Police say forensics on that sheath, combined with cell phone and vehicle records, all point to Kohberger as the killer.
I am going to leave the bail set of this case. Bail.
28-year-old PhD student Bryan Kohberger will have to fight his murder case from behind bars for now. At his first court appearance, Idaho prosecutors argued he was a flight risk because police found him 3,000 miles away from the murder scene at his parents' home in Pennsylvania. It turns out that house is where critical DNA evidence was harvested from the trash. According to this unsealed affidavit of probable cause, first, an Idaho lab located a single source of male DNA left on the button snap of a knife sheath next to one of the stabbing victims. Then, Pennsylvania agents recovered that trash from Kohberger's family residence. DNA from the trash and DNA from the knife sheath identified a male who could not be excluded as the biological father of Kohberger. Kohberger's father is not accused of any crime. This is police body cam video showing both father and son pulled over for tailgating as they drove cross-country from Washington State to Pennsylvania about a month after the stabbings. Bryan Kohberger was arrested in his family's Pennsylvania home last week. The public defender who represented him said Kohberger planned to prove his innocence.
He believes he's going to be exonerated. That's what he believes. Those were his words.
In order to beat the case against him, Kohberger will have to explain not only the DNA on that knife sheath, but also cell phone records cited in the affidavit. Before the 4 University of Idaho students were stabbed to death, police say Kohberger's phone pinged cell towers near the crime scene on at least a dozen occasions, suggesting he was scoping out his victims. They say his mobile phone did not communicate with nearby cell towers during the hours of the stabbings, but the affidavit suggests that is consistent with Kohberger attempting to conceal his location during the quadruple homicide. One of the most chilling passages of the affidavit unsealed today comes from one of the 2 surviving roommates in the apartment. She told investigators just after 4 a.m. in the morning of the killings, she heard crying. She opened her bedroom door and was frozen in shock when she saw someone in black clothing and a mask who walked right past her and out the apartment's back door. The mask, she said, covered the killer's
Welcome to the transparency.
Mouth and nose, but the roommate told police she could see bushy eyebrows, and police described Kohberger as fitting her description.
Welcome to the transparency. Today's the day, guys.
Hey, welcome back, everybody. During the Idaho College student murders investigation, Moscow police contacted the makers of the knife believed to be the murder weapon. The probable cause affidavit says that officers found the sheath to a K-bar knife next to Madison Mogen's body. DNA on that sheath helped police connect Bryan Kohberger to the scene. Now, the director of sales and marketing for K-bar told TMZ that investigators contacted the company about the knives and sheaths they sell, but K-bar did not have any records of someone named Bryan Kohberger purchasing one. Experts say the knife that would fit the sheath is a 7-inch utility knife, commonly used as a tool by campers or hunters. While police haven't found the knife itself, the sheath.
All right, guys, good morning. Welcome. Give a shout out here to Sunny Days. Thank you for that super sticker. We do have a goal. I want to reach that goal because I'm going to make a lot of phone calls. We're going to see who we can get to talk to us about what it is as far as the procedure, and is Ann Taylor truly just trying to go to the Supreme Court and try to change the law? Come on now. Laughable. But thank you, Sunny Days. Liz, thank you. Let's reach Lana's goal. The goal is for us to be able to possibly, I want to know if Bryan Kohberger's other attorney is under the gag. And that's fine. Under the gag, great. But you just can't talk about certain things. Procedure, maybe he just doesn't want to talk about it in period. So that way there's no question. They see such a channel like myself being pro our rights, we the people. So Moonlit, thank you so much. Gifted membership. Somebody got it. Gail, thank you so much. Thank you for all you do. You rock, Lana. Thank you. Whiskey Jack, let's go and show us what prosecution and law enforcement is hiding and their lies. And then William, good to see you in here, William. A lot of you guys have been with me from the beginning, and we've been waiting for this day for a long time, the suppression hearing. People are referring it to a Frank's hearing. People are referring it to, I don't even know what. But this is a suppression hearing. And then just last night, new documents dropped. So what I want to go ahead and show you guys, that's why I'm starting early, is to bring up those new documents, which let's go on over here to Hector. What do you got for me, Hector? Well, if anybody wants to take their very handy-dandy notes, make sure you guys do realize that the case number has changed. This is the case number now that it's in Ada. This was the case number when it was in Latah. So that's that. But first up is, this was the reply, and it's a really important reply. And for, I believe that the state and the judge, you can twist anything that you want. But this was the reply to the state's objection to the defendant's motion to unseal the IGG, the suppression briefing and hearing. Now, let's get this straight. The reason that, well, I'll let this this motion talk a little bit, but people are getting it confused as to why this was ever, when you have like a bunch of sealings. It's because in the beginning, they stipulated to things, and they talk about it right here. And it was, we need a gag order because of all the misinformation. Ann Taylor's just getting on the case, so it couldn't have been her and the defense putting out misinformation, right? Because there was no defendant in the first 6 weeks. The only narrative that we've ever heard from the public has been from the police. Okay, that's been the only narrative. And so here, the reason for the gag, and it's perfectly stated in this argument, is Mr. Kohberger stipulated to a non-dissemination order to avoid over 100 law enforcement personnel from speaking publicly about this case before trial. That stipulation was in no way intended to circumvent his right to have matters properly before the court, because it still continued to be this narrative to this day. When I woke up this morning and saw News Nation and other people dropping their 1 minute or 3 minute clip and blurb about that, okay, it's always been sealed, the defense has always wanted this, no, that's inaccurate. That's just completely inaccurate. If you're going to try to have, remember Ann Taylor when she was like, well, hey, Judge, we need to have this. If we're moving venues, we need to have this now, not later, right? Remember Judge was like, we can take all that up about changing a venue. Like, why do we have to do that right now? Do you guys remember that? If you don't, please go back and listen to one of the first two hearings where Ann Taylor informs him of that. And it's one thing that, hey, we're sealing things or we're redacting things because we don't want to have somebody's name out there. Okay. It is another thing to completely seal or hide the entire case. And that's never been what Bryan Kohberger or his team wanted. Okay. It's been to, hey, well, I just got arrested, right? And regardless of who would have ever been arrested, the complete narrative up and into the point of arrest has literally come from law enforcement. And now right here today, and even months before right here today, but at least right here today, we know that law enforcement has put out false things to us while they were hunting for a killer. So the defense, he was saying, we're not letting you twist this. We got into a non-dissemination order to avoid over 100 law enforcement personnel from speaking publicly about this case before trial. That was a stipulation, and it was no way to circumvent his right to have matters publicly in the court, be heard openly, with a judge presiding over an adversarial hearing. Like here, you're the referee. Like you're going to be there. The significant downside to having stipulated to that non-dissemination order is that Mr. Kohberger cannot correct the many false reports in the media, which have resulted in an overwhelming public sentiment of his guilt. Do you want to know how I know that that's accurate? Go into mainstream media's comment section. Go into mainstream media's comment section. And these people are saying things like, how are we still talking about this? Just already fry the guy and blah, blah, blah. Like it's been so long, and it's been how long now? And they just want to keep on, the defense just keep on procrastinating or delaying. And go read the comment section in mainstream media when they post anything. And the comments in those, it's absolutely absurd for what these people, they're either trolling or they are that misinformed, and mainstream media just lets it be there. Wild. Do you understand if I was to let stuff like that stay in my comment section? Let's just be real. Okay. If I was allowing people to comment in my comment section about killing people, all right, how do you think that would roll? Like, I'd be burned at the head. Like, oh my God. Absolutely ridiculous. And so do I think that the defense is just saying this? No, just go and look in the comment section, go and listen to the mainstream media clips. And it's wild. It's absolutely wild. It is what it is. So it is no surprise, okay, that the state wants, let me just back up and say that all of these many false reports in the media, which have resulted in an overwhelming public sentiment of his guilt. Okay. So in a way, just like how Richard Allen kind of had to do it, you have to basically prove that you didn't commit this crime versus the state having to prove that you did. Okay. So, but it is no surprise that the state wants no part in stopping that narrative and hence objects to an open suppression hearing. Why is the state objecting to any of this? These are the same people that are supposed to uphold our rights, the state, the government. All right. They're working for the government. And so why would the state, if the defendant wants this to be public, right? And wants this document out there as it should be, why would the state not want that? Why wouldn't the state puff like, hey, I'm going to stick out my chest, man. Look at how we got this, man. Like, this is how good we are. This is why you guys should believe in us. This is why you should back us. But here, the state's like, we're objecting to this. We're objecting to this. Well, I said to myself, okay, why? Let's find out why. Why? So the state wants no part in stopping that narrative and hence objects to this open suppression hearing where legitimate legal issues will be heard. Mr. Kohberger does not believe the non-dissemination order is the same as closing proceedings that are public. The party seeking to close a suppression hearing over the objection of the accused, there is law, there is case precedent about this. It is then on the state to then have to provide reasons that meet these criterias. So the closure, if it's being objected to, say, hey, the defendant wants it all out there, the state doesn't, well, then the state is bound by this. They must advance an overriding interest that is likely to prejudice. The closure must be no broader than necessary to protect the interest. The trial court must consider reasonable alternatives to closing the hearing. It must make findings adequate to support the closure. And that's Waller versus Georgia. I went ahead and read up on all that this morning. The interest the state asserts are influence on the potential jury pool and possible inadmissible evidence being discussed in open court. Wait, for the past 2 years, all we've discussed is stuff that might not make it through that door. Like, it doesn't come up in court about the venue being changed and why that had to happen. But we saw it all, right? But hey, they're saying if we have this open, it's going to affect the jury pool. It's going to taint the jury pool. How? Think about that. How? Think about basically what they're saying. It'll affect the jury pool. Because when we go to talk in voir dire, we're going to ask them if they've what? Read, seen, or heard that there was a sheet that had blood on it and it belonged to Bryan Kohberger. Raise your hand if you heard that. Okay, they're automatically out. Well, shouldn't they be automatically out anyway? Because that didn't happen just in a suppression hearing. That's happened for the past 2 years. I mean, think about it. How would this potentially affect the jury pool? Because of what? If they read, seen, or heard and followed anything to do with this case, then they shouldn't be in the jury pool. They shouldn't be there anyways. So this is odd, says the defense, because such matters are routinely discussed in court, and much of what may eventually turn out to be excludable as evidence in this matter was released to the public with no concern for Mr. Kohberger's rights by the state. Oh my God, Lana, you just talked all that crap, and then here it is, the next sentence, that's what they say. Yeah, it's exactly what they just said. Like, this is odd, because what are you talking about? These questions are going to be asked in voir dire anyways, right? Whether it's in or it's out, right? Because I want to know if you know about any of this case. So I'm going to ask you, let's say that it doesn't get suppressed, right? If it doesn't get suppressed, I'm still asking if you know about it, because if you know about it, then you're not coming on this case, right? Well, but it doesn't just work like that. You have to have a prejudice about what you heard. Yeah. And then I'm going to ask you, do you think that you could be fair and impartial after hearing that? And that you've had how long to ponder on the fact that you knew that there was DNA on, and what now is being said that it's blood over, if you listen to that channel and those, the TV court people that, who was it? We talked about that the other day. This is an oxymoron, if you ask me. Okay. Clear as day. Like, suppression hearing is totally should be open, and if people are watching this, they shouldn't be on the jury, right? So whether it's in or out, right, it doesn't matter. If you know about it and then you have some type of feeling about it, this is absolutely absurd. Unsealing the pleadings and hearing post jury trial. So they had this discussion, by the way. And hey, guys, guess what? We're just going to unseal everything after the trial. That way the public can see it all. Well, guess who that still infringes? Bryan. Because guess what Bryan has to do? He has to go through the post-conviction stages, okay? And to try to remedy this. Just like if it was me or you. We would have to go, after we were found guilty, right? We would have to go through the post-conviction stages and phases of our criminal justice system, because, oh, wait, guess what? Afterwards, we can go ahead and make all this public. And then my, My appellate attorneys can work on this and that. Get out of here. No. So the defense here is arguing that no, it is not an alternative just to unseal something after the trial. That is not an alternative. Well, don't worry, we're going to make it all public after the trial. Okay. It is no alternative since the recommendation remedy is post-trial and has right to a public trial is now. Additionally, since all orders sealing matters in this case are temporary, offering to unseal post-trial is not an alternative because that's an oxymoron. Again, it's a temporary seal, so it's eventually going to become unsealed. So what you're basically telling me you're going to do, we're doing anyways, so that's not a remedy. That's not an alternative, rather, because it's already happening. So it's like you're trying to win over your kid by saying, hey, we're gonna go get ice cream after dinner. We were already going to get ice cream after dinner. I heard you tell Dad that. Get out of here. Like, the state's concern about potential juror influence is misplaced. 100% it's misplaced. The only influence there may be on potential jurors is they're learning that there is more than the current guilt narrative about this case. Emphasis added. So think about this. The state's concern about potential juror influence is totally misplaced. And then here, it's just in one simple sentence that the only influence that there may be on potential jurors is they're going to learn that there is more than the current guilt narrative that is out there. And that's the facts. And so the state is playing that. They're like, we don't want anyone to hear this. We don't want anyone to hear this because then people that are out there that, like this could influence the way that they're thinking. And why would those people ever be on the jury? Like, your job is to sniff those people out. Okay. And you don't do it by infringing our rights. You don't infringe our rights to do your job as a prosecutor. Okay. So be it if people start thinking that this guy isn't fucking 100% guilty, because you're constitutionally innocent right now. And why wouldn't we be affording that to him or anybody else for that matter? Especially in a case like this where it is anything but open and shut. And people that think that are absolutely totally misinformed, and so is mainstream media. Mainstream media is completely misinformed, and they can say, well, Lana, you don't know procedure. I don't? Okay. Well, let's see what happens here today. Let's see what happens in this hearing, which people are telling people out there that it's not public. Then you're not reading reports. It is 100% public. Okay? It is 100% public, and what they are going to do is have a portion at the beginning not public so that they can make we're going to get to it because it's really funny how they're doing this. This is not labeled the Franks hearing, but it's being treated as one. And the judge says this. It's mind-blowing. So it is no secret that a public hearing will allow the opportunity for the adversarial process to lend itself to a fuller picture. One that is more than the current guilt narrative. Mr. Kohberger's Sixth Amendment right to a fair and public trial does not begin with jury selection. Boom! Mic drop. Do you want to know how they got around sealing this portion of it? Because Judge Hippler sided with, yeah, it's going to affect the jury pool. And tried to use, well, didn't you move it in the first place because of that? They didn't move it in the first place because of that. It was they couldn't get a fair trial in Moscow, Idaho. Okay. because of all the connections, because of law enforcement, married to people and relatives. It's such a small community that you are going to know somebody involved in this case. You are married by, or you're married to somebody, or you're related. They're twisting, and the judge did it too. He is twisting and using one little sentence to back all of this. It's like, wait, we moved. We asked for it to be moved, not because we knew that there'd be suppression hearings and that, oh my God, all these people, like, what? No, we moved it because of all the pre-trial phase, the guilt phase of everything that was going on in that community, okay? And the relationships with the university, with the police. There are so many families in this case, and then you're reached to that in that area, that we wouldn't be able to have an impartial jury because of the relationships. Those aren't there in Boise. Not because of what they're thinking, but because of the relationships. And it's not just to the victims. It's somebody that's let's say that you're a restaurant owner. Let's say that you're a small mom and pop business there. Someone finds out that you're on the jury, right? And then, you have these pressures to vote a certain way because people are going to blackball and blacklist your mom and pop place. That is what we're talking about. But for you to go ahead and twist this and argue it basically the way that you are, no, you didn't meet the burden that's put on you, the objector in the situation, which is the state. It's period. Absolute crap. So again, Mr. Kohberger's Sixth Amendment right to a fair and public trial does not begin with jury selection. It began the day he was arrested. Now, 2 years into the state having control of the narrative through its extensive probable cause statement, a suppression hearing is exactly the proceeding where his right to have motions heard publicly matter. Moreover, he holds the right to a presumptively open hearing. As to the state's points about the IGG being inadmissible evidence, Mr. Kohberger has the right to confront the evidence against him at trial, especially that which identifies him. And I underline that because it's everything in this case, in my opinion. Okay? It's everything. Because of what Payne put in the probable cause affidavit. You understand? Payne put in the probable cause affidavit right here. This makes everything. Identification of Bryan Kohberger came from this. DM stated she opened her door for the third time after hearing the crying and saw a figure clad in black clothing and a mask that covered the person's mouth and nose walking toward her. DM described the figure as 5'10" or taller, male. How the fuck would she know it was a male? Not very muscular, so could be a female then, but athletically built with bushy eyebrows. I know a lot of broads with bushy eyebrows. The male walked past DM as she stood in a frozen shock phase. The male walked towards the back sliding glass door. DM locked herself in her room after seeing the male. DM did not state that she recognized the male. This leads investigators to believe that the murderer left the scene. Play every body cam of the noise complaints. Nobody knew anybody there. Shit, the people that were partying, they didn't even know who the owners were. What? She didn't know half of the people that were ever coming through her house. Now, also, if DM was, quote unquote, drinking, intoxicated, doing drugs the night before, she doesn't wake up until, way later. Is this even a reliable description, the description that it is? Is it reliable? Should Payne have put in the probable cause that DM was also fucking hammered, told me she did drugs, told me she did this, told me she drank this, told me where she was, what she was doing, right? As we talked about yesterday. Now, Payne then says from DM's statements that then he was the one to identify Bryan, because then he looked at his ID, Bryan's ID, and determined that Bryan had bushy eyebrows. And then he met the description of DM. Wow. Again, all of this is in the probable cause, right? And then the question is it's very simple. Officer Payne, why did you ever look? How did you ever come across looking at Bryan Kohberger's driver's license? Well, because the FBI gave us the tip, Bryan Kohberger. And what was that tip off of? They used investigative genetic genealogy. Now tell me how investigative genetic genealogy is not what led them to Bryan Kohberger. When I say them, Moscow Police Department. It's in here. It was his determination. He doesn't say, I then showed Dylan a six-pack. He doesn't say, I then showed Dylan, a bunch of eyebrows and said, which one is it? He determined that Bryan Kohberger fit the description that Dylan gave because he determined that Bryan had bushy eyebrows. It says nowhere in here that Dylan determined that. Maybe Dylan would have been like, oh God, no. No. This dude had like freaking full on bush. You know what I'm saying? Now, so that's what it means when they're saying, the defense is saying that Bryan Kohberger has the absolute right to confront his accusers and how they got to him and how they identified him. And they identified him by IGG, Moscow Police Department, identified him. And then the person that said, yep, this fits the description of Dylan Mortensen, Payne. Because let's say that, let's hypothetically say that the IGG would have come back and it was to a girl named Susie Smith. Okay. Susie Smith. And, oh God, let's pull her up. Oh, well, she's 5'10". I mean, and her eyebrows, they're not penciled in. What would have happened then? What would have happened? Oh, but Dylan said she saw a man. Well, the person was wearing a mask. How the fuck would Dylan know if it's a guy or a girl? Like, oh, they didn't have any hair coming outside of the mask, let's say, underneath. Oh, look at Susie Smith has fucking short ass hair. It wouldn't come out, it wouldn't flow out of the mask. Absolutely ridiculous. Absurd arguments here. This is great right here. This is awesome. As to the states pointing out that IGG being inadmissible evidence, Mr. Kohberger has the right to confront the evidence against him at trial, especially that which identifies him. Previously, the state has characterized IGG information in this case as a lead, a tip, and at one point, remember, we were all confidential informants. We were all confidential informants, according to Bill Thompson. Bill Thompson wanted to put all of us and list us as we're not giving up this information with this IGG because we are all informants. Okay? The state does not get to hide behind an informant to prove identity. Whether the state wants to describe the IGG identification as a lead, a tip, or an informant, such is testimonial in nature to prove identity. That means like testimonial, like somebody has to testify to how you identify Bryan Kohberger, how he became a person of interest in this case. You understand that? To think that you can just start this case by saying, we did a neighborhood canvass, we noticed that there was a white Honda Elantra, and we just started inquiring all these white Honda Elantras. And then we came across Bryan Kohberger's white Honda Elantra. But I never got the tip or the lead because WSU never gave it to me. I didn't know about it. And then they located him on November 29th. I didn't know about it. I never talked to that guy until December 20th. But here on December 19th, the FBI, they were the ones that told me that it's, they ran, or actually they couldn't really tell me. I really didn't ask any questions. They just said, here, this is the person you want to look into. But we can't tell you how we got there. His name's Bryan Kohberger. Say what? Let's hear this. Let's hear this testimony. Okay. Right now, the courtroom is open, and we are in session right here at 11 o'clock. Let's shake it. We are waiting patiently. We are waiting patiently. We'll be getting updates to say when it is going to be open. Okay. So take a look. But the state does not get to hide behind an informant to prove identity. So the purpose of IGG was to investigate a criminal case. What is more is without IGG, the defense is saying, this case would never have been brought against Mr. Kohberger. You understand? They're stamping it saying, you didn't get to Bryan because of this white Elantra. Okay, none of that. You got to Bryan because of this sheath that the defense is saying it was a placed sheath, and you later noticed. So we're going to get a lot of, hopefully, answers to dates of statements that were made in this probable cause. I have a ton of them. So the Sixth Amendment, there's a confrontational clause. They talk about that, and then that's it. Now, an order regarding presentation of IGG, and here's the order then after they met on Tuesday. Okay. Here's how Hippler did it. And this was his order. And so everybody can understand that Hippler said, before the courts is defendant's motion to unseal IGG suppression briefing hearing. A hearing on the motion was held on January 21st, during which the court denied the motion from the bench. This order memorializes that ruling. So let's see if they are live right now. Let's take a look. They're live. Let's see what's going on. Here we go. Court will begin soon. That's where we're at. So we are looking at a blank. They are not live right now. So this was Hippler, him just memorializing it, and said that as defendant has observed the case has garnered intense, if not overwhelming, national and international attention in the media. And it's like, and so what that there's attention on it? It doesn't matter. Okay. It doesn't matter. This has led to the sealing of several filings in this case. Pursuant to ICAR 32, which contemplates sealing information temporarily when necessary to protect the rights to a fair trial. And I believe they're making a huge mistake. Again, this is all appealable. So I just think that you're making a huge mistake. The defendant wants it that way. The state just say, okay, sounds great. You know what I mean? So further, Judge then presiding entered a comprehensive non-dissemination order designed to prevent publicity about evidence that may or may not be ultimately admitted at trial from tainting a prospective jury pool. Now this is, so he's saying, he's using Judge's words here. And among the sealed filings is the briefing on defendant's motion to suppress. Defendant seeks to unseal this briefing as well as the hearing on the suppression motion. He points out that the public has long been aware that law enforcement used IGG procedures in investigating this case. However, because the details of the IGG investigation have been withheld from the public, defendant contends there is a significant and prejudicial misinformation circulating in the public eye about his guilt. Unsealing, he argues, will correct such misinformation, protect his Sixth Amendment right to a public trial, and preserve the public's First Amendment right to know what is going on in its courts. The state responds that it has no objection to unsealing the IGG evidence after trial, but doing so prior to trial poses a significant risk of tainting the jury pool. The court agrees. And now that is absolutely absurd in the mere fact that in voir dire, you ask somebody if they watch this, do they know about a suppression hearing? Did they see a suppression hearing? Do you know what the word suppression even means? That's what I need to start asking people. Do you even know what this shit means? And so basically, I'm not blaming Judge Hippler here. I am blaming the prosecutors, because had the prosecutors not objected, it's all in. We're all watching right now. And then the defense's argument is that, listen, we have so many things that are overlapping and intertwined. I need to oral argue and cross-examine people, as well as, bring our witnesses forward for direct testimony. And I'm not going to think in my head and worry, oh, wait, hold on, I have to be careful because I can't say certain things because they're going to say, oh, wait, stop. You're talking about, we got to go off live and we got to, hold on. Are you kidding me? So why would the state even want to do any of that? Even put themselves into a situation? Because there is case law that because of a suppression hearing being, it was a RICO case. Like, you want to do all this over again? Sounds great. After William Lindsay, thank you so much. $9.99. Sleuthy Kitty. Whoop, whoop. Gifted one Truth and Transparency membership is too late to skate by. Like all the letters and the numbers. Perry, $2. Thank you so much. Mama Steph, $2. We're trying to reach this goal, always bringing the truth and advocating for our rights. Lana is the goat. That hair. You guys like it? It's wild. It is possible, or is it possible, the MSM is afraid of being sued and now claims that they didn't understand? No, they're getting paid. They know how they have to be. So that's no, man. Absolutely not. No. Woo, Liz, baby. Doing this Christmas morning. It is Christmas morning. So again, but Judge Hippler says, hey, guess what? Yep. It's going to taint the jury pool. It ain't tainting shit. Taint. Chain it up. Ridiculous. Absolutely ridiculous. Then we have the First Amendment and the Sixth Amendment. Guarantees the right to an open public trial. These rights benefits the accused to the extent, quote unquote, the presence of interested spectators may keep his triers keenly alive to a scene or to a sense of their responsibility and to the importance of their functions. So at least what Judge Hippler did say, though, is that because they can't do certain things is, no, this doesn't all get sealed, is boom, these little clips that are happening here in the beginning, because there is a lot of overlay. So this stuff is going to come out. It's going to come out in the AT&T motion to suppress, the second AT&T, the Amazon. I mean, trust me, this stuff is all coming out because it overlays. You understand? So, and I can promise you, Judge Hippler is not going to be saying, hold on. Can you turn off that YouTube stream for a second? Can you mute it? It's not going to be happening that much. No. But he's saying, once it's out the tube, I can't put it back in the tube. Imagine how Bryan Kohberger feels about that. Once it's out the tube, I can't put it back in the tube. Everybody out there seems to think that Bryan Kohberger was following all these victims on social media and stalking them by going to the scene or near the house on 12 separate occasions. Yep, you can't. How do you take that out of the tube? Spread this far and wide. So still closed portion, not live yet. Yep. Look at this. Look at this. Look at what they're hiding behind. The court agrees the United States Supreme Court has recognized that publicity concerning pretrial suppression hearings poses special risk of unfairness because it could inform potential jurors of inculpatory information that is eventually going to be inadmissible of the actual trial. Are you fucking kidding me, man? Acting like they care about the defendant here. Inculpate, of the defendant's guilt. Well, then don't you think the defense would be, I don't know, saying they want it sealed? It's usually not this way, you guys. Okay, it's usually not this way that somebody that is begging for something to be open, okay, is doing it because they're like, yeah, the jury's going to see how guilty I am. Woo, these potential jurors. No. Like, I mean, what? That's usually the defendant that's asking, just like in Richard Allen's case. Richard Allen was begging for this shit to be open and cameras in the courtroom and all this shit. Okay? And what's going on now in that case? Oh yeah. Richard Allen's innocent as fuck. And the government's going down with that case. That's what's happening over there. But and for all you nosy people out there that even think that this man is guilty, let's say that he's so guilty, and I see all your comments in the most ridiculous mainstream media sections. Well, don't you want to see all that guilt, baby? Don't you want to tune in and just watch the suppression here and how guilty he is and see how guilty he is? Don't you want to see all this evidence, that juicy juice? I mean, you're wasting all your time watching all that filth that you're just ingesting. Don't you want to come see it? I'm just glad that people like that truly aren't watching my channel, because I have a hard time. Like, I don't even know how you function in life with the brains that I see in those comment sections. And then I think to myself, they aren't functioning in life. It's like that. It's obvious. So John, is the suspicion that IgG was used without the match source opting in, but IgG, we don't know. See, that's the whole thing, is why speculate? I don't know. We don't know. Why don't we find out what they did? Why don't we find out? And that's a great question. I mean, find out. And how we find out is by, and that's what the defense said right here. There's so many misconceptions. And so my question to Judge Hippler is very simple, and to the prosecution, is how would IgG taint the jury pool? Specifically, you just saying it's going to taint the jury pool. I want examples. Is it the use of IgG is what's going to taint the jury pool? The results of the IgG is going to taint the jury pool? Explain to me how this portion, but none of the other stuff that's going to come out, is going to taint the jury pool, but the IgG is going to taint the jury pool. So nothing to do with how people get, wiretaps, I mean, just the IgG. How? I want to see all the guilt. There you go. See, there you go. Admit it. There you go. See, yes. Kimberly, thank you. I hope half the people in here are watching that think he's guilty. That's great. At least you're not getting it from somewhere else. She says it. I want to see all the guilt. Yeah, because he is constitutionally innocent until proven guilty. That's why you should want to see all the guilt. I agree, Kimberly. Because it's very obvious, okay? When Hippler says this, that the court agrees, given the intense media scrutiny, I don't give a shit about the scrutiny about it. Who cares? It's still going to be, whether this is open or closed, it's just going to be more scrutiny. I mean, what the fuck are you talking about? Secrecy brings scrutiny. I mean, does anybody not know what cause and effect are? Did they miss that day at school? By this case, particularly in Idaho, the potential that the IgG evidence will not be admitted at trial, and the fact that most of the evidence in this case is still under seal, the court is concerned that releasing the IgG evidence by making the briefing and testimony portions of the suppression hearing public poses too great of a risk in tainting an already relatively limited jury pool. Again, how in the world, whether these 12 other things aren't going to taint anything? Absurd. The parties' legal arguments, though, on the IgG evidence will remain public, guys. So that's what I'm trying to tell everybody. You need to hold on. When people are trying to say this is not public, it is, okay? So what is up, Forensic Fury? No way. Good to see you in here. Good to see you in here. Colleen O, been a member for a year. Thanks for all the hard work, man. Thank you. Richard, unfortunately, Bryan's case isn't out of the ordinary when it comes to people commenting on it when there is no conviction. You're absolutely right. You're absolutely right. People think when people get arrested, it's like, yep, lock him up, start torturing him. Is that Wisconsin grandma? Hello, thank you, 999. Coffee cake, 999. Lana, you are an outstanding truth seeker. Keep it up. Thank you. That's how I think about myself, If Bryan did it, Bryan did it. But who are we to know if he did or didn't when all this stuff is not public? 1:45 a.m. I hope. Stay awake. LOL. Always do a great job, Lana. Oh, yeah. Stay awake. That's right. We got people all over. Yes. Thank you. $5. Thank you. 799. Let's get 50 super chats so Lana can speak to BK's first attorney from PA. The one who said that BK was looking forward to being exonerated. Yes. We're making phone calls. Rose, thank you so much. $2 there. Thank you. Sparkly Starfish, Lana, you are an awesome person fighting for our rights. That's exactly what people are missing too. That this isn't Bryan's rights. These are our rights. These are our rights. Totally our rights. Like, you violate one man's rights. The way that the law works is that you're violating all of our rights. And if you don't know what that truly means, it means that when a judge is making a ruling, they cite a case and they say, in this case, this is what happened, and so therefore this is how I'm ruling. So Bryan or Richard Allen or whoever it may be, if they are wronged, that is case law, right? And then other judges can use what that judge did and apply it to then my case, your case, our children's cases, grandchildren's cases. That's what that means. So it's about our rights. It's about the Constitution. And the people that are supposed to be upholding the Constitution are the very people that are fucking violating it every motherfucking day. That's what it means. And we're over here like, yeah, fry him. Wait, what? Fry him, don't fry him. How about the process? How about the process to which you want to fry him? I mean, total ignorance. Atrocious, like just, those are the people that you don't copy off of in high school. Fry him. Goals. Please support our gal Anna if you can. Thank you so much. I have a bad feeling about Hitler. I hope I am wrong. I don't give a fuck. Hitler will make his bed and he'll lay in it. Maybe DM was looking at her drunk self in the mirror. Can we investigate that, Pain? Thank you so much, Shelby. You are amazing. $10. I appreciate that. EMI, thank you so much. Carson, what's good? Girl, shake it. Let's hit that goal. All right. Halfway to the goal? Oh, hell yeah. You guys are going to make me work for this. 1,000 in chat. Yep. Thumbs it up, thumbs it down. You have an opinion, make yourself known. If you're all here for it, we're here for the suppression hearing. We are standing by you guys. We are standing by here and waiting. So the parties' legal arguments on the IGG evidence will remain public. This approach is consistent with both Waller and ICAR 32I3A6 and will not contravene defendant's Sixth Amendment rights. Consequently, defendant motion to unseal is denied. I'm telling you guys, this is so much overlay. We will get it all. I'm confident. I'm confident that we're going to get a ton. And it's just who comprehends it, you know? Like you said, like you can spin anything. It's all blah. Now, something that I thought was interesting is then he did an order regarding presentation of IGG, okay? And I just want everyone to know that as discussed with the parties at the January 21st, 2025 status conference, there is a significant evidentiary overlap between defendant's motion to suppress, which, you know, the IGG, and the defendant's motion for a Franks hearing, insofar as it pertains to his proffer. Remember I told you guys yesterday? What was Bryan Kohberger's proffer? They offered a proffer to say, hey, we're showing you all of this. This is a proffer that we're speaking the truth here, okay? So pertaining to his proffer regarding law enforcement's use of investigative genetic genealogy. And I'm going to tell you what I believe that proffer is. And that proffer is that they obtained it using through the FBI by means of, they obtained it unethically. They never paid for a receipt to do it and put it through a databases that law enforcement has. Okay. And so therefore, is it against the law? No, but there is an interim policy that the FBI must abide by. And since they didn't abide by their interim DOJ policy, by obtaining it in that fashion, they wouldn't have been able to obtain it the other way. That's why they used the loophole. And so therefore, they would have never got to Bryan Kohberger. The FBI must supply a receipt that they purchased the kit to be uploaded as a law enforcement kit. Okay. And there's a process to that. It's not like how me and you can go and just upload our stuff to whatever. And so the FBI, I believe, can't produce this receipt because actually in a motion, Bill Thompson put it out there that, and Ashley Jennings and Bill Nye, the science guy, they wrote a motion and they wanted a protective order, and they said how they got it. They said they did it no differently than how we do it, how the public does it. And right when they gave those words that they did it no differently than the public, that's what I knew right then and there, that they didn't use the DOJ policy, which is that you have to notify these these third parties, these consumer products, like, hey, I'm going to use whatever one you're using. You're uploading it as they upload it as like if they were just, oh, here, it's mine. It's mine. That's not what you can do. If you're law enforcement, you have to go a different route and you have to fill out stuff and say that you're uploading this, and you deal with the company, and it's like a 3-week process. Like that shit doesn't happen like, okay, you can just upload it and do it right then and there. There's a process, and then there's a receipt because you pay for it. You pay like $500 or $700. Like there's a bunch of paper trail with it, and as there should be, you know. And then the judge can decide. Well, then their arguments are going to be like, we would have got to Bryan Kohberger anyways. And it's like, okay, how would you have gotten to Bryan? And those are the arguments that I'm waiting to hear. Okay. I don't want to kill her to go free. Who would ever want to kill her to go free? What are you doing? You know what I mean? No, you don't. And what I'm confused about is, why didn't the FBI do it the right way first and attempt to do it? Or did that actually happen? And then they couldn't build a family tree without doing it the right way. And they're like, hey, send it over to the FBI. Those people know how to use that loophole. And so then they sent it, okay, and did the loophole that was testified back to in August of 2023. And then that's how they produced that. Or do they not use IgG at all? So when they want to say how IgG was used, I mean, we're going to hear, though, right here, like we get to hear these legal arguments, and there's going to be a lot of overlap. So now this is where I thought was interesting. Now, although the hearing set for January 23rd, 2025 is not intended as a Franks hearing, it's not. That's why people that are putting it on their thumbnails says this is a Franks hearing. This is not a Franks hearing. Okay. First of all, you have to, you motion to the courts, and then you have a hearing to see and decide if you then can have a Franks hearing. Okay. So although the hearing set for January 23rd is not intended as a Franks hearing, in the interests of time and efficiency, I thought this was very interesting. In the interest of time and efficiency, the court will permit the parties to present their evidence on the IgG issue as if it were a Franks hearing. But then why isn't this public? By permitting such evidence, the court is not concluding or implying, that the defendant has satisfied the preliminary showing required by Franks on the IgG issue to even have a Franks hearing. A Franks hearing, guys, is when you are alleging that that law enforcement lied in their probable cause affidavit. Okay? They lied. They knowingly gave false statements, because it's under oath, in order to then obtain search warrants. They are purposely misleading the tribunal. And I covered it yesterday. You're going to have to show that there was that and factor, meaning, and I think the best way, I talked about it yesterday on how to attack that, because they most certainly lied. And the biggest part that they lied about is that just like you, me, the judge himself, Judge, wrote it in an order. And just like Magistrate Marshall thought, and it's just like how Judge thought, the Moscow Police Department portrayed to the magistrate and to the world when they put out that probable cause affidavit that they had gotten to Bryan Kohberger on November 29th via WSU running a query, finding his vehicle, and then it was like, we got that then as a tip. Like then WSU gave us, and then so we've been on Bryan Kohberger since November 29th. And then started doing all of these things. Then we type in the name Bryan Kohberger. We see, oh wait, he's a student here at WSU, and we did. Then we saw, we pulled him over, so we pulled that body cam. Oh wait, look at we asked him for his cell phone number, or he provided his cell phone number. So then we had his cell phone number, and then so we used that to put it up in the compared to the towers that we pulled to see if his phone was in the area pinging between 3 and 5, which it was not. So right there, you would have gotten like, oh man, okay. So, and you cannot do that. And that's just one example. Now, another big example is, I think that's like just huge. But then the other big example is the whole now Dylan statements, Bethany statements. The Dylan statements, okay, what you cannot do is if you are going to write hearsay statements in your probable cause affidavit, from my understanding, again, I'm not a police officer and I'm not a lawyer, but I'm not a dumbass, is you want to use Dylan's statements because this is what she saw. Okay, how reliable are those statements? If Dylan told you that she was intoxicated and hammered and throwing up and she was at all these parties, she was day drinking all day, like she was a mess, then you, as an officer, would be informing in the probable cause to say, because you want to also provide that, well, like you're not putting something in an affidavit that you know yourself is not reliable. But you're going to just say, okay, here, we can put this in there. So it's not that Dylan, so people that are thinking that Dylan lied, you guys, I have the Dr. Moore, Dr. Drake case that Frank's, and I can prove now with the cameras that Idaho State Police knew and should have put it in the affidavit that their eyewitness that said that they saw a white truck. Well, the white truck came after the eyewitness said that she left in her Pilot. Like you would know that as law enforcement because you're making an Excel spreadsheet. And so you're writing down, okay, the Honda Pilot leaves at, let's say, 7:16 p.m. But you're looking at the camera and you're like, well, there's no white truck there yet. Then you see, oh, white truck arrives at 7:18 p.m. And then you would think to yourself, wait a second. How did the person that said that they left in the Pilot and was gone from the scene, how would they ever know that a white truck came and did exactly what they just told us? Like that it did, because now I'm watching the footage. I'm like, well, yeah, the truck pulls up. It parks weird. It just sits there for a minute. Then it kind of does like a weird little turn. Hello? That person didn't then leave in the vehicle they said they left in, right? Because how would they know about the movements of the white truck? But we don't need to play the guessing game. All you need to do as a honest police officer is you would go back and ask that person, hey, when you said you left that night, you said that you saw a white truck and that's what blocked you and you couldn't get through, right? Yeah. What car did you leave in? My Pilot, the same car that I came there in. Okay. Well, so, and how many trucks were back there? 1, 2, no, just the one. Okay. Well, I'm going to show you a video. Maybe you could even be so kind to say, and this is your Pilot leaving, right? Like can you identify, like that's yours? Okay, great. Okay. Well, do you notice here in the video, there's no white truck there? But then a minute and a half after you leave, a white truck does come and it does exactly what you say it does. Are you sure that you left in that Pilot? I would like a lawyer. That's what's going to happen. So the point is that in that case, Idaho State Police, the same investigators that did this case, they knew that the eyewitness was lying, but they used it and took her statements and just put them in. Yep, that she saw the white truck, knowing that, okay, if she says that she saw that white truck, then she didn't leave in the pilot. Two can't be right? And that's the type of shit I want to fucking see in this hearing, because I know how they play in Idaho, and Taylor knows how they play in Idaho, and they are sick as fuck. Just like what Nick McClelland did with that white van in the Delphi case. It is disgusting. That's what a Franks hearing is for. A Franks hearing is to show the judge that these bastards lied. And so how is this being a shield from us? I want to see the state and the police, who we're supposed to believe, defend themselves against these allegations. I want to see them defend themselves, because then I can say to myself, holy shit, they didn't do anything that Ann's saying. What the fuck is Ann doing? But I can't even say those things, right? Because we're not able to see it. But I'm hoping and praying that the overlappage here is enough for us to get some of that out. But that's what's being hidden right now. The IGG is part of the Franks. Not all of the Franks. Nowhere near all of the Franks. But the IGG is the route to then talk about, then you had to start making up things. Like, when did Dylan give her statements? They were interviewed 3-4 times. Okay. Remember, they were sleeping on the first floor. Nobody was a witness. They were sleeping on the first floor. They didn't wake up until the next morning, later on in the morning, right? Then that all of a sudden changes to what? No, Donald, we won't see any of that. That doesn't come out in trial. This is when you argue it. There is no place to argue this type of stuff at trial. This doesn't come all out at trial. That's when you hear the words objection, sustained. Because they know they can't bring certain things up, because it's already going to be handled before then. This is the time. Mark B. 10 people who turned green think Mark B. So Ann Taylor this is not new for Ann Taylor. Ann Taylor has dealt with the shenanigans of Idaho State Police, local law enforcement in the area. And Elisa has dealt with the federal end of it. She's a federal attorney. So we should be able to see all this, but there's going to be a lot of overlapping. But I was shocked when I read this. I was shocked because they're doing it for judicial economy. And to me, that just blows my mind, because I would think that this would be just a huge problem down the road. Rushing something along. And so although the hearing is set for January 23rd, it's not intended as a Franks hearing, but in the interest of time and efficiency, the court will permit the parties to present their evidence on the IGG issue as if it were a Franks hearing. By permitting each or such evidence, the court is not concluding or implying that defendant has satisfied the preliminary showing required by Franks on the IGG issue, nor is the court bound to consider the full extent of evidence if it if it ultimately concludes defendant's proffer insufficient to warrant a Franks hearing on the matter. And I'm just like, so this is simply intended as a time and resource saving measure. And then here's my only question is why? Why not conduct business per usual? Like, very bizarre. So the only parts that we're not going to be able to see is the evidence portion of what they're presenting, but we 100% are going to see the arguments. And we are 100% going to see the evidence portion of all the suppression parts. Okay. And so just to point out some of the things that I have been harping on this channel. So I went through and I just said, here are the things that I think we should be expecting to find out at this suppression hearing, which is, during the proceeding, this is from the probable cause affidavit. This is what's highly scrutinized in this case. So, during the proceeding of the crime scene, the processing of the crime scene, investigators found a latent shoe print. Well, I want to know, what was the date of this that you're saying that the second processing of the crime scene by Idaho State Police Forensic Team was? Because we know that was a crime scene for like 30 damn days. Okay. There was people coming and going. So what are you considering the second processing of the crime scene, right? Next up. As part of the investigation, an extensive search commonly referred to in law enforcement as video cameras. This is when you go around the area and you knock on people's doors and you ask them if they have, ring camera, surveillance, whatever you want to ask them. And I want to know the dates of your so-called video canvassing. And again, this is just in the area of the King Road residence. This is not in the area of WSU. And that's going to be important because it's going to go in this hearing to talk about, how did you get the WSU footage? Who knew to go and preserve that and when to preserve it? So then, and that's when I make this little notation here, not WSU. So it's only in the area of the King Road residence and surrounding neighborhoods. And if you think that you're going to include the surrounding neighborhoods to be WSU, that's not going to fly. So who gave Moscow Police Department the WSU footage that they used in this case? Because it was well after 30 days and that stuff usually is gone. Right here. This video canvas resulted in the collection of numerous surveillance videos. Okay. We're going to get down to the nitty gritty of which ones those were. Okay. Dates, which ones. Then right here, again, who, when, what, and who, when, what. He said that he watched some, he says this video canvas resulted in the collection of numerous surveillance videos. Remember, he took the stand. He didn't even know what the hell was going on. And then he says, I have reviewed numerous videos that were collected. Which ones did you review? Again, he's just like, Payne's just like, oh, you're asking me a question? I have reviewed numerous videos that were collected and have had conversations with the other MPD officers, Idaho State Police detectives, and FBI agents. You know what he was asked? Who were those people? He did not know the names of the FBI agents. Wow. But we're asking right now because those are the people that reviewed, similarly reviewing footage that was obtained. Who did the reviewing of the video surveillance? When did they do it? What are the dates? And what cameras? You guys know how many cameras were taken in this case? 79. A review of camera footage indicated that a white sedan, hereafter suspect vehicle 1, was observed traveling westbound in the 700 block. And this is where I hammer it. And so will Ann Taylor. Payne testified already that it was Vargas on the Moscow Police Department that obtained that video. Okay. My question is when? When is in the date? And then was it a tip? How did they just miraculously send it through and you were going through that? I mean, that's all gonna come out. And they determined that they were labeling suspect vehicle 1, you guys. That's the one that's in Moscow. Moscow is the suspect vehicle 1, okay? So now what you have to do is you are going to find out in this case that suspect vehicle 1 is a 2011 to 2013. Bryan Kohberger does not drive a 2011, 2013. And yes, it's a big difference because the model is completely changed. It's like looking at a Ford Explorer that was square, okay, that they started switching into the Eddie Bauer edition that became more round, okay? It's noticeable. And in those programs, it's very noticeable, the software that they use. So how are you changing, or how are you going to say that a sedan that's a 2014 or 2016 on WSU's campus is the same as suspect vehicle 1 that's on campus as a 2011, 2013? This goes towards the Franks hearing, which is about lying about the year of the Elantra, to then say that, oh wait, later the FBI agent said, oh, it could be a 2011, 2016. That's not what that motherfucking dude is going to be testifying to. Or is he? But if he doesn't testify that way, again, a Franks hearing is all about knowing statements in here that are just completely not true. 30 minutes and we are 41 of 50. Woo! We got 30 minutes left. All right. We're almost at that goal. Woo! I am so thankful that I found this channel from almost day one. Answers finally. I remember all of Lana's lives and all of the inconsistencies that she has been pointing out. We here know more about the case. I would definitely agree with that. And how I know that is I will debate anybody about the facts of this case. And when you talk about like a debate, no, it's like, let's go back to old school debate days in high school. Like, let's debate. But the total misconception about this case is not all agreeing that it was only one narrative and it was the police putting out this narrative that then we can all know and say that they were pushing out a false narrative, because once we got this, we're like, wait a second, Dylan's a witness? Dylan was on the second floor? Well, I told you guys Dylan was on the second floor before this fucking thing ever came out. That's where her bedroom was. And if she went to sleep in her bedroom, like, or it looks really suspicious that she didn't sleep in her bedroom on the night that 4 fucking kids would be slain. Like, thank you. I'll take that. That's impressive. So we're going to get, I think we're going to get a handful of stuff. I do. And I think that they made a mistake by not making this completely open, because I would want no way for this man to appeal. I wouldn't want to put the families in and out of that courtroom for years to come. And that's just what they're doing. The family is being put in and out of this courtroom for years to come.
With Kohberger's DNA is on it. It's a pretty big get for the prosecution. Wouldn't you agree, Terry?
So let's see. I started a series. It's called the Red Flag Project series. And it's all the red flags in this case, the different reporting in this case. And let's see. I want to show, where it is. New goal? Goal achieved?
That killer cut himself and has, mixed DNA in that blood. But you can't do that much activity and not shed a skin cell or a hair or a fiber off your sweater or your jacket or your hat. It's next to impossible. It's just how many other people have walked through that house through the ages.
Woo! Where the hell is Miss Potts? H-Bag, good to see your... I'm just like good to see your ass in here, but good to see your avatar in here. KK made the goal
with the mispronunciation of Haley's name and of Xana's name, and I was thinking, how could that happen? Well, I believe perhaps this judge is probably like an FBI agent. We don't watch media about our cases. I would guess this judge hasn't watched a lot of media. Has he read about it? Perhaps. So maybe he hasn't heard over and over these names. I am not trying to give an excuse. I'm trying to provide a possible explanation. I think on the cameras, the reason he did that.
Oh, thank you. I'll take that. It's very kind. You guys, I still laugh about Gray Hughes getting chased by Kane.
Studied ad nauseum in every profiling and college and everything else, because he'll be the first one we know of that used social media as opposed to what BTK did, writing into various media outsourced. I mean, to me, that's why I'm a little bit sidetracked with it, down my rabbit hole.
You guys remember this rabbit hole? Everybody want to know who Papa Rogers was?
The question is, do I think Bryan Kohberger used Papa Roger to communicate with social media about his crime? My needle is way to the right that yes, it's him. But
versus, think about this, versus it being actually law enforcement. Versus it being law enforcement. Or Steve Gonsalves, somebody that knows and had intimate details about the investigation. You think Bryan Kohberger just got online and got into a group? Don't you think that would have come out by now? You damn know it would have.
I'm still at a stopgap because of three things, really three main things. The others I've been able to dispel now. But one is the fact that on the profile, it says her. But
maybe the killer is a girl.
I'm not convinced that that wasn't done purposefully for multiple reasons. Number two, he has a very odd post that he sends to the it's an Indiana school board about budgeting. But
and weird that in Indiana is where he was pulled over twice.
I'm very close. I shouldn't spend time on this to popping a connection there. And we're close.
She's close to popping a fucking my blood pressure, okay? Popping a connection there. We're close to getting that connection. Well, here we are 2 years later. How's that connection? Non-existent. So I'm giving you guys little teasers for what my, the Red Flag Project series is just about the most ridiculous shit that's either been said in the case or stuff that why was this hushed up? It's just stuff about the case. It's just like, do you remember this? Do you remember all this stuff when people want to say, if it's not Bryan Kohberger, then who could it be? I think that's the most ridiculous argument. Absolutely ridiculous. When all of your arguments for 6 weeks before his arrest, you didn't even say his name. Ridiculous.
Breaking news and Popagate. But we'll see if for sure. And then the other one was a tweet regarding an individual in California regarding politics, specifically kind of sticking up for the military. That one doesn't strike me near as oddly. It's the budget one. But
do you understand that she's about to get sued by freaking Turtle Boy?
Anyway, the fact.
Oh shit. All right, that was my just wow. Like wow. Again, the Red Flag Project series, it's under videos. So I do a lot of lives, but this is a video, so it's all pre-recorded. Yeah, Right, now here's something else. I keep my vault, so I'm gonna release another old school one. And in honor of IGG today, I made this video. Let's see. Let's see what I did with this one.
Because you're very humble.
I am. I am truly just a average girl.
So let's go back. We're going to start, right from the beginning, how your story kind of started, like where you are today. So you were diagnosed with some medical issues, and you're trying to figure out why, where'd you get these? So tell us how it all started.
I was diagnosed in 2018 with medullary thyroid cancer, which is a genetic form of cancer. I'm hopeless, essentially. And so I started an online group for people who had also gotten unexpected results, mainly as a support group. And I found there was a great need for people to, looking for help with their own DNA problems, and those that were adopted, donor conceived, or they got the same results that I got. And so I turned my depression into a purpose, and I started helping adoptees and those with unknown parentage.
That's incredible. And what a shock. What a shock. You just had a baby. You've got 3 other kids. You're diagnosed with cancer. And what a shock. The last thing you expect. And it kind of defines your life now. It's you've taken that and you've kind of gone with, what is it? You've gone with the skid. You turned in with the skid, Well,
I've had no choice. And unfortunately, it seems to be that in 2018 in particular, people, being in, we call an NPE, you had a non-paternal event or non-parental event.
So that's like from my vault. That's probably never been seen before. Let's see what else I got here. Videos I've made over time. Let's see. I don't know what this is. I have to go back through these. I'm like, God, I haven't seen these in so long. Some of the stuff I made.
You set a deadline for all the information to be provided to the court by December 1st. That should be sufficient time.
So it's a multi-step process. So
a knife sheath, a lab, and then a very early decision.
A criminal complaint was filed yesterday here in Latah County, charging the defendant, Mr. Kohberger, with 4 counts of first-degree murder, in addition to felony burglary, which involves entering the residence with the intent to commit the crime of murder. Mr. Kohberger, and let me preface, there's a pending case now in court, and I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you, through the court process or otherwise, whatever we are allowed to. I just appreciate your patience on that.
Well, that's a damn lie. You cocksucker. You have blocked us. You objected to this fucking hearing. I want everybody to see it. Santa lying to us on Christmas. Damn you, Santa, ruining my Christmas. Again, highlighting the lies. We will make sure everything is public. Everything is public. Go get this clip, mainstream media. I don't know who's a bigger cock block, Santa or Chris Hansen. If you know, you know.
Factual basis for the charges are summarized in what's called a probable cause affidavit that is on file with the court.
Nowhere in the probable cause affidavit did it mention Bill Thompson's decision to move forward with IGG off the rip as a lead tool in this investigation, says Truth and Transparency. And nowhere in the probable cause affidavit did it mention how quickly they obtained the name Bryan Kohberger from their quote-unquote IGG efforts, this so-called lead. God, no wonder why people think I'm working for the defense. This lead from IGG work led law enforcement to focus their investigation on Bryan Kohberger almost exclusively. The DOJ, how important is it? I mean, it is the Department of Justice, right? DOJ, right? Are you aware of how much documentation is needed when law enforcement uses IGG for a criminal investigation? Spoiler. According to the DOJ interim policy, the decision to use IGG comes from the prosecutor and investigating agency. Both have to agree that it is the best course of action at that respective time. That's why I'm saying that they are witnesses. Oh, and another spoiler. The prosecutor is to be contacted almost every step of the way during the course of using IGG for criminal investigation. Now, did you know before people used DNA as part of this old-fashioned process of building family trees and having a genealogist to tell them who they were related to, people would just go to town on digging up documents and doing it themselves, especially the first layers. So bomb number one, what if I told you Bryan Kohberger's grandmother cheated on his grandpa? Would that just not blow up the case? Oh shit, say what? Well now, isn't that going to really fuck up your family tree, or rather your attempt at building it and securing first cousin type matches or cousin? How do we know that, Bryan Kohberger, that he doesn't have some siblings out there? And that's what Bicka Barlow was talking about in her, this exclusive, just like, zzz, ridiculous. Anyway, Santa, you told us.
Have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise whatever we are allowed to. I just appreciate your patience on that. The factual basis.
One more time. What'd you say, Santa? That you're going to... Why did you object to this hearing then?
To felony burglary, which involves entering the residence with the intent to commit the crime of murder. Mr. Kohberger, and let me preface, there's a pending case now in court, and I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise whatever we are allowed to. I just appreciate your patience on that.
God, I love it. The lies. So I'm going to believe in someone's evidence. Thank you guys so much. We've gotten 73 super chats or super stickers. Like, holy shit. Oh my God. And I got cash apps. Thank you guys so much. Freckle Gemini, member for 17 months. Woo! That means you know all about this case over here. Mama J, thank you so much. Mama J also says, how about FF saying BK is Papa and that she deleted her Facebook account because she had a cussing match with him on it? Wait, I don't even know. I don't even know that answer. Thank you. Just Bill Thompson. We'll remove him. We're going to remove that. And let's bring in one more video here. Another classic. which is, I know people were asking for it. So here you go.
Parents, grandparents, and teachers have reported Hooked on Phonics success stories. With intensive, systematic phonics, these children learned important skills used in reading. Surprisingly, many schools do not effectively teach intensive, systematic phonics. So if your child's struggling or starting out in reading...
Live now from Fox, I do want to get to some breaking news that we are following at this hour here. Bryan Kohberger, the criminology PhD student accused of the home invasion murders of 4 University of Idaho undergrads, has now been indicted by a grand jury. That is according to officials there in the county where all of this did play out. The superseding indictment means the accused quadruple murderer will not have a chance to attack the evidence used to arrest him at a preliminary hearing that had been scheduled for the week of June 26th. We have talked a lot about that over the last several months here. A new arraignment has now been set for this coming Monday, May 22nd at 9 a.m. local time.
Remember, they wanted everything to be public. We're all going to hear about this. They take us away from the preliminary public hearing, and now they take us away from this. The only people that have been keeping everything freaking quiet is the damn state. And people out there that are pushing the narrative that it's the defense, sickening. Sickening. The truth is right here. Maybe you guys need Hooked on Phonics to help you asses out. This is one of my favorite videos I've ever made. You guys asked for it the other day.
That should be noon Eastern time. It also spares the 2 surviving housemates and other potential witnesses from having to testify under cross-examination prior to that trial.
Spares them. Then you're hiding behind that. They're going to have to testify eventually. Sparing them. They're going to testify, though. What are we sparing anybody? 4 people were murdered. There's no sparing anybody. Then months later,
I wasn't getting good marks in reading.
It was painful for me as a parent to see Jessica struggling with reading.
Phonics game was a fun way to learn how to read.
At first I thought it was too good to be true, but there's a money-back guarantee.
Here's the phonics game promise. 1 full letter grade improvement on your child's next report card, or your money back.
Using the phonics game, I saw an improvement in 2 weeks. Her teacher came up to me at school and told me that she had seen a great improvement.
This was me saying maybe people needed to go back and get hooked on phonics because
on phonics. Your kid will read a 30-day guarantee, got him hooked.
Bryan Kohberger's cousin.
5 million-second books, cause we got them all hooked on phonics. From ABCs competing in spelling bees, got them hooked on phonics. 30 years in the game, got them learning from the hook. 20 minutes every day. Single lessons you can do at any pace. They can choose from a game or a book, make it easy to learn, celebrate when it works. Yay! In 30 days you're going to hear a lot of questions. What's a resurrection, Dad? What's a recession? Oh my Lord, my kid just put me under pressure, but I'm happy that my kid...
Fox, I do want to get to some breaking news that we are following.
Bryan Kohberger's family members who used...
You guys may know him as Albert Kohberger. Yes, the Hooked on Phonics rapper is the lost cousin of Bryan Kohberger, who went and performed third-party ancestry DNA tests to try to find his lost mommy. Unfortunately, Albert Kohberger repeatedly filled out the boxes wrong and the questionnaires wrong, and therefore was matched numerous times with the wrong family and family members. Well, it is breaking news here today that Albert Kohberger, the Hooked on Phonics rapper, is the long-lost cousin of Bryan Kohberger due to once again filling out the wrong boxes. We expect Albert Kohberger to take a DNA test and to have that DNA tested against any unnamed, unknown male DNA from 1122 King Road.
Me too.
That's breaking news this morning. And please get with your next Hooked on Phonics specialist to help you and your family not only be able to read, but to be able to check the right boxes so that you can find your lost family.
That's how I felt like the breaking news was going at the time with everything in the Bryan Kohberger case. It was just misinformation after misinformation after misinformation. And it was like, you know, here we go. That guy's real name is Albert Kohberger. Okay. And so why don't we just say that that's Brian's cousin and that he is ancestry? You know, it was just so ridiculous. And so I made this video to say, this is how I feel when I see News Nation breaking news. This is what I felt like. And so watching that is what y'all that consume that. This is what you are watching. And so I just, put that out there. Did you like that people are seeing that for the first time? Tell me that video is not hilarious. Yeah. Big Al Kohberger. It's fucking stupid. Let's see what else taking us down memory lane. We're waiting so patiently here to just let us through the doors. I feel like we're all in line. Like it was like at Delphi. We're just in line waiting for the doors to open for us to go in. So that's kind of like what I feel like we're doing right here is we're just once the doors fly open, we're just going to be charging through like we're going to get the first seat in there, Yeah. So let's see what else I got in the vault here. We are chat line sitting. Yes, we are. Okay. It's great. Let's see. I think it's worth talking about the Brent Kopaka situation. So
literally just moments ago who gave us a slight
here's one of the videos I did.
So now we did learn that around 8:37 last night, police received a phone call from actually this apartment complex right behind us. And they didn't tell us who called, but we do know that a man in his 30s was threatening to harm his roommates. So at that time, police did respond. They were able to get those two roommates out safely. We're told that they're doing fine at this time, but we're also told that a member of the SWAT unit did shoot and kill that 30-year-old suspect who was threatening to harm his roommates. Now, again, police have told us that this is the early stages of the investigation, so they are continuing to work. And again, this is a very active scene behind me right now. While we just got here at this area, we saw another couple of police cars who pulled up from Pullman Police, but we're also told that Washington State Police are actually on their way as well. They're the ones who actually have to clear this scene. As you can see, there's still a lot of crime tape, and this section of the street right near Stadium Way is still closed off. Traffic is being slightly rerouted, but it's not a major impact to traffic in the area just yet. There's just a few lanes that are closed and people are taking the slight detour in the area as well. So now we're going to continue gathering more information for you all and try and speak to some students here who are impacted because of course this is late in the semester. I'm sure a lot of people have finals and those late classes to get to, or early classes rather, to get to this morning. So we're going to continue gathering the latest information.
So on December 14th, 2022, at about 8:37 p.m., our officers were dispatched to the 1000 block of Latah Street for a weapon offense. Officers learned a male in his 30s was threatening to kill his roommates. The roommates were evacuated from the apartment, and police officers attempted to speak with that male, who barricaded himself inside of his apartment. Pullman PD crisis negotiators and the Whitman County Regional SWAT team responded. The suspect began firing from his apartment. The area was evacuated. After unsuccessful negotiations, his escalating behavior, and a continued danger to the public and others, the male was shot by a member of the Whitman County Regional SWAT team. The suspect was found deceased when the Whitman County Regional SWAT team cleared the apartment. On behalf of the Whitman County Regional SWAT team, Pullman PD has requested assistance of the Washington State Patrol to investigate the officer-involved shooting. Further information will be released by the Washington State Patrol.
Hippler, open the door.
Per RCW 43102,
let's
this
do it.
investigation must be completely independent of the agency.
Hippler, open the door. So let's share screen. I don't see it. This portion of the hearing is closed. Not yet. I just want him to. Oh, God. What are you doing? It's okay.
Officer was involved in the
Lan
use
is
of
on it.
deadly force. The Whitman County Regional SWAT Team is made up of officers from the Whitman County Sheriff's Office, Pullman.
You guys know that the police set up a command room across from apartment 311 and kept the resident in the room during the shootout. Like, that is protocol. The fuck out of here. Like, protocol. That's why I just want to laugh when people say, like, Landon, you just don't know protocol. I'm like, okay. Okay. Let me just put it to you this way. Let's say that I don't know protocol. I will tell you this, that everything that's happened in the Idaho4 case, in Brent's case, in Richard Allen's case, it's not protocol. I don't know what is, but I can promise you that whatever the fuck y'all are doing is not. Okay? Because if it is, then shit needs to change. But you want to know why we don't know about protocols, guys? Because they hide their little handbooks from everybody. Yeah. Well, tell us what protocol is. Oh, wait, that's right. We can't go and get your little handbooks.
Police Department and the WSU Police Department. Thank you.
I promise you
I don't really have anything more I can give you at this time.
that I'd make it through the 6 weeks to 6 months to 3 months
Okay.
through law enforcement little camp.
Block number for the apartment?
In the 1000 block of Latah.
1000 block of Latah. Okay, and you said it was a man in his 30s threatening to kill his roommate?
Yes.
Okay.
Did his roommates get out?
Yes.
Do you know when that call came in?
8:37.
Has that officer been put on administrative leave?
Right now, we're in the very beginning stages of this investigation, and Washington State Patrol will be conducting that investigation.
Do we know the status of the roommates yet? Or how many there were?
There were 2 roommates that were evacuated, and they're fine.
Was that before or after the firing started?
Before.
These are all reports. That's how many officers they had. And if you look at Daniel Tanego, look at he's the shooter, Brent Boyd. Brent Boyd is on the SA unit with Curtis Whitman, who is the one that was out playing around with Brian's car on November 29th at midnight. John Daniels.
Who explained to us, gave us a little bit more of a timeline of events as far as what happened here. So they told us around 8:37 last night, they received a phone call from some people who lived in an apartment complex not too far from where we are. Right now we're at Stadium in Maine here, just right across from WSU's
Listen to
campus.
this.
And they
Right
told
here.
us that at that time they received a phone call from residents at that apartment saying that that one of the people in that apartment was threatening to harm and kill some of their other roommates. Now, there were 2 other roommates that were in the apartment at that time. Police were able to get them out safely. We're told that they're doing fine. But that 30-year-old suspect who made those threats, the male in his 30s, we are told that officers did shoot and kill him. Now, we were able again to speak to the chief of police in Pullman, and here's a little bit about what he had to say about the situation.
His escalating behavior and a continued danger to the public and others, the male was shot by a member of the Whitman County Regional SWAT Team. The suspect was found deceased when the Whitman County Regional SWAT Team cleared the apartment.
Breaking news from the WSU campus this morning. A SWAT team operation near the south side of the Pullman campus had students sheltering in place for hours overnight and into this morning.
But that standoff ended with one man being shot and killed. Desi Richards live in Pullman with the latest.
Yes, an officer with the Whitman County Regional SWAT team shot and killed a man in his 30s who was threatening to kill his two roommates at an apartment here on the 1000 block of Southeast Latah Street. Right now, we're seeing more activity down at the scene. Officers, investigators on scene. We have WSP who's investigating this incident right now, and this area is going to be blocked off for some time. We know that man was threatening to kill his two roommates. The roommates were able to get out safely before he started firing shots from his apartment.
At approximately 8:45 p.m., Officer Lamley was currently speaking with two males in the parking lot outside the apartment complex, who later were determined to be the roommates of the individual that was the focus of the Pullman Police Department's investigation. Officer Lamley tells the roommates the police are going to try and end the situation peacefully and ask the roommates if there was anyone else in the apartment other than the person who was making the threats. The answer to the question was not audible when we were listening to the audio on the log. But the fact that Officer Lamley quickly moves on to another question leads one to believe the answer was no. One of the individuals states that a person named Brent is in the apartment. Officer Lamley asked them to tell her everything they knew about Brent as quickly as they could. Again, this was at 8. Did you guys just hear that? This is the investigation within the investigation. This is what I went and got. The answer to this question is not audible, but the fact that Officer Lamley quickly moves on to another question leads one to believe that the answer was no. That means there was no threat. Were you threatened? No. Why did you shoot this man? This is the investigation that they performed on the investigation. 54 p.m. A male who identified himself as Jordan Baker, tells Officer Lamley he believed Brent Kopaka, the suspect, has some type of mental illness and that he sometimes drinks. Jordan described Kopaka as a 35-year-old white male with a small stature. Officer Lamley ends her conversation with the males and leaves to obtain a ballistic shield. At 9:22 p.m., the final video clip labeled Officer Janovich meets up with Officer Lamley and Christian Yannon, roommate to Brent Kopaka. Officer Lamley speaks with Christian Yannon and asks him several questions about what he knew about Brent Kopaka. Yannon, that was boom 2. The two people that were inside the apartment were not the two roommates. Okay, so the boom 2 there is wait a second, I thought the two roommates made it out safely. No, the one roommate was never even in the room, in the apartment. Okay? Like, I'm pointing out all the booms to the press release that WSU released. The lies. All of these booms are highlighting the lies that were told in that press conference. Because then here, they investigated the investigation that led to this shooting. And this is the results of that. Tells Lamley he does not know much about Kopaka, but does state he knew Kopaka had served in the Army and that Kopaka had told him he suffered from PTSD. Yannon told Officer Lamley that today, Brent had one of his episodes where he goes off ranting and throwing stuff. Officer Lamley asked if Kopaka had said anything about shooting anybody. Yannon replied, he did honestly. He said he was going to shoot somebody. He said something about letting his brother go, and he asked me before if I had ever fought his brother, but I've never met anybody or anyone from his family. Officer Lamley asked Yannon what Kopaka meant when he said something about letting his brother go. Yannon said Kopaka made it sound like someone was holding his brother against his will. Officer Lamley asked Yannon if he believed he or his roommates, as in plural, were the target of Kopaka's statements when he stated that Kopaka was going to shoot people. Yannon said he did not believe he or his roommates, again in plural, was who Kopaka was referring to when he said he was going to shoot people. Plural. Boom. So what did that 911 call really say? who all really lived in 311, and how did Officer Harris not know this before ordering a kill shot? Of a freaking person that fought for our country, or God damn it, how do you do this to somebody? How do you just shoot a man that is ex-military? Somebody that's clearly struggling. And this happens as they are literally about to pull over Bryan Kohberger the next morning. And God forbid Brian's dad mentions this. Because I guess we got all these notifications about blah, 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 you know what I mean? God forbid, because it just happened. Literally. It's something, we just heard about that, because it just happened. Because it literally did just happen. You would say something, we've been driving, we just hear about that shooting over there. Oh, but he doesn't mention anything about the Idaho4. What? Why would he mention anything about the Idaho4? That's something that just literally happened. They're getting notifications on it. Brian's getting notified. Unreal. So who were the roommates of Christian Yenin? Because if it should say him or Jordan Baker, the apartment is 3 bedrooms. So if it's Jordan Baker, Christian Yenin, and Brett Kopaka, they all each have a bedroom. But if Brett Kopaka is the one that's threatening Yenin's roommates, that's plural. Who are Yenin's roommates plural? Because it would just be he was threatening. Nobody on my channel would ever think that I would.
Yenin's statements were very puzzling. The plurals of the roommates, who's really Yenin's roommates? It makes it seem like that he has multiple other roommates, where he should just have one other roommate. If, and in fact, Bryan Kohberger is his roommate. There's only 3 bedrooms, so his statements about the roommates and the pluralness around that does not add up with the fact of only having 3 bedrooms. But more importantly, the talks of the brother, that talks about that Brent's brother is being held hostage. So I went and I found in the report, Harkins was interviewed, and Harkins says the following, that Harkins said he met Brent before when he tried to rip the panel off of his Harkins car. Harkins said Brent would stand outside of apartment 311 for long periods, and when he asked him why he was standing outside, Brent would say his brother was in the shower or asleep and he was waiting for him to let him in. Does that sound like a guy that has a key to that apartment? Does that sound like a guy that actually is the resident of that apartment? I know multiple people that have gone on and gotten leases in their names for other people that cannot obtain leases. This would not be the first, nor will it be the last. I wanted to know more of what Mr. Harkin was saying, as he was the alleged resident of apartment 301. And I came across that Mr. Harkin, he was in his apartment. He said that he heard the sound was loud when this first happened. Harkin said that he heard the cops remove a dog. Harkin said he did not open the door enough to see. Harkin said it was fuzzy what happened the next 40 minutes, but he turned on his police scanner and listened to them call SWAT. Harkin said that he remembered an officer attempting to get Brent to open the door so they could get his side of the story. Harkin said that at first Brent, would respond by opening the door, but he got yelled at as to stop and to show what he had in his hands. Harkin said after that he answered to the officer just a few more times, but it was too soft to hear. Harkin said listening to this was irritating him because of the looping questions, so he went back to playing video games. Harkin said his girlfriend called the non-emergency phone and the cops walked them out to the back of the apartments. Harkin said that they sat in the back of the police car. There was a dog in the apartment? Whose dog did the police come and get? Number one. Number two, the looping of questions. All right, so Parkin had a girlfriend, and it was actually Crystal. She lived in 301. So I wanted to see what Crystal had to say.
On the phone, texting.
Crystal said sometime around 8:35 p.m. she had heard a loud noise. It sounded like a firework or a gunshot sound. This was very important for me because at 8:36 is when this alleged cell phone call went out reporting a fire.
You see that right there? This broad says that she heard a gunshot at 8:35. That's interesting because that's what would make somebody call the police. You know what I'm saying? Not like somebody like. So, but here she's like, I heard a gunshot, or at 8:35. And I went back. I was like, oh, interesting. That's right when this so-called call came out.
Offense, firearm offense, and it's supposedly being threatened to get killed.
And then I thought to myself, like, oh, this is why the other roommates like probably took off. Like, that was never told. You know what I mean? It's just lies, you guys. It's just fucking lies, man. It's sad. What happened to Brent? It's so sad. That didn't need to happen. And if you listen to the video of the shooting, I mean,
Blah, blah, blah. Well, here you have it. You have a gunshot being heard at 8:35 p.m. It was either that or a firework. Or what do we think it is? I'm going with gunshot. Next, Crystal said that she heard a loud noise again. Crystal said that she went out to her balcony and saw the police running away with a dog. Crystal said that she has seen the dog from apartment 311. Crystal said within 10 minutes she saw a police officer in the parking lot with a gun watching the balcony of apartment 311. So the police arrive after this, after the dog is taken away.
Thank you, James.
So who was running with the dog and that she thought was the cops?
And so I interview her, and it was the cops.
Why would you bring a dog? Is it the dog from?
So if the cops are running away with the dog, there was the shooting and the cop was already in that room. If you're following the story, because I'm trying to like decipher it all, and I did, and I'm like, holy fucking shit, dude. There was a cop in there when that gunshot went off of what the other girl was saying at 8:35. A cop was in there. Because in this broad sees like, the dog being running off, and a cop is the one that had that dog. So this little narrative that they spewed to the fucking world, anybody that would do their homework, it's not what happened. It's sad. So sad.
311, or was it a canine dog for drugs? What went horribly wrong on the night of December 14th into the 15th?
Canine dog for drugs. Something went horribly wrong, and then they had to change
Crystal said that she heard
narrative.
the police in the hallway
Something
asking
happened.
if the remaining.
These are the same people. These are the same people that in the middle of the night show up at Bryan Kohberger's car at 12:58 a.m. Just miraculously finding it. What detective works at 12:58 a.m.? That's a 9 to 5er. If you're not like actively, I mean, WSU wasn't. He wasn't working that case. It wasn't his case. And then if you do find, you'd be like jumping up and down. I can't wait I'm going to go over and tell Payne myself. Payne doesn't get this information from this guy until December 20th about his little November 29th secretive scoping of Bryan Kohberger's car out. It's because I believe that I just believe that the FBI didn't trust the Moscow Police Department. And and they were running a parallel investigation because everybody's on the table. We're not ruling anybody out. So if you thought police officers were sketchy, are you going to tell them what you know? No. The FBI is not going to tell you shit. So person's Brent was okay, and if he was armed, and if he would respond to them. Crystal said at first it seemed like Brent was cooperating as the police got him to respond, but she could not hear what Brent was saying. Crystal said after a while, it sounded like Brent opened the door as the officers were saying, now, when you open the door, you need to listen to what he tells you. Open the door, hands where we can see them, and what is at your waist, what do you have behind you? Crystal said that this did not last long, and more cops were coming to and from the stairs, while a few more with guns positioned in the parking lot. While all of these people are in this apartment complex, this is what's going on. How could this possibly be protocol? The safety of all of those residents. Why aren't you taking them out? If you are surrounding an area with guns, what in the world are you doing with leaving all of these people in their apartment complexes? The court is on a break, guys. Yes, it is. The court is on a break. Again, one more time.
Factual base.
One more time here. Bill Thompson wants us to all know that, remember.
Mr. Kohberger, and let me preface, there's a pending case now in court, and I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise, whatever we are allowed to. I just appreciate your patience on that.
Love it.
Factual base.
Santa be lying to us on Christmas. Oh, Santa. Santa said he would share whatever. We're going to just do it through the right chains. We're going to promise you we're going to share it all with you. They're the ones. They're the ones that objected to this being public. Not the defense. Not a man that's innocent until proven guilty. Santa. This is what should be playing on loop right now for all those fucking idiots on mainstream media. Little puppets, my purse is being and then I'm gonna be. This is it right here. Santa, you said you want everything's gonna be public. We're just gonna go the right channels,
Mr. Kohberger, and let me preface, there's a pending case now in court, and I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise, whatever we are allowed to. I just appreciate your patience on that. The fact
said that they had tried leaving a phone outside his door so that Brent could talk to the police with a phone since he could not be heard through the wall that well. Crystal said that they started trying to negotiate with Brent for the next hours, using a phone or anything he would talk to them, but Brent was uncooperative and she could not hear him say anything. Anything. Or give any... Because he wasn't alive. He wasn't alive. He was not alive anymore. They pretended that this man was alive. He wasn't. He wasn't alive anymore. Do you guys want me to continue on with this Brent stuff, or you want me to switch to another video? How do you feel in chat? I have a ton of videos, so I'm trying to just move it on to different aspects of this case. So curious. So sad. Do what you want, Lana. No one heard him say anything. Not one. Exactly.
indication by the police that he was responding. Crystal said by midnight, the police were discussing charging the door, getting students away from the dorm room windows, and who was close.
Not till midnight. Not till midnight were they saying. This is an 8:30 call. Not till midnight. Okay, here, let's just evacuate people. You guys, there was a shootout. A shootout with themselves. They were shooting out with themselves.
Too close to the scene. Crystal said at this time, she called the non-emergency line and dispatched and asked them if they could be helped out of the apartment, 301. Crystal said within a minute, they were escorted out of the apartment down the stairs, and that she had nowhere to go, so that they then sat in a patrol car outside of the apartments. Crystal said she could hear a second gunshot because the first one was at 8:35, and now the second one was coming just after midnight. Crystal said while 10 to 15 minutes, after 10 or 15 minutes, she heard 3 louder shots that came from the police. Crystal said it was quiet again from where she was for another 10 or 15 minutes until she heard a quieter shot. Crystal said
that
it
was
continued this way
shot.
for about an hour to 2 hours.
The quieter
slowly
shot
increasing
would be
in
from
frequency.
further away.
How often?
You give it like if something's quiet, so she heard the sniper shot. Okay, she heard. Yeah, the police were firing, not fucking anybody in that room.
Then she heard the quieter shot until when she heard one shot every 3 to 4 minutes.
What? See, they started their own little shootout.
This completely contradicts everybody else's accounts of when gunshots were actually beginning to start firing, which was not until 2:13 or 2:14 a.m. But according to Crystal, 3 gunshots coming from police. There is no report anywhere that any police fired any gunshots except for the sniper shooting twice. I wanted to look closer at the 8:35, 8:40, 9 o'clock time frame, and I came across a Kylie apartment 101. She had heard a loud bang crash around 8:30 or 9 p.m. from above apartment 101. Silence after was dismissed. Kaylee said that there was movement upstairs that could be heard, but often enough that happens anyway, so it was dismissed as well. Running back and forth through the halls above. No shots were heard until about midnight or 1:30 a.m., she said. In this time, there was more running upstairs and 3 loud bangs. Then she was taken by sleepy bitch disease. That was in quotes.
What the fuck?
Kaylee
Sleepy
said that
bitch disease.
the first shot was louder. The later 3 shots were incredibly loud, enough to get her from her sleep. It was 2 bangs, followed by a minute later a third. At this point, she thought it could be gunfire, but again dismissed it. Kaylee said she was awoken by knocks on the door at about 3:34
What's up, how are
a.m.
you?
Who could possibly give a time that is on the money of 3:34 a.m.? Again, Kaylee said that the final shot was heard about 4 a.m. Kaylee said that it was quieter than the other shots. Excuse me?
We got people outside the courthouse. No movement yet.
Again, staying with that time frame of that 8 to 8:30, 9 o'clock, I came across McCoy in apartment 102. McCoy said she had gotten home around 8 or 8:25 and heard some loud noises, shuffling sort of sounded like people arguing, so she assumed it was a couple fighting, arguing with each other. McCoy said this was above her. Then she went into her room and fell asleep and woke up around 2 a.m. and noticed cops outside of the building from her window. McCoy said that she heard a bunch of shots going off at random times from 2 a.m. until they were evacuated around 4 a.m. McCoy said certain shots were louder than others and that they were random times with sometimes longer times in between them. McCoy said that she heard quite a bit of shuffling above her throughout the time. McCoy said that she was texting with her friends while this was happening and text them updates while shots were going off. I was able to find each message she sent to her friends with timestamps, says this officer, and it says see attached statements. I would love to see those attached statements. and timestamps.
Yeah.
Next, I would come to.
All right. I'm sorry, but like everything about that just is, it's so hard to listen to because it's just so, fuck. You guys remember the Cowboys, right? The Cowboys and the Indians, right? So, I have a video here that talks about, you know, I don't know. It might be on this one. We'll see. We're waiting here patiently.
What he's learned. Jordan, what can you tell us?
Well, the highest priority at this point remains tracking down that white Hyundai Elantra that was seen near the crime scene. But amidst thousands of tips law enforcement has received, it's been like tracking down a needle in a nationwide haystack. It's been 6 weeks since the murders of 4 U of I students. Law enforcement with limited answers, though with plenty of leads to go off of.
Investigators continue to work through over 17,000 tips and leads that we've had thus far. The last number that we had were over 250 interviews have been conducted thus far, and that number continues to grow every day.
Despite the sea of potential leads, no substantial updates have been announced in weeks. I asked if there was anything that they could share that might indicate that they're progressing in this case.
It's hard for the people in the public to understand the inner workings and the things that are going on behind the scenes in an investigation like this. Like I said before, 17,000
it's still
tips
hard.
and leads is a massive amount of information to analyze, review, and then get out to the investigators to work on. We are making progress. The case is continuing to move forward, and we've got investigators working on this 24 hours a day.
Despite little information to go off of,
There are a lot of theories out there, and
250 interviews. Who are these interviews? Can't wait for it. My note-taking skills will be on point, don't worry.
Investigators continue to work through over 17,000 tips and leads that we've had thus far. The last number that we had were over 250 interviews have been conducted thus far, and that
This is
number
what he's saying on
continues to grow
December
every day.
28th.
despite the sea of potential leads, no substantial updates have been announced in weeks.
How many leads before the wet Elantra were called in? How about that?
In this case.
It's hard for the people in the public to understand the inner workings and the things that are going on behind the scenes in an investigation like this. Like I said before, 17,000 tips and leads is a massive amount of information to analyze, review, and then get out to the investigators to work on. We are making progress. The case is continuing.
Progress my ass. Behind the scenes, you guys. This interview was one day before they arrested Bryan Kohberger. That interview was one day before they arrested Bryan Kohberger. Just the lies just coming from their mouths. It's just wild. It's just wild. November 25th, 2022, Moscow Police Department supposedly asked law enforcement to help them find a white Elantra. November 29th, WSU campus police find Bryan Kohberger's white Elantra, but somehow decide not to tell anybody about it.
Hyundai.
Who's going to believe this? Who believes this, right? Remember I said, who believes this? Who believes this?
In this case.
It's hard for people in the public to understand the inner workings and the things that are going on behind the scenes in an investigation like this. Like I said before, 17,000 tips and leads is a massive amount of information to analyze, review, and then get out to the investigators to work on. We are making progress. The case is continuing.
December 7th, you guys, Moscow Police Department are asking for the public's help. Bolo, man, 2011-2013, White Honda Elantra, seen near the crime scene and believe the driver and or passengers have critical information for the investigation. Come forward. 2011-2013. Were the police looking for the passenger of the car to come forward? You know, because the police already had Bryan Kohberger's 2015 White Elantra, right? Right? December 14th, 2022.
A big break in the case. A grainy image of a speeding car that could be the white Hyundai Elantra police are looking for. A night manager at this gas station in Moscow, Idaho, discovered surveillance video that showed a white sedan driving by on the night the 4 University of Idaho students were murdered. The timestamp says 3:45 a.m., right in the time frame in which police say the killings took place. The video has been handed over to police. It shows the car traveling on this road outside the gas station. It's just 1.2 miles from the house where the students were murdered.
Wow. Remember? Oh, shit. This is a probable cause, 329, 402. That car is just circling.
Students were murdered. The timestamp says 3:45 a.m., right in the time frame in which police say the killings took place. The video has been handed over to police. It shows the car traveling on this road outside the gas station.
Wait, do you guys remember that police said they did surveillance? They did canvassing. They did neighborhood canvassing. So they did a neighborhood canvas, and they got all these 70 some cameras. Well, by God, you didn't go and get this camera. The night manager had to turn it in. Isn't this why the Gonsalveses were losing their tits? Yeah, it is. It's exactly why they were losing their asses. I would have been losing my ass too. Been like, what are you guys doing? We're going around to these businesses and they're telling us that they haven't even heard from you guys. Nobody's gone in there to go pick up the video. You know, like it's one thing. You just can't say, oh, can you guys come forward? Like, what do you mean? You have 120 agents. You're not driving around. You said that you're neighborhood canvassing to get video. How does this person have to turn it over to the police? Unless the police officer is going to come forward and say, yeah, we went there, we gave them a thumb drive. And the reason that they didn't turn it over to us because we didn't go ask for it. So therefore the media is twisting how this went down then? I'd be pretty pissed off at the media then.
It's just 1.2 miles from the house where the students were murdered.
Who's out at 3:45 a.m. speeding? And this is significant, Harris. Very significant.
Woo, Nancy, baby. Nancy, baby. Nothing but all the right stuff, right? Have you guys seen her latest this morning? Did you see what she dropped? I tell you all the time I about fell out of my chair. Well, I'm starting to hurt my back from falling out of my chair. She had none other than Chris McDonough on there to talk about the 2021 burglary incident. And she said, Chris, you know that either they're going to say it's Kohberger or the defense is going to use it in trial to say that that's the killer. That's the killer. That's the killer. I'm just like, oh, geez. What is she? Guys, wild shit. Give it up for Nancy, though. Go, Nancy, go.
Less than 50,000 people, less than 30,000 people. The driver has not come forward. Why?
Inside Edition spoke with news.
Nancy, the driver of a 2011, 2013, or, right? That's who you wanted to come forward, right? 2011 to 2013 driver. Make sure that we say that. Because then they want to say, oh, see, Bryan Kohberger didn't even come forward. And they were asking for him to come forward, and he just did not. Well, after the news flash here, guys. After the Delphi case, I can tell you this. Do not come forward for any reason to talk to police officers and inject yourself, because then you are putting yourself as a suspect on this in a case. I'm not helping you guys. Why would anybody come forward and say that, yeah, that's my car? They're not your friends. The police aren't here to help you and say, oh yeah, hey, thanks for coming forward. No, they're looking at you like, well, I'll tell you what we think about this car. We're already thinking that this car is involved. Really? Come on, man. It's 2025. With all the technology that we have, you don't need humans to help anybody, okay? You don't even need humans to take your order at Wendy's anymore, okay? Computers do it. I just went to Wendy's the other day. And then I'm a jackass because I love fucking with them, and I want to know if they know Spanish. So I spoke in some Spanish words just to see if they could understand it. Because what if there's like a non-American speaking? So I was just curious. Yep, that's what I do.
Nation's Bryan Enton
I
in
test her.
Idaho.
The exact direction we don't know. We know that it was on Highway 8, right in front of the gas station, and turned onto a side road. It appeared the car was headed out of town, and reportedly the assistant manager at the gas station said it was going quite fast.
The night manager says she was acting on a hunch and went through hours of surveillance video from that night. Turns out her hunch was right. Now questions are being raised about why a month after the murders, that gas station video and others from businesses along Route 8 had not been already examined by police. There are several.
Thank you, Jared on point. Big shout out to TNT. We have an Atlanta watch party waiting for the court doors to open. You know it. You know it. Nothing but the facts. Nothing but the motherfucking facts. You guys, the hearing has not started yet in terms of what we can see. All right. It is right now 10:55 a.m. in that courthouse. So this Elantra with the missing front plate that is traveling away from the house at a fast rate of speed would leave the probable causes of the suspect car. One was seen at 3:26 a.m., 700 block, 3:28 Snyder, 3:29 a.m., and then to 4:02 a.m., making those three passes. And then somehow has to be on, this Exxon Mobil footage here, if you're saying it's the same one, at 3:45. Okay. Because it comes back at 4:04 for its fourth and
the
final loop.
timestamp says 3:45 a.m., right in the time frame in which police say the killings took place. The video has been handed over to police. It shows the car traveling on this road outside the gas station. It's just 1.2 miles.
So now think about this. Going the wrong way at the wrong time. Is this one of the videos that
from the house where the
Jay's speaking about? I don't know. All I know is it's a video of a car with the wrong year at the wrong time, going the wrong way. That's what we know. And so how are you going to say that that car is then the car that's on the WSU campus? And this is part of the Franks, which is they knew that it wasn't a match and they lied in the probable cause affidavit. And that's the subject of the Franks, which is all the lies in that motherfucker. Everything that you knew that you put in it wasn't truthful. It was misleading. You were misleading the tribunal, who is the judge, who is the magistrate, who is signing these search warrants. Okay? They all know what the fuck they've done. They know what they've done. And they're all protecting. That's why I think it's crazy that judges are the referees when judges take money from lawyers campaigning. Think about how fucked up that is when you really think about it. I'm sorry, but judges shouldn't be allowed to take money from lawyers. and campaigning. I think it's wild. You know, it's like it's the refs that we have here for, you know, Patrick Mahomes right now is the center of, like, you breathe on the guy, they're throwing a flag. Okay. So we have a referee here in our courts that, hey, it's like they're supposed to be impartial. And I have yet to walk into a courtroom in the past 2 years where I feel that the judge is not an extension of the prosecution. And that to me is just fucking mind blowing. You know, you have a defendant here that's saying that they want this to be public. You have a fucking prosecutor who says that he wants it to be public too, but he has to abide by the rules. But guess what? When he's allowed to, everything that we can, we're going to put out there. We just have to go through the proper channels. Well, here was a proper channel, but you objected to it being public. When I say you, the prosecution objected. So when everybody's wondering why we can't see this shit, it's the prosecution.
Case now in court. And I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise whatever we are allowed to. I just appreciate
whatever we are allowed to. They were allowed to share this. They were allowed to have this open. These people right here, Santa Claus came and delivered coal to all of us Christmas morning. Christmas morning, Santa, Bill Thompson, backseat Bill here, he's like, hey, it's all going to come out. It just has to go through the court process. You're going to be able to see everything. Bryan Kohberger wanted this public. He did not. Ashley Jennings did not. The state did not. Why? Why don't you ask yourselves why? They were like, you, this is who people that you would vote for. The DA is somebody you vote for. This guy wouldn't get my vote. Like, if he paid me $1 million, if he paid me $1 million, I wouldn't vote for him. Chief Fry thought he could run for sheriff and win. You do realize that you have to get votes to win. Like, it's an elected position, right? He got his ass handed to him, and I fucking love it. What's Chief Fry doing now? Maybe working at fucking Home Depot. Who knows? Who was going to vote for somebody? Like, he should have won in a landslide because that town should have been so happy that they have Chief Fry. He solved the fucking Idaho4 murders. Nobody voted for him. He lost. Chief Fry, after getting this arrest in the highest profile case ever to come through that town, let alone I think it's the state, but people didn't vote for him. Well, why? Because he's a liar. People, Bill Thompson, I'm showing you, this is proof right here. This is what mainstream media won't show you. Here is Bill Thompson saying, hey, we made such a mouthy probable cause, we want you to spread far and wide, right? Woohoo! The sheriff is liked by everyone. Well, good. He would have got my vote.
Mr. Kohberger, and let me preface, there's a pending case now in court, and I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise whatever we are allowed to. I just appreciate your patience on that.
They were allowed to have it public. And then him and Ashley Jennings went crying to Hitler. To Hitler, no, we can't have this public. Oh, God, we have to protect our police officers who lied. The public has an interest in corruption, and Hitler went ahead and protected them. They said, well, don't worry, this is all going to come out. Well, Ann Taylor, rough them up, baby. Because we will one day see everything that's being hidden right now. It is going to be public one day. But that's only going to help us for our want to know, okay? But that does not help Bryan Kohberger. And I'd be so fucking pissed if I was in his shoes right now. And the only reason they don't want it public is because the state does not want it to sway public opinion right now, which is literally mainstream media repeatedly saying and giving this narrative by letting their guests come on to literally spread misinformation and bash the fuck out of the defense and this defendant. That's who mainstream media is having on, and they're saying that they're unbiased. Unbelievable. But I appreciate it because there's 1,300 people right here that are like, yeah, we're not buying it. And so cheers to you guys. 1,300 people in here are like, yeah. And so I guarantee you, Anne and Elisa and Jay, they're handing the state their ass right now. Literally hand fisting. Okay?
The factual base.
Here's the shit that you gave us. Now we're putting it on a fucking platter, all right, with a bow on top and some cherries, some sprinkles, and serving it right back.
This for the charges are
And Bill Thompson doesn't want to be called out and for us to all see it. Bill Thompson was going around literally parading and doing interviews at the end of November saying that he would send his kid to school because he knows more than we do. He's a witness to the IGG call because guess what happened on November 29th? That's when WSU did what, Bill? They were doing what? At 2:58 in the morning. But who made that call? The FBI, not you. And then Fry has to come out and say, "This is our case. We're in charge." Who's he telling that to? The Gonsalveses?
And what's called a probable cause affidavit that is on file with the court.
Unbelievable. Nowhere in the probable cause affidavit did it mention Bill Thompson's decision to move forward with IGG off the rip as a lead tool in this investigation. And that's who makes that call. He made that call. I want to hear who made the call to bring in the FBI for the portion of the IGG, because it was with the Idaho State lab, and then they were sending it to a lab that they, deal with, Ortham, and there's a $9,000 bill for it. And it's just, there's a proffer on the table, and this proffer is I don't think it's chicken noodle shit. I think it's chicken noodle soup. And let's see another one from the vault. Let's see. Anna, what else you got in that little bag of tricks? Oh, let's see. Oh, this might be a good one. Thank you so much, LaDonna. Jean!
Hello.
Hello, police and fire.
Yes, this is not emergency, correct?
Yes, it is.
Okay. I left a message for Officer Fry as well. I just wanted to let you guys know that there is a crazy YouTuber in Idaho right now. She's fixated on the Idaho4 case and vindicating Bryan Kohberger. And she just put up a live stream of 2 hours ago where she's walking around the house, knocking on witnesses and neighbors' doors, trying to talk to them. And
she's walking around the
house.
1122
Kings Drive, yes. She said she wants to get the camera so close to Ian's face she could see his zit. She has, I don't know if you're aware of her channel, it's Truth and Transparency. And like I said, she's a convicted stalker. But she stalks other YouTubers. She gets fixated on things and goes absolutely crazy. If this woman knocked on my door, I would be terrified. But she stalks the neighbors before, accused them of calling in noise complaints, put their address and everything on her channel for her 40,000 subscribers. She is if this woman knocked on my door, I would be terrified. Like, she's that mentally ill and deranged. But I left a message for Mr. Fry because that's all I need to do. I tried to
Mr. Fry
link to this woman's page in this video, but it wouldn't let me. So I wanted to call the non-emergency just so somebody would know that this person is in that area and walking around talking to witnesses and knocking on
witnesses
and the neighbors' doors. And she's not a journalist. She thinks she's a lawyer.
You guys.
She's not. Come on. She's a crazy person, and she's there now for, I guess I don't keep up with the case as much as I did when it first came out, but she is trying to vindicate Bryan Kohberger.
Do you know her actual name?
Yes, it is Alana, Lana, Oriani, Oriani.
Okay.
Do you know how old she is?
She is 42, I believe. Well, she might be a little younger than I am, so maybe 40 to 42 range, something like that.
And you said she's live streaming and walking around right now?
2 hours ago. It's up on her channel. If I click her channel, it's called Truth and Transparency. I didn't catch the live stream. But
So
she was sending me nudes.
She's not live streaming anymore now?
No, not right this minute.
Okay.
So you called after the fact.
But she will be. Trust me.
But she will
can't
be.
help herself. Like, she's going to show every address, every person
those
that
nudes.
every person that talks to her, every person she will.
What's the crime?
She is nuts. Completely nuts.
Shit can nuts.
And invasive.
Invasive.
No respect for personal space, personal anything. And just the thought of her knocking on people's doors around there makes me sick to my stomach.
Why?
Because she's got them, and these people have had to contact for their information to be taken down, and trying to reason with this woman because she's trying to, vindicate Bryan Kohberger for some fucking god-awful reason.
Vindicate Bryan Kohberger.
But she works.
She's so upset that I said I was going to put the camera so close to Enon's face that you could see his zit, or did she say his dick? I couldn't understand over that twang. Girl, come on now.
Cases on YouTube, and she does this with every case. She did it with Chris White. I don't know if you know about that big case in Colorado. Any case she gets fixated on, the person who did it, she tries to vindicate them.
Okay. Could I have your name for my report, ma'am?
I'm so scared to give you my name for her to have my actual real name.
Right, I understand. I could mark you non-disclosed. That way an officer could get your name and still get in contact with if they need it, but it won't show up on the public record.
Okay.
But if you're still scared, I can still just mark you
I'm really like that. I'm going to be completely honest with you. The thought of her knowing my real name or having any access to me is terrifying. She goes after people, their children, their jobs, their ex-husbands, their...
For sure, I understand. Could I have a callback number for you in case an officer wanted to get in touch with you?
Absolutely.
They tried to have me swatted when I was there. I'm driving around just...
I will enter this in.
Reporting.
Did you want an officer to...
Do you guys understand, Nancy Grace goes and does a pop-up table. Brian Etten goes there and reports live, okay? I'm going there to report live, and you're trying to have me swatted by cops? I mean, do people call, on, I don't know, name whoever who's been out there. Fucking Connie Chung.
Contact you?
He doesn't have to. It doesn't matter to me. I would be happy to share any information I know with him if he wants to contact me. That's fine, but whatever is convenient for them.
Okay, sure. All right, I have an officer. He's going to go double-check the area. He might give you a phone call afterwards, but we'll make sure they're aware of that.
Okay, thank you. I know she's staying in an Airbnb near bagel shop. She shows it on the
When
live
was
stream.
this?
I was. You have an email address. I could just forward it.
I wanted to show you guys when, right
Or
after it
you
was
could just
demolished.
go to our channel. It's the last live stream she did. She's in that area. She's got an Airbnb that you can see on there. I'm sure you're more familiar with that area.
She
than
wasn't
I am.
even in
I'm
Idaho.
a different
No.
state. But yes, if he needs to call me back, absolutely, that's fine.
Okay, gotcha.
So
Right. I'll add
anyways,
that to my
this is
report,
just-
and if
this
they
was
need to call
last
you,
year. Yeah,
we'll let them
it
know
was
they can.
Okay, thank
yeah,
you so much.
2024.
I know this sounds nuts, but
I'm out just vindicating.
that felt necessary.
I'm trying out here
Yep,
to try to
for sure.
vindicate
Thank you,
Bryan Kohberger, you know what I mean? You know, I'm out here trying to vindicate everybody and just, you know, ruin everybody's lives. And she is just crazy. I'm so obsessed with somebody that I just watch everything that they do on YouTube, but I hate them. She knows where he's like it. I'm over here documenting away and you know, I just, you know, I'm gonna give my kid candy all day, watch YouTube all day. Remember Joyce? Joyce, do you remember? Oh God, dang. She's the stalker. Careful, next thing you know, Al Kohberger come find me. Anyways, the reason I went over here is because in the video, or I'm sorry, part of the PCA. So part of the PCA, one of the tests I did was they talk about this dog bark. And I knew that there was a dog based on, I've done so many FOIA requests in this case, I can't even count. But I knew there was a dog that lived right up the stairs here, which is right next to the house, right on the right. And I wanted to prove that right when you walk past the door or walk up to it, that dog is going to bark. Okay. And so, one way to prove that the so-called dog that was barking wasn't Murphy, right? But it's this dog. And it was this, and that means the killer, if they're saying it's, had to come through here, right? And then this is either going to go into one of these apartments, or they're going to be on foot, which then you're going to be coming out Linda Lane over there. I mean, it's, but no way, shape, or form would this person be getting in a vehicle, which would have been right around the house before you get to these stairs, because there would be no dog barking. Okay. And so I just wanted to see if so that's what this video was about. I wanted to check out my experiment, and I was right. And there's this dog that right when you come up, it starts barking. And so here's the rest of it. P.S. This is the first day that you've been subscribed for 2 years. Thank you so much. Yeah, I gotta have a good sense of humor. I mean, the stuff that we cover is just awful. Thank you so much for being here. Right there. That's the apartment. See, right there, it's right next to the house. See, as you can see, it's right next to the house. And that's what I believe the dog was barking from there. And this person was on foot, and they walked right past us, because the dog wouldn't bark unless somebody walked right past there. And then I also wanted to show that, see these stairs right here? Would this be consistent if you have Apple Health data? That could somebody think that you were going up or down stairs if you're the roommates? Say that was the roommates that were walking around and their Apple Health data is going off or whatever, and it has them like going up a flight of stairs. Well, maybe the flight of stairs that they went up or down was actually this flight of stairs, not that flight of stairs. And so it's like such a close proximity that could that be an answer? Could that be, can that be ruled out based on the meters that they're going to be using? Okay. And for me, I'm all about like, either you can prove something or you can't. And that proof is on the state. And so they had all these devices that they said that they used in the probable cause. And are we going off of, if you're going off the Daybell case, they were doing something within 100 meters. So if in 100 meters, it was registering something. Well, 100 meters is, that would cover this area. No doubt about it. Did the area echo? Yep, you could hear, I mean, it echoed. I could yell or say something, and then Bella could hear me over here. I mean, so that's that episode. I just wanted to share you guys that people on YouTube tried to have me swatted. The hate's real. As far as what's going on in the case right now, we are waiting for Judge to open up the doors. Okay. Judge. Let's see. This portion of the hearing is closed. Well, let's look at this. Look at these numbers. 739 are watching it in long crime. Or, yeah, is it long crime? So I'm really impressed with that. I'm really impressed with the fact that, you know, we have here 1,375 people. So we're double, which is good because the mainstream narrative that's coming out of this case is just so unfortunate. All right. Who should we call? Who should we call? Looks like we got to call somebody. Let's call Bob Mata and see, is he still live with the case? And then we can talk to each other while we're both live. Is he still live? I'll see if he's live. And as far as the Karen Reed case, I know people were asking me about it. Now he's on break. Turtle Boy, breaking news with Karen Reed. A motion to dismiss for extraordinary governmental misconduct is forthcoming from Karen Reed's defense. Oh, he just went live again? Okay, perfect. I'll get him. They paid $13,229 to fly and lodge an expert who was going to review Canton Police DVR system to determine if the Sallyport video shown at trial was intentionally inverted. When they arrived at CPD, he found out that the evidence was destroyed. What? I mean, what the fuck? And they're going to say, guess what, though? Guess what they're going to say? Well, they didn't put in a motion to preserve evidence. You know what I mean? Well, I'm just telling you what already the comeback is. If Karen Reed's team did not put a motion to preserve evidence, then I want to know if they can hide behind that. And they were just like, oh, we weren't planning on using that in this trial, so we just, you know, they didn't put in a motion. Think about it. So they weren't going to use the inverted video this time? I mean, you just can't make this shit up. And here we're just all supposed to sit here and just be like, yeah, woo, they don't have to tell us anything. So let's see what I got. I'm going to text Bob and say, Bob, let's talk to each other on speakerphone on our channels while we wait. I just sent him a message. You know, I can fuck with Bob. Ugh. Boy, oh boy. Sad day. I would think it was a Brady violation. It's exculpatory evidence. You have to turn that over. And if you don't, it's material. They used it in the first trial. I mean, if I was Bev, I'd want out of this so damn bad that I would grant it. I would grant it, man. Like you think I want, like, I would say I don't want any more part of this. You know, I think the fuckerage in the Allen case, I think the fuckerage in the Karen Reed case, and now this suppression hearing was for people to, like, if you believe that Karen Reed was framed, there is more evidence in the Bryan Kohberger case that he was framed than there was in the Karen Reed case that she was framed. Because the difference is that Karen Reed put herself at the crime scene. Okay. Bryan Kohberger did not. And the only evidence that puts him at the crime scene is this placed and seen later sheath. Okay. And it's all secretive on how they got and what was on it. To then, like, even once you got his name, I believe that if Bryan Kohberger was the person, we would have seen a ton of fruits come back from, like, his car with, like, there being DNA in it, with his, you know, apartment, with his devices. You know what I'm saying? And just none of those fruits were coming back. And it was like a dead end every chance they got. And their explanation for that, it's not good enough for you to say he's just really smart and he's really good. That's not good enough. That's not good enough. Nobody can outsmart and be really good. Like Scott Roeder said, Atlanta, there's not even just going to be the evidence of the DNA, but then if you did a cleanup job, it's the evidence of the cleanup job. That's what would have been there. So everybody that's saying that he bleached this or he cleaned the shit out of this and did that, that's going to be there. And none of that's there. So I just think that if you can say, like, you know, Richard Allen totally framed and railroaded, okay? They had that video. They just knew it all with that case. Karen Reed, they knew what they did, right? And for whatever reason, people are just like, oh, but the Bryan Kohberger case, like, we're not even going to consider that. Well, that's a head scratcher for me. That's a head scratcher for me. But you want me to say that law enforcement worked with people that were actually outside of law enforcement. The McCabe's aren't law enforcement. Kerry Roberts, but we're sprinkling, we bashed the headlight in and then we sprinkled it and then yeah. So if you were on that you see that all happened, right? And trust me, I believe that it happened. Then I just have a problem with the logic and when you try to say, look, here, well, look at this. I don't get it. And then I think absolutely forensic theory. Then we hear these interviews with these jurors, and I'm just like, I might as well not even do an episode about it because it's just so hard. Lana, you're being so critical. Or Lana, wow, you didn't have to say all that. Well, what do you want me to say? What are you guys saying? I mean, this is crazy. I mean, it's one thing that it's right in front of our faces, but none of these jurors have the cajoons to all you have to do is say you're voting not guilty due to the fact that they didn't make their case, not because you believe that the person's innocent or guilty. I don't understand that. And maybe that needs to be said by these defense attorneys to say, hey, if you don't, just because you're saying not guilty, your vote, that's why I think the wording should change, because I think people aren't liking the fact that they have to say not guilty due to the whole, I'm finding that way because of the lack of, evidence, the reasonable doubt, So maybe we need to switch up the way that it's worded for these jurors when they're looking at these verdict forms. Because it's like, well, I don't believe that he's innocent. I don't know if he's innocent, And then you just answered your own question. Yeah, exactly. You don't know. I'm not going to say he's innocent, So if it's like, check the box and just write, yeah, reasonable doubt. Which in turn, then just let even come out in court to say, the jury has voted on reasonable doubt. Therefore, the defendant is found not guilty by the courts. Because I think that might be, a huge hang up for people. I don't know. But their explanations on why they're voting guilty is actually the explanation on why you would actually check the box for not guilty. And it's because there's all this reasonable doubt. I mean, they have to prove their case. There is no possibility. If it can be someone else, or like, they have to prove each element. Everything that they're saying, they're this theory to you. They have to prove it to you, this theory. They can't just say, this is what we think happened. And then you're like, yeah, that could have happened. I'm voting guilty. No. If somebody brings in, so for me, the headphones with the Richard Allen case, to me, it's just this simple. I don't know if Richard Allen, I wasn't there. None of us were there. So we don't know if Richard Allen's guilty or innocent, right? But I will tell you this, there's no DNA at the scene. None. So a stabbing, 2 people, right? No DNA at the scene of his. But the reasonable doubt that everybody should have held their, is the phone, the cord. Because when you want to say, it's because of water damage, who proved to you in that courtroom that phone jack going in at 5:55 and out at 10:50 was because of water damage? Nobody. You can't just say that to yourself back in the deliberating room. I mean, you don't, but at the very least, what you can say is, holy shit, wow, yeah, that means somebody handled this phone at 5:55 and then again at, 10, whatever, at night. Who went back to the scene? Who did any of this? That's reasonable doubt. That's reasonable doubt. That is what reasonable doubt is. A Google search to come back on the stand and say, oh, well, I Googled it, and for an expert to say I Googled it during our break, and it says that that could have been from water damage. That should have never even been allowed to be said. I can't even believe that the guy who said it would ever even admit that he did that. If you're an expert, so were you just Google searching your whole time for the past 7 years before we came to trial? A Google search, asking Google, hey Google, what's the temperature outside? So if I was a juror and I heard that an expert was Google searching, wait, what? Then I could be a fucking expert. You can be an expert. We all can be experts. But the bottom line is that there was this phone comes back on and all these calls come through and when the phone stops and then it's just like, wait a second, what is truly going on? It looks like the phone left the area. It looks like the phone could have been shut off and then turned back on. Now we got cords going in, cords going out. And guess what? Back in the day when you plugged in the phone to the hardwired earphones, it made the sound go. It would cut out the sound, so if you were calling a phone, it wouldn't ring anymore. It's going to ring through the ears. So people that were looking for the bodies wouldn't have been able to hear the phone ringing, okay? Wouldn't have been hearing vibrating or anything. That to me right there, that's holy shit. So how you could get around that is just pure, that's reasonable doubt. The headphones are reasonable doubt. The logging of the phone in that. And then the state being allowed to literally try to mess with the jurors and say, oh, that could have been just a malfunction because the phone got wet. But it's basically that case says that we're all experts because if we do a Google search, whatever comes off of Google that that's expert testimony. Just unbelievable. And I can speak a lot on that case because I was fucking in that courtroom. I heard it. I was there for that testimony. And that's when I came back out on my channel and I said, it's over. It's over, meaning he is going home. He is going home because Stacey Eldridge sealed the deal, what she just testified to. Sealed the deal. Sealed the deal. Like, you should have heard the courtroom when that testimony happened and boom, this comes out. It was like, and when a bunch of people are doing that, like, you hear it. And that's when I said, I was like, it's over. Like, you're not going to be like, that's reasonable doubt. That, holy shit, who grabbed the phone, plugged it in, then came back to and unplugged it. Okay. And you have 5 to 6 mixtures of people's DNA at that scene. You have unknown samples. They wouldn't even consider touch DNA in Indiana. They wouldn't even consider using IgG in Indiana. And so I'm just like, wow. And so I put it out there. I was like, it's over. And then when I saw, holy shit, Nick's going to use a rebuttal and call Cecil back to the stand. I was like, now you guys are all just lying. Now people are just literally lying on the stand. And it used to mean something when you lied on the stand. It used to be like, holy shit, you're gonna get hit with perjury charges and you're gonna go to jail. Okay. When's the last time you saw anybody get in trouble for perjury? How is Colin Albert? Literally, we have video evidence of him fighting. He committed perjury. He was a material witness and testified to material shit. His knuckles being bloody. He committed perjury on that stand. How is he not arrested? I mean, why aren't we? I mean, perjury needs to be it used to be a big deal. People were scared to lie on the stand. Now you have no consequences when you lie on the stand because nothing is happening to people when they do. The last time I saw somebody in a case that I covered get charged with perjury was in the Adam Montgomery case. And it was when the state used it to basically threaten Kayla Montgomery. And we're going to charge you with perjury. And so you're either going to give us all these proffers and tell us all this shit. And who knows, maybe testify how we're going to tell you to testify so that we can get this piece of shit. Okay. But Kayla Montgomery was charged with perjury, brought in because and it was with a proffer. And the only people that can decide if they're going to bring, it's not like me and you can just go down to the court or go down to the police and be like, I want so-and-so charged with perjury. Versus like if I was assaulted, I'm going to go down there, I'm going to file a complaint and this person did this to me and I want to press charges. Okay. Like, I think something should change about that. But the only person that can decide to bring perjury charges and file that complaint, is all government. Where I think that the person that was affected by the perjury, I think that they should be able to file a complaint to then warrant somebody looking into it to then bring forward perjury charges. How the fuck not? I mean, fuck A, man. It makes me sick. Someone call Hitler and say, yo, we outside. Yeah, exactly. Bring back actions. Have consequences, accountability. Yeah. Show your work. Can you imagine going to college and having no books and somebody saying and teaching us and saying that this is just it, but they don't have to, there's no books, there's no proof, there's no show your work, can you imagine learning like that? Right. So here I look at the same thing. This is it. The answer is 21. The answer is 21. What's the question? Here it is. Okay. Unbelievable. No one's going to stop using 23andMe or whatever because of whatever comes out in this case. During voir dire, all the state has to do is ask them, did you watch the suppression hearing? Yes, I did. Okay. We would like to use a challenge. We would like to use a challenge. Because stuff that came out in that suppression hearing, was stuff that could have been inculpatory, could have been, did you watch the suppression hearing? Yes, I did. What's a suppression hearing? That's the person you also want to vote off, okay? But twisting and covering for each other, it just, $120 agents on this case for everything that Ann Taylor is alleging. There's got to be a lot of witnesses to this shit, right? Where are those witnesses? No offense, but they could say, well, Lana, wouldn't that be like if I told on somebody that, no, fuck you, dude. Just because I wear the same badge as you wear, I back you in the line of duty. I don't back you in the bullshit. It's just so, But they all stick by each other, and then they'll just make sure that you get, you're not going to get promoted, and you're going to be doing what? Yep, let's have them have, second or third shift for the rest of their career if, you speak out. But then there's this whole whistleblower, If I was the parent, just so you guys know, the parents aren't seeing any of this either right now. The parents are the public. The parents are the public. There's a non-dissemination order. Okay, the parents are just like us. So as a parent, I couldn't even believe. I'd be like, you got to be fucking kidding me. And then to find out that the people that are trying to protect this information are the cops. So someone go interview the G's. How do you feel about this? We're fine with it. We're fine with it. We want to make sure that the right thing happens. So we're fine with it. Really? Well, let's go ahead and remind you of every time you came out and talked to Fox News, talked to this person, talked to that person, News Nation. We're emailing YouTubers. So if I was a parent, I'd be pissed. Like you've been asking, like I would, Bill, why? Why? Well, don't you want to get this guy? Don't you want to get this guy? Fuck you, dude. Fuck you, Bill. I'd be pissed. I'd be pissed. No, I don't want to just get this dude. I want to know what the fuck happened to my kid. And I want to know what the fuck you guys did. Because if there was so much shit that was going around in that neighborhood and that this wouldn't have happened if X, Y, and Z would have happened, and here it's to cover up what should have happened leading up into that day and that this would have never happened, fuck you, I want to know about that. I want to know about that. If your guys' practices literally led to this in any way, shape, or form, I want to know about that. And so basically they're treating this like a Franks hearing, and because they're treating it like a Franks hearing, I would think that this would have been like a 4-hour process at the very least. So if they started at 11 my time, which was 9 their time, they'd get a lunch break at like 12 or 1, and then they'd break for like an hour. And so, you know, yeah, 100%. Yep. Heather says, no consequences for lying, so what would you expect besides witnesses lying under oath? Every time I've had to deal with a court case in the past 5 years, I have witnessed lying. And then so what do you have to do? You then have to have the proof to show to go to impeach them that they're lying, right? And then you go and you show that they did. And so like you win your little hearing, but nothing happens about it. Like as a judge, wouldn't you be pissed if somebody had the fucking audacity to come in and lie in your courtroom? I'd be one pissed bitch if I was a judge and some little prick came into my courtroom and thought that they could lie while I was at the helm. I would say, bailiff, I want to hold this motherfucker in contempt. Take him away. Charge him. And they're like, wait, that has to come from the DA. Oh, then you realize, oh, wait, the DA, you think the DA is going to recommend charges for one of their own witnesses? Oh, wait, that's right. No, they're not. Disgusting. I just get so fired up about this shit. You know how many parents lose custody? You know how many civil cases are literally won and lost due to people lying? You know how many shitty ass attorneys there are out there? If I ever come back in another life, I will definitely be an attorney. I mean, I literally do not know how attorneys, with the exception of, Defense Diaries out there, Andrea, I don't know how they fucking literally live. I don't know how they live with themselves. They just do a really good job of like, hey, that's just not my problem. Even though they're getting fucked, sorry, I can't. Like, I don't know, man. That's just, woo! Nasty. Family court attorneys are definitely crooks. They're literally the whole like part about it. Like it's like the whole family court system though. Because if you realize what it is, it's just all a big circle jerk with that. Okay. Those people are always dealing with each other, those lawyers in that little area, in that city. And then you got the same guardian ad litems and you got the same judges, and all they do, actually that might be actually a pretty good idea, is come back. I actually said I want to be a prosecutor because I would know, I would do my due diligence, and there's just no way that I would be prosecuting cases or going about things that like, get the fuck out of here. That's how you stop corruption is the DAs. But family court is just sick. Family court's disgusting. It's so piggish. It's woo. God, if I just had all this time in the world, I'd write a book on family court. But it is literally, it's woo. It's exactly what it is. It's exactly what it is. If I could inform anybody on how to divorces, if you're getting an attorney for a divorce, you're a fucking moron. An absolute moron. You don't need to. If you need help with a divorce case, if you want to divorce somebody, you guys, the law is the law. Like, do not believe that stuff, that you have to go get a divorce attorney. Okay. Everything is, unless you are, if you're in a state where it's 50-50, it's 50-50. Like you're splitting up everything 50-50. You just want to reiterate, all you want to say is you want the law to be applied in your case. I want 50%. I want 50%. They get 50%. Everything is half. Now, if you are that fuck that tried to come to me and say you wanted everything, I wouldn't take you as a client. How about that? I say, well, no, our laws are this. These are our laws. So why would you think that you would be entitled to everything? Tell me that. Come and sit down and tell me why you think that you'd be entitled to everything. And then I'd probably look at you and think that you're absolutely fucking crazy. And I would say, there's the door. It's 50-50. You got kids. Don't you want your kids to be in good situations when they're with them and when they're with you? So if you get everything, then how is your kid going to be in a good situation when they're with them? Oh, I want my kid to all the time. Yeah. Is that really what's best interest of the child? Take your fucking selfish fucking ass the fuck up out of here. Okay. Like, trust me, people wouldn't. But now if you come to me and you say, I didn't really want a lawyer and my husband is trying to take the kids and everything from me. Oh, he is. Come on into my office. Let's talk about this. Well, first of all, he's not going to. So let's just assure you that. But why does he think that that would ever happen? And you're not going to go around wasting a bunch of money. This is how you're going to do it. You're going to sign right here. I'm your attorney and you're going to pay me $1. And then you're going to start signing up for therapy. And you're going to start talking to somebody weekly because you're not going to be talking to me weekly or it's going to cost you a fortune. But instead, attorneys are like, yeah, let me get $20,000 for a retainer. I tried to file for a divorce and couldn't do it without a paralegal's help. Where do you live? Just curious about that. Annie Pot says, I am loving you, Lana, and I don't even know I'm listening. Family courts are awful, right? You know, remember back in the day during COVID when everybody was on those apps, those swipe apps? What is it like? What is it? Tinder or whatever the fuck they were called. You know how you'd put like you could put what your profession is on there? I was only swiping right on attorneys. Because I had never been on one of those. It was just something to do for fun while we all had to be indoors. And you couldn't, but I just wanted to read these profiles. And then I wanted to talk to them. And I basically was just asking them like about law. I was like, what would you do in this situation? And it's like always just so I can get all this fucking info. Hey, what would you do if this was going on? Was it Grindr? You guys, we would just, man, my friends were like, Lena, do you even look at this app? No. You have all these matches. Why don't you just talk to these people? They didn't even know how to work the fucking thing. I was like, do you guys really do this stuff? You just meet up with strangers? And there were so many people on those apps that were like looking for a plus one. And I'm like, what's a plus one? Looking for a unicorn? What's a unicorn? Tell me more about these things. Oh, shit. I just laugh for days. I'm like, oh, I love this. Husband and wife looking for their live-in girlfriend. What does that entail? Is that a job? Where do I apply? Gosh. Yeah, absolutely. And then there was like, and you know what the best part is when you hear that people say, they're like, oh my God, me and my husband or me and my wife, we have the best relationship ever. I'm like, yeah, right. You guys keep lying to yourselves. Nobody's on these apps saying how they want to add to their amazing life by bringing in somebody that's going to clearly cause so many problems in a relationship. Because especially when you get like ADD people and they're just like, oh, who do I give all my attention to? Like, I can't focus. You gave me more attention in the bedroom than I got last hookup session. Excuse me? Who's keeping track of this time? Tinder for legal advice. Yeah. That was all during COVID. I was just like, this is real. I'm like, you guys are farmers? Oh, I thought you guys put lawyers down. I'm sorry, I gotta go. I really wanted to get some legal advice. That's why I swiped right. Damn it! I must have been drinking when I saw farmers here. Farmers? This combo is amazing. Yeah. Stand up right here. Jen, love you. You guys, we've had 79. Thank you so much, Jen. We've had 79. Oh God, how did I just notice you coming? Yeah, I cut it all off. It'll grow back. You guys have no idea how fast my hair grows back. It'll grow back super, super fast. Ooh. What was I saying? Well, for some of you guys that don't know, if you're new to the channel, I said there were 79 people that super stickered or super chat or whatever. And then people hit me up in Cash App. Bob Model laughed. I said, let's talk to each other on the speakerphone. He laughed. I was like, you think this is fucking funny? What the fuck, Bob? Who's laughing? But back when it was COVID and, we couldn't go anywhere, Columbus is really notorious for like having like, it's sweet. It's, inclusion, everything. Like there's bars for everything. Well, if you look it up, there's a place that's called Princeton and it's a sex club or whatever. And my friend Courtney is like, hey, do you want to go to Princeton nightclub? It's called or something like that. And I was like, it's fucking COVID. What are you talking about? And she's like, it's considered a private club and they don't have to abide by the rules of COVID. I was like, oh my God, shut up. We can like go. And I was like, it's a wait, what? She's like, well, let's go. We got to go get memberships. I said, how do we get members? They have to run a background check to make sure you're not a felon. I said, excuse me, who the fuck's coming in these places? I was like, okay, so we had to fill out these freaking things. And we go, that was on a Thursday night. We go and we show up. And they're like, but clearly we're just totally out of place probably. But, oh, hey, yeah, we just signed up on the website. You just passed your background check. Hey, give us your names. Give the names, and then they're like, well, "Who are these people with you?" I was like, "Oh, these are our friends. They were guys." And they're like, "Did they sign up?" And I was like, "I don't know." And so our memberships were like $20 for the year. The guys were like $200 for the year, and my one friend was like, I'm not paying $200. This is so stupid. I was like, here, I'll pay for you. Just come on, let's go. Cause I was already there. I was just like, fuck you. You can buy me back like dinners over the course of the next, whatever, we're going in. And they're like, where's your drinks? And I was like, excuse me? They're like, you bring your own drinks in there. And so then we leave to go down to the store to go buy these drinks. Cause then we go in there and then they give us these wristbands and we have to give our drinks over the bartender. And I'm like, what did you get us into, Courtney? And I just wanted to go to like listen to music, be by the bar, just bullshit. And next thing I know, this guy comes over to us and he's like, hello, ladies. Would you like a tour of your new club? Blah, blah, blah. This is the. I was like, okay, yeah, sure. We'll go tour the place. Fucking A. So we get our little, you don't buy back your drinks. You just tip the person when they serve them to you. So I get my drink. She gets her drink. And we're ready to just go tour this like sex club. I'll never forget it. We open up these doors and they're like, these are where the bathrooms are. And here's one of our lovely play areas. And I was like, holy shit, was not expecting what I got. There was a saddle and somebody was riding this little, fake pony and royally, just engaging in sexual activity. With some masked man, I don't know, like you were at Mardi Gras, one of those masks, not like fucking BK mask. And I'm just like, holy shit, what the fuck is going on here? And I just bust out laughing. And I'm like, oh my God, it's probably totally not nice. And then they're like, yeah, this is our public area, blah, blah, blah. Then these now are our rooms here. If you want to take one of these rooms, you can go right in, you can leave the door open and people can just come in and play with you. I'm like, what? Yep, you leave the door open. If you pull the blind back a little bit, that means you just want to you can have peekers. And I'm like, excuse me? Or if you pull totally open up the blinds, it's, exhibitionist. And I'm just like, okay. And we have 24/7, like when you're done playing, just take your sheets and da-da-da. And I'm just like, this is like a thing. And I'm like, for you to get me speechless, it's pretty hard. And I'm just like, Courtney, what the fuck? Where the fuck are we? So let me go to this next area. And here it is, just like a big old room now. And just beds and couches everywhere. And they're like, this is another one of our lovely play areas. And sure shit, people are just having sex. And I'm just like, oh my God. And I'm like, how much longer on this fucking tour? I'm getting not embarrassed, but I'm just getting uncomfortable for the people that are engaging. But then they're like winking and being like, yeah, come on over here. So we get finally back. And I'm like, oh my God, I have to go to the bathroom. And I was like, Courtney, I'm not going by myself. So you're coming with me. Because I have to go past fucking plow land over here with like the saddle up people. And I'm like, you're coming with me. Then because she would start laughing because she knows why I'm saying this. And so here we go. And I'm just like, okay, just look down and you're just going right to the left and just to go to the bathroom. Well, here, horsey people and saddle people, they decided to move on over to the left side where I was headed because I'm keeping my head down, going left to the bathrooms. Well, right before the bathroom, though, there's this doctor exam room, and I just fucking lost it. I run like right into these people, and this guy's over here just. I'm like, fucking A. I was like, oh my God, I'm so sorry. Then oh no, it's fine, you can join. I'm like, this is ridiculous. I was like, I wasn't ready for it. I was like, holy shit. Go back out. And then these people bring Jello shots up to us. Hey, do you guys want to party? You guys hear some Jello shots? I'm like, what do you mean party? Like, I want to play pool if that's what you're talking about. I don't know what you want to do. So then we became regulars at this place twice a week. And everybody, we would see PTA moms and dads coming in there, bringing in their freaking coolers, reeling in stuff, like getting all dressed up. These are people that are like the pristine community members, literally like our PTA moms and our business dads, gone on vacation, always away working, whatever. We see them rolling in there for like, oh God, tonight's like jocks and a cheerleader night. And we're just going there to drink and hang out because we don't want to be inside. These people are going there and it's a lifestyle. They're like, oh, so when did you get involved with the community? I'm like, excuse me? When did I get involved? Oh, when COVID hit. I just came right out of the closet right after COVID. So I was just like, wow. I was like, I thought I knew a lot about life. Wow. They're like, oh, this is our lifestyle. I'm like, okay. We live like an hour, 2 hours away. Like we come here I'm like, okay. She's like, will you film me while I give my boyfriend a blowjob? I'm like, excuse me? Film you? I said, I think those are against the rules. She's like, oh yeah, just don't tell anybody. I'm like, no way. I'm not getting my membership taken away from me because you want me to watch you blow your boy and you want me to video record it. I'm like, so this is me. I'm like, why don't you just set up your camera in like under the sheets? Like, what's wrong with you? So here I'm then teaching people how to get around the damn cameras everywhere. And you had to like literally, if you can't have a record and be in there, and if you had your phone out, they charge at you and just rip it out of your hands. And there's no phones in there. But I'm over here teaching them. I'm like, well, you would just put your phone up underneath those sheets, girl. Come on, get a tripod. So that's what I did during COVID. Learned a lot about the anatomy. Dateline and sex clubs. All about those camera angles. Look out. So great. My story, we lost 100 people due to that story. That's all your guys' fault. Film school. Thank you there, Moon. Moonvale, 5 memberships to people. Cheers. So I would just cheer people on in there. I was like, oh, you guys having a great time? Oh, I'm so glad. Great. Awesome. Woo! I was like the biggest cheerleader for people when I would see them. The bartenders, they loved us because there's a rule there that when you had to walk, like they could let the bartender know, like, hey, can you tell that person that we want to play with them? And so the bartender would always come and be like, hey, Lana, I know that I was like, hey, anybody asks you, just say no. Like that way they could just, but she was like, I just have to tell you who is least asking me so that you know. Because like we became like, I don't want to say friends with them, but they would love when we came in there. Plus we tip well. And I hate that couple wants to play. I'm like, okay, well, you told them, right? I just would wave. I'll take those Jello shots, though. Come on over with those Jello shots. Though they're allowed to. They're allowed, the bartender. You can go to a bartender and be like, hey, does that person, what do they like? And I'm like, what does that even mean? Oh, I get what you're saying. What do I like? I got you now. I was like, I like Jello shots, yeah. So, but it was all like, I'm telling you, it was business people. I learned a lot. It was PTA moms and businessmen. It wasn't like college freaks or something like that. So the bartender is like the broker. Yeah, but they don't get cut off a piece. They don't get no tips for that. It was the cleanest place I've ever seen in my life. I'm telling you, look it up. People fly in from all over the country to go to this place, and I had no idea. It's a really big, it's huge. It's like a warehouse. It was like a Diddy freak off. Not quite. Who's at work listening to this in their earbuds? I met no lawyers there. I met none. I was like, are you a lawyer? You a lawyer? No, I wasn't asking people what they did, but are you a farmer? So who's at work? We're just waiting over here for Judge Hipla. We have that here. It's called Lifestyle. It's totally underground. Oh, yeah. I'm a member for life. Men, yeah, it's like women pay like $20 for the year. Guys pay $200 or $250 or something. And then each time you go, it's like $25. I am happy I'm not listening on speaker at Walmart. That'd be great. Hipler is heading to the Princeton tonight. Hey, What is up with this hearing? Well, if they're treating like a Franks, you know, this order that just came through, and that this is a, I would think that that would be a long hearing. I don't know if the Franks should have been heard with this motion to suppress after this little, you know, order. Bob laughed. All right, let's see what else in the vault. In the video files. I know I got more. Thank you. Ooh, this is Welch's body cam. I got my jury report date yesterday, and my partner was very confused by how interested I was. Be kind in chat, love. Truly's for the win. What do we got? Let's see which one this is. This is the body cam footage from September 1st, 2022. 8:34 p.m. A call was placed for a noise violation. I got your Truly. I'm gonna have to order Jersey Mike's, man. I have to order something. I'm gonna get some Chinese in here. The Moscow Police Department arrived at 8:54 p.m. 3 officers in uniform, 1 undercover officer. We have still yet to find out who is that undercover man. See what any reports are. Ooh, look at that. See what it is. So this is the one. This is the video that's not. You guys, listen to how loud that is. Okay. Like they're in the street right now.
We can stop, observe what's going on, see if there's any other activities we need to be aware of.
They're so concerned. Okay, so think about this. So think about the night of the murder. There's these undercovers that are all over, and they actually are coming out of an area where they parked that is right kind of where this is, just a little bit, south of where this camera's at. And so they like to always like stand back, you know what I mean? They park away from it. They walk around though. So the people that would be clad in black are going to be, they're clad in black. Look at how dark that is. Don't you hear somebody in there saying Kaylee? Kaylee? Did you not just hear that? I heard that. Did you not hear that?
We can stop, observe what's going on, see if there's any other activities we need to be aware of.
Okay.
Hey ladies, how's it going?
Good, how are you?
Good.
We're not actually I don't know.
Who lives here?
No, I don't.
We're here for noise complaints.
Yeah, they did.
Beat on the damn door.
There's Blaker right there with the light shining on. Like he's the one that's right across right there with the light.
Hey, who's the owner or who lives here?
I can go get them real quick.
Okay, thank you, please.
Oh! Pain. Truly's for the win!
That ran away.
Oh, really?
It just ditched it. Awesome. Yeah, those ones kept walking in the car, and the other one around the back corner. Hey, property. Take that back. There's a lot of fucking alcohol in there.
Mm-hmm.
That's not abandoned property. How is that abandoned property? It's on property.
Moscow, I said why.
That is not abandoned property. Like, this is how dumb. That's not abandoned property. That is on that. You have no idea if the person that lives at that house is the person that dropped that bag. Okay. You have no idea if the person that dropped that bag is a friend and who was at that house. Like, how is that abandoned property? Well, let me tell you guys something. It's not.
Got an 1122. Yes. That's hilarious. Tuesday has the cops just blend into the darkness. Yeah. Not gonna come back?
How many people do you bring to a freaking noise complaint?
That's all right.
They don't have to answer the door.
We're only here for a noise complaint. Come to the damn door.
We're supposed to believe anything that anybody's going to say because...
Teach you how to dog.
Start the search. I just rang the doorbell.
I remember getting this video thinking, what the hell are they doing? Look at this little peeping Tom. This little peeper. Look it right there. God, I remember like this was yesterday. This was 2 years ago.
Whoever lives here needs to come talk to us, or we're going to start doing a lot more than just deal with noise.
I will go tell them.
Yeah, just tell them to come to the front door. We'll
Front
deal with
door?
the noise complaint, and we'll
Okay.
leave. Yep, thank you.
We're gonna start doing a lot more. We're doing what? Doing what? What are they doing? We're gonna start doing a lot more. About what? What are we gonna do a lot more with? Because if you know that they're doing something illegal, like what do you mean? Think about that. We're gonna start doing a lot more. What can you legally do that's more? We're gonna start doing a lot more.
Come to the door, guys. Send whoever lives here down to the door. Not leaving. We can also see you.
Yeah.
We can also see you.
They're scared.
Oh my god. Look at, listen to how immature they are. They're scared. Oh god. Serve and protect. This is what we're hiding. We're hiding law enforcement today. They're not talking to them, right? They've lied to them, right? They're gonna lie to them here. So we're supposed to believe anything that then any of them would have said during a murder investigation? The day that they started interviewing people after the bodies were found on November 13th, you think that these people are telling the truth? Thank you there, Mikey S. Still not down there. Still no one's opening the door for the police. What's going on?
Okay.
So I just looked for everyone that lived here, and they're not here right now.
No one's here that
No one's here
that
that
lives here at all.
No one's here that lives
So
here.
everyone here is trespassing?
No one's here that lives here. No one's here. No one's here that lives here. So now I want to ask you guys a question. You want me to believe that Dylan and Bethany were there when 4 people were stabbed, brutally stabbed? Because it's customary for them not to be there, right? And people will be partying in our house, we won't be there. We just looked all over. No one's here. No one's here that lives here. The best comment is, well, who lives here? Oh, we don't really know. Then how could you go around looking for them if you don't know who lives here? Listen to this.
Well, no one's here that's trespassing, but no one that lives here is here right now.
So where'd they go?
They're just not here. I have no clue where they went. No clue.
So you guys just throwing a party in their house at this
They were
time?
here
And
at one point. They're not here right now. I just searched all the rooms.
They left and went over to some other party, and everyone is about to
I
leave
just
and
searched
go
all
over
the
to
rooms
another
and looked
party.
for them.
Okay. Who does live here? What are their names?
I am actually not sure. I live.
But listen, I'm actually not sure, but they all went to a party. Listen to this idiot. Listen to this shit. Listen, everybody that lives here is not here. Well, who lives here? I don't even know.
Across the street. I just came over. I haven't drank a drop.
Male, female?
I think it's mainly females. I think it's like 4.
I think it's It's mainly females. Who's the male? Who are the males? I think it's mainly females.
What sorority are they affiliated with?
I don't know.
I don't know if they're associated with the. I don't know.
So I guarantee you they're.
I don't know if they're associated with a sorority, which may not be a lie, you know, because we got information that says that Maddie and Kaylee were no longer in the sorority, and that doesn't want to be talked about. Well,
associated with the sorority. As many of them are living here, it's an off-campus sorority house. I've been a cop for 22 years here.
it's an off-campus sorority house. I've been a cop for 22 years here.
I'm not stupid. Don't play dumb games with me. I'd rather deal with this as a noise complaint than getting a hold of the Greek council and the Greek board and all of that and the students and playing all these stupid fucking games.
Do you?
All I want to do is deal with noise complaints. Because I guarantee you there's a lot of underage drinking because they left their alcohol behind.
Do you want us to try and get a name or a phone number and if we can call someone?
We just need to talk to somebody who lives here because otherwise I have to be under the assumption you guys are unlawfully entered because no one who lives here is here.
Okay.
Right?
We'll go.
So I need to verify that there was a party here. Not everyone left.
We'll go get a phone number. We'll be right back. Sorry, we're not trying to make your life.
I understand. I just letting you know this is how it's going to play out. I'm not going anywhere until I talk to somebody.
We'll be right back.
You guys mind just leaving the door open for us? That way we can get some sort of communication between us and them. We're not going to come in.
No.
Yeah.
Okay. Thank you.
Yeah. No worries. And hey guys, really, we're just coming here for a noise complaint. So we understand y'all drinking.
The reason I apologize for no one coming to the door. The issue was we were trying to find the
everyone's kind of freaked out because cops are here. You guys are having a good time, right?
Well, I've been at another house before and I went out and talked to the cops, but I wasn't the resident, so they just told me to go back inside, basically. So
no worries. So hey, just go ahead and get the contact. Thanks, man.
We'll be right back.
All right.
He just shuts the door. I love it. Do you mind leaving this door open? Yeah, I fucking mind. He shuts the door.
And don't tell me this isn't a fucking off-campus sorority house.
100% sorority house.
I was seriously the same thing. Take all the campus back. Have a nice day. They threw a big ass party with underage drinkers, and they all left and wouldn't come to the door. Center and cooperative. Yep. Here are the names of the people who were there.
Can you imagine? Now think about this. These guys showing up for quadruple homicide. These are the guys. They royally fucked this case up.
There's a party somewhere.
Yeah, their music got real quiet.
Real fast.
Real fast. Noise complaint done.
The only one that I hear.
Yep.
Noise complaint at 8:30.
Guess what?
Huh?
Start dumping alcohol.
Good to go.
Guess what? Start dumping alcohol. Let's start touching all the evidence. Just start dumping it. Listen. Guess who made that call? Blaker made that call. Guess what? Start dumping the alcohol. Why? Why are we dumping the alcohol?
They abandoned property.
It's not abandoned property. What are they doing?
White Claws? White Claws. You're going to be so angry at me.
You're going to be so angry at me.
Yeah, these are cold.
Open one.
Hello. You do that? Learn that from a college kid.
All right, Josh. Gordon, you talk to
Yep.
Maddie.
This is one of the owners that lives here. She's on the phone right now.
Hi, this is Officer Welsh from Moscow Police Department. Who am I speaking with?
What an idiot. Doesn't even get her phone number.
Maddie, 1 second. Let me turn the volume up on this phone here.
People want to be dumb.
All right, can you hear me, Maddie?
That's a legal search. Why are you going through that bag? What are you doing? What are you doing with that bag? What are you doing? I don't understand. They just assume that was somebody's. Think about this. You're just assuming that. Why are you dumping this out? Alcohol in a book bag is not illegal on the property of a house. I'm just saying, think about it now in the source of work. What do you think they did in this case? They just do whatever the fuck they want. That's what they do.
Yes, I can hear you.
Okay. Do you live at 1122 Queen Street?
Yes, I do.
Okay. So, hey, the reason that we're here is that we received a noise complaint of loud music, partying. Okay. Once we approached the house, people started running away. They left a bunch of alcohol behind. We're not even coming for alcohol. We're coming for the noise complaint. And then we sat here for approximately 10 minutes trying to knock on the door. No one would come to the door until these two gentlemen came down and actually answered the door. So, right now, if I can, I would like to collect your information, your name, number, your date of birth, and I'm guessing, and I want your current address also as well, okay?
Yeah, sounds good. I'm so sorry about that.
It's okay. So, let me go ahead, and what's your first name? Maddie?
Maybe.
And how do you spell that, Maddie?
My legal name is Madison. It's Madison.
What's your middle name, Madison?
May, M-A-Y.
Okay. What's your last name?
Mogen, M-O-G-E-N.
M-O-G-E-N?
Yep.
Okay. What's your date of birth, Madison? Okay. And what's your current address?
1122 King Road.
Okay. And are you a student at U of I?
Yep.
Okay.
I will graduate with a bachelor's. I'm still getting my master's.
All right, Madison. So here's the deal. Okay. They've already said that no one here lives at, none of the occupants that live at this address are here right now. So now you have a house full of random people. You need to let them know that the noise needs to come down. Okay. We just received a noise complaint. We want that music turned down. And we don't want to come back again tonight. If we have to come back again tonight, then there's going to be even more problems, okay?
What problem? Good. I'm just frustrated. I'm also so sorry once again.
Hey, I understand, okay? It's just, I mean, if I were you guys, I'd probably just come home and make sure that whoever is partying here is keeping it down to a minimum, okay?
Yeah, we're going to take all of them.
Okay. So at this point, we're going to leave, okay? And again, if I have to come back later tonight, like I said, I just want to express that there's going to be some citations given out, okay?
Who's getting cited?
Okay, very clear. Thank you.
Yes, ma'am. Okay, you enjoy your evening, all right?
You too.
Bye. All right, man.
Who's
Here's your phone.
Thank you.
Hey, so, yep.
He didn't ask
You already
for
told her about
number.
noise?
Yep, already told her about noise. If we have to come back.
You guys to noise because you don't live here.
Yeah.
But I would probably strongly suggest that anyone else that's left here, they don't live here. Probably just be
Thank you guys.
If not, I'm going to come back.
We weren't lying to you guys. No one lives here that we were just.
Yeah, they were here. They went to a party.
This would not be the first party I've ever gone to where the people who live here leave. Yeah. And just let people stay. Why they do that, I don't know. To me, that would be stupid.
It happens
Stay where I
pretty
live.
frequently.
I've done this for 22 years now.
Yeah, I guess, yeah. But, yeah, we'll go let them know. And then make sure.
Just let them know I'm not going to stand
check to
out
see
here
if she
and wait
lived
for them
there?
to come out and give them MIPs or anything like that.
So he just, okay, Maddie, sounds good. Like, how do they know that she lives there?
Yeah. That's the first way you're going to get us. Don't do stupid shit, right?
Could have just talked to anybody.
I'm sure it's not the first time
Unless
you've
you
heard
know that
somebody
Maddie
say,
lives there.
don't do stupid shit and the cops won't touch you. Yeah. Be smart. Don't be stupid. Don't draw attention to yourself. Right?
Pouring out the drinks.
Thank you. Appreciate it.
Oh, we're going to try it. I appreciate you guys going above and beyond for us and helping us out a little bit.
I'm sorry for the issues in the first
Going
place.
above and
Hey, it is
beyond
what it is,
for
man.
us.
I'm used to it. All right. You guys have a good one.
They just lied to you. They went above and beyond. They don't know who lives there, and
My hand smells like Truly.
my hands smell.
It's kind of delicious. Dude, Truly's are.
That's going on my next CD. My hands smell like Truly. That's going to go at the end of Lana Brains. My hands smell like Trulies.
Trulies are awesome, man.
Trulies are awesome, man. All this shit.
I can drink like 12 of those things and not wake up hungover. It's awesome.
You can drink 12 of those things and just not wake up hungover. Wow. And Taylor's gonna have it easy. So you have no problem lying to the cops, right? You've lied to the cops before, right? Well, look here in this clip. Like, you knew who lived there, right? You knew everybody that lived there, right? Okay. Absolutely ridiculous. Absolutely ridiculous. Let's see what else we got in the vault. More camera. It is 2:34 here. It is 12:34 there. All right. And let's see. Oh boy.
$40.78. It's going to be this 1222, or correction, 1122 Queen Road up here.
Yes, I did.
I got it. Hey guys, Moscow PD.
Okay. Let's see. This is a good right here. Welcome if you are hanging out. Truth and Transparency. Appreciate you guys being here. So Exhibit A of Brett Payne, that's his probable cause affidavit. Right here. Based on the above information, I am requesting an arrest warrant be issued for Bryan C. Kohberger. So based on, everything that was in that probable cause. And so what we're talking about today is this is how you obtain the arrest warrant of Bryan Kohberger. On December 27, 2022, Pennsylvania, right? Oh, wait. Instead, the state has relied on and will continue to rely on the STR DNA analysis comparison. Well, no shit, you're going to be relying on that, but how do you have a comparison? How are you able to compare the DNA? Well, you can compare the DNA because of IgG. I mean, fuck shit. It ain't that difficult. You don't obtain his swab without the IgG. Because then you would have never taken his parents' trash, right? So prior to the FBI's IgG efforts, the ISP laboratory developed the traditional STR DNA profile from the DNA on the K-1 IgG. But after identification, it says after identification of defendant, law enforcement recovered trash from the home of defendant's parents, and ISP laboratory did STR DNA. Yeah, after identification of defendant. How did you obtain the identification of the defendant, Mr. Payne? The FBI gave me the name Bryan Kohberger. And how did they get that name? Investigative genetic genealogy. It's pretty simple. The state did not get the buccal swab from Bryan Kohberger until after his arrest. How did the state obtain an arrest warrant for Bryan Kohberger? By lies. The FBI gave the name Bryan Kohberger to local law enforcement through a tip. The name Bryan Kohberger was the tip. What was the date of the tip? How was the tip submitted? What FBI agent submitted the tip? Was the tip before FBI took over lab work on the sheath to develop an IgG family tree? Well, we found out that the date of the tip allegedly out of Brett Payne's mouth is December 19th. Then we find out that he didn't know anything about WSU until December 20th. What FBI agent submitted a tip that has not been revealed yet? And was the tip before FBI took over lab work on the sheath to develop an IgG family tree? And that technically hasn't been answered, but I believe that it's no. Remember that the FBI set up their own tip line just a couple days into the investigation. Off of the work that I've done in this case, the FBI most certainly had Bryan Kohberger's name from something before December 6th, 2022, because they issued an Amazon subpoena through the federal courts, federal grand jury, okay, a subpoena for Bryan Kohberger's Amazon account. Oh, how do you know that, Lana? Because Maury made a huge boo-boo when he copy cut and pasted the FBI's work and put it on then onto his warrant that he drew up and forgot to change the 12/6 ending date to 12/29. That's coming out in the hearings today. The Idaho State Police utilized a private lab to develop an SMP profile from the DNA on the K-bar knife sheath. The private laboratory started using genetic genealogy to develop a family tree. We want dates on all of that shit. They're coming. We're going to get those dates. Because that's everything that if you're putting together a timeline as to how you got and when you got to Bryan Kohberger, what were you doing? There's reports, but why can't we get any of these reports? You guys are sealing everything. And when I say you're stealing everything, you're stealing stuff from us, but you are not providing the material because here's Jennings and fucking Bill. We don't have it. It's not in our possession. We don't have that shit. Sin spin. It's lies. They knew exactly what they did in this case. The IgG process pointed law enforcement toward defendant, but it did not provide law enforcement with substantive evidence of guilt. The FBI did not, for example, conduct a direct comparison between the SMP profile from the K-bar knife sheath and defense. Well, really? They didn't? Why not? Why wouldn't they? I disagree. And when you go back and you read these documents, the best part about these documents is that you can clearly see now that they were lying. They lied in these documents. These documents have lies in them. Like, it's just wild. Prior to the FBI's IgG efforts, the ISP laboratory developed the traditional, we all know that, right? Right here. For example, they did not conduct a direct comparison. You would. When did they give that name again? Oh, Idaho testified via Payne. I got Bryan Kohberger's name on December 19th. Okay. So let me get this straight. The FBI, who's supposed to be working in concert with you together, they were just doing their own thing and they weren't providing you with any of this stuff so that you guys could protect the community from a potential complete psychopath. Awesome. Good to know. According to Payne, the FBI kept the name Bryan Kohberger from them, and they had the name Bryan Kohberger way before. Unbelievable. So sad. Again, when we want dates. Let's get the thumbs up to 1,000. Yeah, sounds good. I like it. After identification of defendant, again, law enforcement recovered trash from the home of defendant's parents. Why would you ever do that? Now here, I could tell that they're lying. Okay, let me ask you a question. If you got the name Bryan Kohberger, because everything that I've talked to and everybody that's involved in investigative genetic genealogy, they tell you this is protocol. Once we have some people that we believe are like, okay, here, this person, this person, this person, because let's say that it leads back to this family and they have 3 brothers. Okay, we then go out and get the DNA of each of the people. We don't go get their parents' DNA. We go and lift like a cigarette or a pop can, whatever, and then we're comparing that individual to what we have. And so after the identification of the defendant, law enforcement recovered trash from the home of defendant's parents. Well, I know for a fact that law enforcement, aka the FBI, had his name so way long before December 19th. So, and he was in Washington. And why wouldn't the FBI, that's the DOJ policy, that when you're working with a genealogist, they will say, go and get this guy's DNA. And then we're going to compare it to what the fuck we have. That's what you do. And they had it. And so what was the FBI doing? And that's what, what's his name says. Jay says, I'm sorry that Bryan Kohberger doesn't want to just, I mean, what was the FBI doing running around with Bryan's DNA? Anybody that works in that industry says you would have told the agency that you're working with, this is the name I came up with, or these are the 3 names that I came up with, or the 4 or the 5. Then they go and get the DNA of that person to then test it. The FBI wouldn't just say, here you go, Moscow. Here's the name Bryan Kohberger on December 19th and not have done their homework. You understand? They had his name. They used a grand jury, and on December 6th, got his Amazon account. So you're telling me you didn't try to get his DNA? Or did you and did it not match? I have no idea. But this is the stuff that's we're being shielded from, is why, like, this type of shit. You guys, the FBI got the name Bryan Kohberger from doing their IgG. He's in Washington. They're in Washington. You're going to tell me from December 6th until he left with his dad on like the 14th or 15th, whatever day that they got in the car, 13th, for that whole week, they couldn't lift any DNA off of Bryan Kohberger? And that's being kind to say that they would have started on the 6th. They went after the Amazon search subpoena on December 6th. It doesn't make sense. That needs to be explained, so then it would make sense. But instead, they're just doing all of these things with the grand jury, right? Their own federal grand jury that Moscow Police Department has no idea, right? And then FBI says, well, it's fine. We're not going to tell anybody anything. We're just going to keep an eye on him ourselves. We're just going to keep an eye on him, and we're going to run these things, and we're just going to make sure he's not a serial killer, because if he is a serial killer, then we're just going to assume jurisdiction, and we're just going to steal it from Moscow, right? But here, guess what? They couldn't federally indict this motherfucker. Why? Why couldn't they get a federal indictment? Why couldn't the FBI get a federal indictment? Because it's Moscow. They don't have jurisdiction. It's Moscow's case. And you guys now think about it. Remember when Chief Fry came out and said, this has always been our case. This is Moscow's case. He said that on December 21st or 22nd in a presser, when they're being recorded with their YouTube channel. This is our case. We've always been in charge, blah, blah, blah. Who is he telling that to? Why would he even be needing to say that? Well, clearly there was a power struggle going on between Moscow, Idaho State Police, and the FBI. And they wanted to act like they're all like chummy chum with each other. And they're not chummy chum with each other at all. And the FBI, exactly. That's what I think it was, is why wouldn't you, and so then they eventually some way, somehow decide, okay, we're going to go ahead and give Moscow Police Department the name Bryan Kohberger. And then I don't think in 1,000,000 years, I don't know, because I'd have to see the testimony here, but how Moscow went about doing anything that they did between December 2019 when they got the name to then December 30th when he's being, arrested. Think about that whole time, and here the FBI had Bryan Kohberger's name for way longer than that, actually, and it just doesn't make sense. Everybody that I talked to said that this is never how you would go about comparing it. This is not the DOJ policy. And that's the people that testified back in August. It's people that didn't testify back in August. This process would never have been handled this way. So why? If he would have been a serial killer, it would have been a federal case. He was clearly deemed not a serial killer. Since December 30, 2022, Lana has been asking myself, how did law enforcement get the name Bryan Kohberger? How did they truly get it? And when did they truly get it? Well, they got it from the FBI. And here I'm telling all of you guys that the FBI had his name for weeks before they turned it over to Moscow. Why? So it's, and this is what we're being shielded from right now, is them hammering the hell out of law enforcement. Lana, how did the FBI get his name? Well, that's what's being revealed right now in court. And that's what we're being shielded from. No, you don't have to. No, they didn't have to say anything like that. That's why this is happening, though. They chose to be so crazy with, hey, you can't. It's like someone saying to you, hey, you can't use me. You can't. But you're not going to. The question I just want to know is, did the FBI help truly Payne obtain his search warrants? And I believe it's no. Because I don't think this would have ever been this sloppy. It's just been like, here, I'll help you do this. I'll help you do that. I'll show you how to do this. I'll show you how to do that. And all there was copy, cut, and paste. And that's not helping. And in fact, that clearly hurt the case. But this is the part that's being shielded that we're not seeing right now. They say, don't worry, you're eventually going to see it one day. And the defense is saying, well, Bryan Kohberger's open trial and he's on trial for murder is now, not after the hearing. No, this is where I show why Bill Thompson lost his shit. Ann Taylor wanted to know who's the confidential informant. She just asked for discovery. And when it came to number 7, it said, give up your co-defendants or give up your, is there a co-defendant in this case? Give up your confidential informants. And this is when literally Bill Thompson lost it in open court. And and claimed that all of us are informants because of IGG. And that's just unbelievable. What's up, woman doing chaos? What is good? Good to see you in here. So number 10 here, to the extent that the information exists, is any informant who is not going to be produced as a witness, including recordings or written statements of an informant at the identity of the informant, such that. And so she's citing this case, right? And this is just where Bill Thompson just loses it. And I'm saying, hey, Dylan, were you told about the bushy brows? And it's like, no, I don't even think Dylan ever said that. You know, and what's bushy to me could not be bushy to you. But for Payne to determine on his own that something was bushy, that doesn't make any sense. He isn't the person that saw the person. It's just so stupid, you know? So 17,000 tips. How many tips before the public inquiry? You know, 17,000 tips. Not a single one of them was the name Bryan Kohberger. Just we're clear on that too. 17,000 tips. Remember, if you have a neighbor that drives an Elantra, tell us about it. Okay. Nobody called in Bryan Kohberger or his Elantra. 17,000 tips. Not a one was BK. Just like Richard Allen. You know? And then you get to the guy, and I'm all for it. Hey, you know what? You use IgG. You didn't want to tell anybody about it. Great. Awesome. I would expect some returns on your damn search warrants. You know, people put search warrants out there before they arrest somebody. So why not put out a search warrant for his car and see what happens when, you know, see what you get back. And then for his apartment, see what you get back. For his this, for his that, see what comes back. But the reason that they couldn't do that in this case that you normally would do is because they knew that there was going to be no returns on those, which would have then kept on, you know, making it harder and harder and harder to get then your arrest warrant, because that in a way is exculpatory for Mr. Kohberger. That's how I would argue that, because at every turning point that they were trying to get something, which they did, it returned nothing though. Like you should be, oh my God, boom, here we go, here it is. Wow, we got blood, you know, in the car, or we got him searching for days and liking the victim's social medias or whatever, you know, whatever it may be. But they couldn't do it in that order because they already knew that the returns were going to return nothing because the FBI did it. Okay. And so then we're going to shield Moscow Police Department from this all so they can just claim fucking ignorance. All right. And there's different ways to look at why the FBI did what they did and why Moscow Police Department. But we don't want to guess. I don't want to guess. That's not what I'm here to do. I want to see the information, view it, put it out here, and then based off of everything that's led up to this point, I'm going to tell you what I think. But they sealed it. They closed it until they want to open it. And so everything that's being talked about right now is still just the so-called Franks hearing. We're not even on to the suppression parts. We're not even on to the suppression parts. The only thing that's been talked about in that courtroom right now has been everything to do with this. Hey, we're going to have a Franks hearing, but it's really not a Franks hearing. But yeah. Crazy. Thank you. Very kind. Deborah, Lana, keep on keeping on. It's going to be all right. Oh, hell yeah, it's going to be all right. I'm just saying, like, anybody that's literally, like, defense ain't hiding shit. The state is hiding it all. So, but let's go back over here. Yeah, what's up? Alrighty. So, yep, we are still in a hold here. I mean, they have to take a break to eat lunch, so that's an hour of it. So if they started at 9, they went from 9 to noon, 9 to 12:30, then they would break for lunch. So I expect them back in the courtroom between 3 and 3:30 after an hour break. I mean, we're not running it's just a day of work. So, but yeah. Court will be, oh, yes, there we go. Court will begin soon after the lunch break. Knew it. Yeah. Here we go. Yeah, bitches. Let's get ready to rumble. Yes.
You want Jimmy John's? He's good with it. You know what to order him. I'll go pick it up.
Okay, I'll send it to you then. Okay. I'll text it to you. Text it to you?
Oh, okay.
Is that what you want? Yeah.
Yeah, you can do that.
Okay. Thank you. Appreciate that. Here we go, guys. I need extra water for this. Again, I won't be doing much talking. Obviously, I'll have to make sure your guys' volume's up. I want to say thank you, though, for joining up into this point. Thank you for all of the super chats, super stickers. We hit 89 total in some capacity, and I'm going to read these all at the end because I just want to say thank you guys so much. A lot of time does go in and researching all this before to talk about, whatever is up and coming. But thank you, and I'm glad that you're here because you can be watching it anywhere you want. When I used to own a bar, I always say that, you can go get a beer wherever you want. You go places because of the people. The people make things go around. So thank you. Appreciate you. What'd you learn at school? Stuff? Cool stuff or bad stuff? Stuff? Don't you guys love it when you ask your kid what they learned? Stuff. Oh my goodness, Anna, thank you for your beautiful words to Kathy. Oh yeah, absolutely. I love Kathy. That broke my heart that day of the verdict. Broke my heart. Broke my heart. The judge was like, nobody's making any outbursts in this courtroom. And so Kathy had to be like, whoever's side. But she's going to win. Kathy's going to win. Vanna. And Mike, come get you to partner with. What? Nope, I would just want to do her discovery work. Kathy is a queen. Sure is. Lana, my son would have said lunch. He said it was great day. What'd you learn? Stuff. What kind of stuff? Stuff. I told him we're going to go out and celebrate truth, justice, and transparency. Tonight we're going to go to have sushi, and Jack's favorite dinner is sushi. He loves California rolls, rainbow rolls. What else? Then he loves the sashimi. We grew him up in a sushi bar. So Kathy Allen is a very strong woman. Kathy Allen is the shit. What is up, What's up, Hella? That's what I'm talking about, girl. You knew where to come. Cheers, baby. Drop her link in chat. If you guys don't know about her, know about her. Also, shout out to all the amazing mods. I see a bunch of mod names that mod, around town, and you guys are awesome. You guys are literally. I pop into people's lives, like literally to see and say hi to the mods. So I just want you guys to know that. And of course, Truth and Transparency mods are just fucking dynamite. Keep in your prayers, Miss Kelly. She's a mod. Her mom, if she's listening, maybe she is. She just had a couple different surgeries, and she's always been so kind and opened up her home for me and Bella to come there during the Karen Reed stuff. And we just want to say thank you, and we're thinking of you and praying for you. Miss Kelly's mom. We'll leave it at that. No doxing. All right, you guys got your little pens out? Who's taking notes? I guess I'll just take them and you guys, I'll just screenshot them and put them up later. I rested my hand all night. I iced it. I was ready. I got a bunch of pens. You got to have a pen ready. I got the probable cause affidavit right here. I got every suppression motion right here, the objections, the replies, everything. So, ooh, sushi is my fave. Oh my God, we go there. Are you from Ohio? You live in Columbus? That's one of the best restaurants around. We go there. We're gonna be. Oh, you know who has the best soup though? I'll tell you what. If you guys know J. Alexander's. Their chicken pasta soup. Oh my God. I feel like I could I'm going to go get it just on Saturday just because I want it. That's all I order when I go there. I just can I get 4 of those? That's my meal. So I love soups. She heard it. Oh, yay. Miss Kelly's mom heard it. She's watching. Oh, I love it. That's awesome. She's a great woman. Great family. Can't say enough positive things. All the mods you know how many mods I have that are in the Boston area? I was like, geez, I didn't even know that. I wasn't picking all Boston people or something, but when I say in the area, just little tentacles all around. So Heather knows all about that free Karen Reed train. I cannot believe that they destroyed the video in the Karen Reed case. That's the breaking news, by the way, in the Karen Reed case. The breaking news is that the video, the inverted video, the Sallyport video, that video, they destroyed it. They destroyed evidence. Oh my God. Just when you thought why? Why? So of course, Karen Reed spent $13,000 to bring in an expert to go through this video and to see when it was altered. You can do a lot. Like people were saying with the bridge guy video. Spent $13,500 to bring in this expert and to do X, Y, and Z, lodge him, do all these things. gets to town. Don't know if it's a man or a woman, but this expert gets to town and come to find out, like, there is no, like, what? Oh, we destroyed that. We got rid of that. It was a huge, huge part of the case. Trial 1, Karen Reed 1.0. Can't believe it. Exactly, that fraudulent video. We want to put who inverted the video. Like, I'm sorry, but somebody inverted the video, and so somebody's going to come forward and claim that shit. That's how I would look at it. Your Honor, I'm going to call 700 people to the stand here until somebody says that they were the ones that inverted the video. Because once I go through the whole Norfolk County DA's office and the Canton Police Department, and anybody that was in possession of that video, and it comes back that all of these people say that they did not invert the video, well, then somebody is lying because it's inverted. Right? Right, Your Honor? So for judicial economy, how would you like this to happen? Should you just have a day here where I, call everybody to the stand and we just knock them off? But I want to know who inverted the video. Karen Reed has a right to know. She has a right to face her accusers. Who inverted that video in an attempt to persuade the jury? How is that not criminal? You motherfuckers are just, to even think that you're going to go ahead and do that. Like, how does Lally put forward the evidence? How is he not sanctioned? How does he still have his bar license? How is he not in cuffs? Because if we did that, if we try to frame somebody in the world, guess what happens? We get in trouble for that criminally. Here, the government can just do whatever they want while a trial is live and the world is watching, and we all catch it, and nothing happens. And then now they deleted and destroyed this video, which could ultimately prove where it came from, who did it, whatever questions this expert would want to know and had, right? So can you imagine Karen Reed spending out and forking out $13,500 to put up lodge and then send on over, here, we're going to come and we're going to view the evidence. If that's what you do, you go and you see the evidence. I mean, now, hopefully they had some of that money in escrow and you can just give it back. We got a retainer or something. I don't know. So court will begin soon, guys. This is the first time we've heard this. I believe that they are coming back in from lunch, and so the second half of the day would then begin the suppression. Detective Mowry wants us all to know that his palms are sweaty, knees weak, arms are heavy. There's vomit on his sweater already, mom spaghetti. He's nervous, but he's calm, and right? DV in the house, watch out, woman. And then here, we can't catch a break with a jury. Thank God Daniel Petty caught a break. Penny, he caught a break. His jury. Oh, this portion of the hearing is closed. Wait, what's going on here? They just now switched this. Maybe somebody hit the wrong button. They're back from lunch. Well, we're about to find out. Well, we'll see right here. You guys, how pissed off would you be if you're the family right now? Fuck it, we're just gonna call the courthouse. I have no shame in my game. We're gonna make sure that they know that their shit's all messed up. It's the 4th District Courthouse. Ada County, Idaho. Yeah, 200 West. Yeah, let's give them a call.
You have reached the Ada County Clerk's office. All calls are monitored for quality assurance. If needed, you may email questions to adacountyclerk@adacounty.id.gov. For information regarding courthouse access, please visit our website. Please listen carefully to the menu options as they have changed. For office hours, press 1. For citations, press 2. For misdemeanor felony cases, press 3. For civil matters, press 4. For cash bonds, press 5. If your taxes have been intercepted, please press 6. If you would like to hear these options again, press 9.
I just pressed 3.
You have reached the Ada County Clerk's office. All calls are monitored for quality assurance. If needed, you may email questions to adacountyclerk@adacounty.id.
What the fuck? Let's try it again.
Clerk's office. All calls are monitored for quality assurance. If needed, you may email questions to adacountyclerk@adacounty.id.gov. For information regarding courthouse access, please visit our website. Please listen carefully to the menu options as they have changed. For office hours, press 1. For citation, office hours are 8 a.m. to 5 p.m. Monday through Friday, excluding holidays.
They took the phones out.
County Clerk's office.
They think I'm playing?
Calls are monitored.
To research cases or pay online, go to mycourt.idaho.gov. To speak to a clerk, press 1. Return to... Please hold while your call is transferred.
Hi, yes, I'm just calling. I have a question. I don't know if maybe your computers are glitching, but it said that the live stream for the Bryan Kohberger case was going to be ready to start as this portion was going to be live broadcast. And then it just switched to this portion is closed now. So do you have any update on that?
Oh, I don't have anything to do with that. So let me transfer you up to our trial court administration's office and see if they'll be able to have any insight on that, okay?
Okay, thank you so much. I appreciate that.
Yeah, of course.
Okay.
You bet. Step by way transfer.
Thanks.
Thank you for contacting the trial court administration office for the 4th Judicial District. For case information or to pay a citation, press 1. For a video court link or to speak with someone in the court administrator's office, press 2. To request... Wait while I transfer your call. Thank you for calling the TCA office. Your time is very important to us. Please hold until the next representative can take your call. Thank you. Court administration?
Oh, hey, how you doing, court administrations? Just giving you a call here, trying to watch the Bryan Kohberger live hearing. Do you have any update here? Because I think your slides kind of got shuffled around. It said that you guys were coming on to live stream it, and then all of a sudden it said this portion of the hearing is now closed. So I didn't know if maybe there was like a glitch.
No glitch. So what that means is the hearing started again, but it's still sealed until the judge says it can be streamed.
Okay, and then so someone's just standing by, and as soon as he gives the okay, then you guys just click it on or something?
Yes.
Okay, cool. Sorry if I'm bothering you. I'm sure you're probably getting a million calls.
No problem. Yep. So it's been like that pretty much all day. So yeah, anytime when the judge will give the okay, that's when it'll start live streaming right away. But they just can't live stream anything that they're talking about currently in the hearing. So
Okay, cool. And then you'll put up another like slide once it's about to be coming on or something.
not necessarily. It'll just pop up.
Okay. So it could just come on and it could just be live.
Yes.
Okay, cool. Thank you so much. You've been very, very helpful. I appreciate you.
No problem.
Okay, have a good one.
Good one.
Okay.
Bye-bye.
Yeah. So there you guys go. It'll just pop up. It's just gonna pop up like a pop-up video. You guys remember those pop-up videos? You know, I was always taught in life, if you want an answer, you just ask questions and you go seek it. Oh, okay, right now. Yeah. Oh, the red one. Thank you. Let's see. You just want a Slim Jim?
Yeah, can I get this? I get that. I get guaranteed this and this.
Okay. Well, what is the damage? Were you a good boy?
Yeah.
Polite?
Yeah.
You want to say hi to anybody? You want to tell them a joke? You got any jokes in your joke book? You know any good jokes?
No.
No good jokes for today?
Nope.
Want to ring the bell? Go ahead. Here you go. I think I did it.
Thanks.
You're welcome. Did it work?
Yeah.
All right. We collect cards together. Got a nice little hobby going. He's the best human ever. His common sense is off. The kid won't be. He won't be walking himself into any problems. His common sense is there. So thank you for the kind words. So there you guys heard it. I called the courts. There is no glitch. They can just pop on any moment and oh, thank you, James. I appreciate that. We got our first we buy like the hobby boxes that are like way too much money. We got our first Neymar. That's a pristine edition. We were going nuts yesterday. Man, I have a coffee. Oh, I'm fine. I don't need a coffee. So I love pop-up videos. Pop-up videos. Breaking news. News alert. Pay attention. Oops. No news. No, we just went straight to the courts. So you guys could hear it right. Oh, pain would be 100% in there. I'm curious if the families truly, if they were like, okay, we'll give the families a link. You know what I mean? So. Oh, Janet, welcome. Oh, you didn't really miss much, Janet. So right now, guys, it's 1:23 there. And so this is going till 5. And so I feel like I'm just looking at a blank screen. And yeah. See, I don't think they were given one. I don't think they could afford to because they're the public, and that would be, I mean, I don't know. Are they a party to the case? So they get one? I don't know. I don't know. Oh, we gotta pick what I want as my little. Oh boy. Who's making pancakes and coffee? What time is it there? Let me make sure I get my. Oh shit balls. So yeah, Payne would definitely have been Payne's the guy that wrote the affidavit. So he would 100% be there and in part of for the Franks. Let's see. I just some of me doesn't want to like click off of this because based on what she said, it's not like they would change. Like they're just gonna they would just pop into it now. So I don't want to like. I have a bunch of slides ready to show you guys, but I'm nervous if I show you. If I switch off of this, then. The defense team stamping it though with their argument and saying that without IGG there is no case against Bryan Kohberger. So that was in a filing on January 21st. I read it earlier. So open the stream on my phone. I could do that. Yeah, okay, we'll do that. We'll be smarter. What time is it in Boise? In Boise, it is 1:27 p.m. So they go until 5. So then here's a video. Video file. Pop-up video.
We have tips coming in. We have investigators out every day interviewing people. We're still reviewing evidence. We're still looking at all aspects of this. And I said early on that no stone will go unturned. And I mean that. We are going to continue. This case is not going.
Sorry, hold on. I wanted to use this other one. My bad. Whoops. There you guys go. You guys are asking about Linda Lane. Here's some Linda Lane. Do you guys want to see Gray Hughes being chased out of Linda Lane by Kane?
Well, just trying to save gas. They downgraded us from patrol cars. Gotcha. They gave us hybrids to save on fuel.
I want to see that again. Yeah. Gray Hughes. Did you guys see Gray Hughes and Bob?
Lets me know that
Oh, hell.
Actually, sorry.
Gray pubes. What, Lana? Ridiculous. Absolutely ridiculous. You guys want to see him getting run out of town? You know what I do too. Okay, so here, this is the Linda Lane, Excel spreadsheet. And when you compare it to
description can be seen between 2:45 and 3:15 a.m.
the different things that were happening that night, where does it fall on the master Excel spreadsheet?
Away from the crime scene on King Road. Video shows the vehicle traveling toward the crime scene. Later, Hall claims a similar vehicle can be seen on body camera video of an unrelated underage drinking bust. Hall pinpoints the car driving by at 2:58 a.m. and uses a digital overlay to place a Hyundai Elantra on top of the vehicle. Law and Crime took it a step further and superimposed the photo of a white car believed to be the Elantra that was caught on security camera by a local gas station that same night. It's important to note the vehicle has not been confirmed to be a Hyundai Elantra, and some believe the car appears to be a white Tesla. Later on, at 3:12 a.m., body camera video picks up what appears to be 4 people running under a street lamp in the background, and less than a minute later, a high-pitched noise. Some online detectives believe this sound to be a scream, while others say it could be tires screeching. The timestamp on this noise is important to note, as investigators believe the victims were killed between 3 and 4 a.m. on November 13th.
We start to identify patterns, and like we said earlier, we are confident that the occupant or occupants of that vehicle have information that's critical to this investigation. We also understand that even though there's sometimes a fascination with a particular case, some people simply don't see the news and may not know that we're looking for it. So if we get the word out there, hey, maybe your neighbor has one in the garage that they don't drive very often. Maybe there's one that's just not on the registration database, let us know. So far, we have a list of approximately 22,000 registered white Hyundai Elantras that fit into our criteria that we're sorting through. That's an awful lot of information.
How many of those 22,000 people have bushy eyebrows?
But it may not be all of them. So the public.
Oh, multiple voices.
No, I don't.
You guys haven't been drinking?
You guys haven't been drinking
or anything, right?
No.
Okay, drive careful.
It is 1:33 in Boise. Yes, it is.
You guys want to leave the door open for us? That way we can get some sort of communication between us and them.
No one lives here right now. So
no. Yeah, okay, thank you.
Yeah. Live across the street. I just came over. I haven't drank a drop. Male, female. I think it's like
That's going on.
I don't know if they're.
I don't.
So I guarantee they're associated with the store. Many of them are living here. It's not campus store.
So what I did with this is I was trying to compare when listening to this video what type of background noises, we heard. And then comparing it then to Linda Lane when I was typing up things to add on to this.
I've been a cop for 22 years here. I'm not stupid. Don't play young games with me. I'd rather deal with this as a noise complaint than getting a hold of the Greek Council and the Greek Board and all of that.
And the big thing that I saw is there's a bunch of flashlights, and if they don't want to call them flashlights, I think they're flashlights. I don't think they're bugs. You guys, it's November. Bugs, fucking bugs. No, there's these little flashlights. I think they're flashlights.
Exactly.
Aww.
Street views.
I
White
need to be
Claws?
sponsored by Truly's.
Nice. I hate when I leave my White Claws. Oh, they're cold too, man.
Yeah, these are cold.
So then the other thing I was thinking of it when I was making this video, when we turned over here and we saw these lights on from the house next door, is would they have it in their cloud space that if the iCloud held 6 months worth of shit, I want to hear what type of sounds are made and that you can hear from those videos back when these noise complaints were happening, the cops were out there, and what you're seeing, and is anything similar, because all these cops have flashlights. Cops have flashlights. Phones have flashlights. Yeah, I mean, and Bryan didn't have either one of them on him that night,
Oh my God. An open one. Hello.
You do that? Learned that from a college kid.
Yep. All right, Josh. With Jordan, you talk to them.
Yep.
Maddie.
Okay. Hi, this is Dr. Walkman. Please tell me. Who am I speaking with? Maddie, 1 second. Turn the volume up on this phone here. It's okay.
I don't assume that's Gatorade.
But it could be, though. Maybe take a test. And how do you spell it, Maddie?
I don't know. You can leave it there. So I take you guys are Sigma guys?
I'm a Sigma.
I was in the house, but I'm not.
Why? Why?
Graduated.
Oh, there you go.
I will graduated with a bachelor's. I'm still getting my master's right now. So.
But you get a master's.
All right, Madison.
Like
So here's the deal. Okay.
I actually got a kid
They've
of mine
already
who
said that
started
no
in
one
that
here
program.
lives
Really?
like cash. Yes, ma'am. Okay, you enjoy your evening, all right?
All right.
It's Halo time.
It's Halo time. It's Halo time. That kid is so dumb. And he's whoever the
Our detective
tribal.
sergeant goes, talks to all their bosses, and pulls all their records. It's crazy because it's such a high liability. Like if you hire someone who's got a bad record and you don't find it, you're stuck with them. So it's a work. Like we send people to where they live. Yeah, so we like to get them to this point, just to get them hired. It's a pretty substantial they do a full background check, tons of interviews. We go to all their previous places of work. Like we send people to where they live. So just to get to where you're hired is a big deal. And then
Whoever is not in it here is keeping it down to.
no.
Okay. So at this point, we're going to leave. Okay. And again, if I have to come back later tonight, like I said, I just want to express that there's some citation given out. Okay. Yes, ma'am. Okay, you enjoy your evening, all right?
During the course of the last several months, there has been a lot of discovery that's been requested and a lot of charge.
Yeah, so we like to get them to this point, just to get them hired. It's a pretty substantial they do a full background check.
I would not want to
Go
stand here and
to all their previous places of work. Like we send people to where they live. So just to get to where you're hired is a big deal. And then it's 4 phases, 4 weeks each. They get progressively more burden put on them to do the job on their own.
These 3 officers are officers that have each conducted critical interviews with critical witnesses in the case, made decisions about the interviews, made decisions about evidence, and conducted other kinds of investigations.
Talks to all their bosses.
We seek their training records to understand their process.
Oops, hold on 1 second. I'm gonna pull up and play good old Gray Hughes Run Away. I need something to laugh about. Okay, here we go. Enjoy this with me. I've already talked about my, people try to swat me down there. Here you go.
Moss 106 traffic.
So we're messing me going a little too fast. Hold on a second. Hold on a second. Just a second.
Yeah, with an obstructed plate.
Obstructed plate? Oh, hell.
Oh, shit. Where do I go?
Let's go in. Chris with the Moscow Police Department.
Oh, hi.
The reason I'm stopping you today, you're doing 36 coming up that hill. It's 25 miles an hour.
Oh, I apologize. I'm from out of town. I was trying to do a live stream and I'm talking.
I got you. You just talking randomly? Or?
No, I'm online. We're doing a live stream. I turned off the mic now.
Okay, cool. You have your driver's license, registration, proof of insurance on you?
It should all be in there. Right?
Where are you guys coming from?
Oregon.
Oregon?
I'm actually, I'm here filming because they're going to be just taking down that house.
Uh-huh. Your current address? Yeah. What's a good phone number for you?
Hopefully it just gives me a warning.
Issuing a citation today, kid. You're going 11 over. Okay?
Oh, yeah.
Sound good? Have any questions?
Well, it doesn't sound good, but I get it.
Yeah.
It's like,
if you have any questions on how to take care of it, you can take care of it in person on the internet. I think there's a phone option as well, okay? Sound good? All right.
Sound good? No, I mean, it doesn't sound good, but I mean, yay!
Yep. I'm safe rest of your day.
He just tells Moscow police, I was just doing a live broadcast here. I wish it would have been in the same spot that Ian Harsh got pulled over at. You want to pet my cat? You guys remember that, right? God, where is Enon? I need to call him. Enon, were you summoned to this thing? Are you a witness? Are you a witness? Oh, God. Then, there's been a lot of things happen to people that go, why don't we have these things happen to like Ashley Banfield or, I don't know, Nancy Grace. I mean, God bless America. I mean, jeez. Then here's another one. So here's this other one. Then you got Jonathan Lee Riches. JLR investigates. He was, man arrested. All right. This is a classic right here.
Lee Riches Investigates. I am covering the Moscow, Idaho. Jonathan Lee Riches Investigates. I am covering the Moscow, Idaho Bryan Kohberger case. As some of you might or might not know, there was a man that got arrested outside the Moscow, Idaho home last week. There was an incident where a man threatened me. A man threatened me outside the home. I was in the area working on a documentary covering the case. It was after I met the Gonzalez family, and I want to share what this man did, and then we will further discuss. Again, this is for educational purposes. Only say no to violence. Do not support any violence or threats whatsoever. So
Ready, guys?
Right.
I'm sorry, but I died. Because this dude, okay, look at. You guys, he pulls his car to block JLR. You see this? Block him so he can't leave. That's the only way out of there. It's the only way out of there. Look at this man.
How's it going? How's it going?
I see your fucking face here again. I'm gonna fuck you up, okay? I'm gonna give you a fucking fair warning. I don't like your fucking YouTube. You're making this fucking place look like a fucking clown. I'm gonna give you a fucking fair warning. Maybe you should call the cops and let them know about me, because I'm gonna give you one fucking fair warning. If you don't think I'm fucking true, I'll drag you out of the car right now. Leave this fucking place and don't come back. You understand? I'll pull away so you can get the fuck out of here. I see you in fucking town today. Anywhere, I'm gonna fucking get you. Have a fucking good day, motherfucker.
Have a good day, mother. The guys, the house is right there. You gotta zooms in on his fucking. He's like, yeah, I got you, motherfucker. Yeah, Jonathan, get him. You guys, unbelievable. Unbelievable. Right outside the house. It's not over.
Have a fucking good day, motherfucker.
Have a good one. He's like, I'm going to get my video of the house. Now this guy pulls up.
Fucking playing with you, huh? Huh? You think I'm fucking playing with you, huh? You think I'm fucking playing with you, huh, motherfucker?
What a psycho.
Your mom told me I'm gonna come for you. Dude, you have no respect for this fucking place. You're just a piece of shit YouTube motherfucker. Get the fuck out of here. How long do you think you're gonna last right now? I'm gonna make history over your fucking face, and when I do, I'm gonna smash it really fucking bad. Get the fuck out of here.
So that man, he has been identified as Kirk Adams, pulled out his car to block me because he didn't want me in the area. I don't know why, and came up and made serious threats towards me. And, you know, I just stayed quiet the entire time. Now, as soon as I left the scene, I did the responsible thing and I called 911 to report this guy. One, because he said he was going to do bodily harm on me if he sees me anywhere in Moscow, not just there. So 911 got called and officers arrived on the scene. I shared the video with the officers, and this is what happened.
I can't, you guys. I just can't. I'm like, what is going on? This is the United States. Yep, this is Idaho4 though. I'm gonna get you. He's requesting that we arrest you. He went without incident. No report taken. Yeah, they arrested him. They definitely arrested his ass. I have more video of he was circling the courthouse. It was crazy. There's more shit I have on Kirky boy. I put it out. I mean, to go through like all these videos I have is just so much. And then this is, so he gets this guy's whole arrest, okay? So then he's there to video record him getting arrested, right? And I'm like,
he got arrested. Guess he's charged. I don't know, but he's on the docket now.
I guess he's charged. I don't know. He's on the docket now. Megan Marshall.
Actually charged him, I think, with assault or threatening.
What?
You know, whether you agree with someone or not, that's unacceptable. That guy actually has a history, a recent history, criminal history in Moscow, numerous charges of disturbing the peace. He has recent harassment charges, and I've spoken to others in the area, and he causes problems in the Moscow, Idaho area. He drives around in a white SUV with a bunch of flags all over and drives around Moscow. Other people I've known that have been around the Moscow, Idaho home, filming and documenting. He gets very hostile towards people and yells and, tries to kick people out of the area despite it being a public street. It's not his property. There's no interest whatsoever in that Moscow, Idaho home. He just doesn't like YouTubers and people filming. But, there's consequences. You just can't threaten people. I don't know what's going to happen with this. I am a victim now. I don't know if eventually they'll just cite him or
cite him. What ended up happening?
What the situation is, but I wanted to share what was going on.
I'm gonna have to do a fucking FOIA request. I need to know the case number. Let's see. Let me get that case number right there. Incident right there. CR29. Let me just write this down. Oh, sweetness. Hold on. We're gonna get an update on this. CR 2923-1759. Let's get an update on that, on what's going on with that. We like to just keep everybody informed. Thank you.
I think I handled it well. I want to thank the Moscow, Idaho police for being very.
I think I handled it well. Absolutely, JLR. I love JLR. I don't care what anybody says. We are on the opposite sides of obviously the Karen Reed case. I think he's come back on the side of the right side for Richard Allen. But it's here it is again. I just want to show you guys this part. This guy knows he's coming down this hill. The only way he can get out, he parks his vehicle and blocks
Leave this fucking place and don't come back.
How's it going? How's it going?
I see your fucking face here again. I'm gonna fuck you up, okay? I'm gonna give you a fucking fair warning. I don't like your fucking YouTube. You're making this fucking place like a fucking clown. I'm gonna give you a fucking.
Do you know what I would have said if somebody would have rolled up to me and said, "I'm gonna fuck you up"? I would have been like, "Pow pow, bang bang." From the Karen Reed case, I'm gonna fuck you up. You're gonna what? I would have been. You're gonna fuck me up, huh? Okay. Like, do you think he would have said that to a girl? I don't know. But I'll be damned if someone's going to come up to me and say, I'm going to fuck you up. Okay. I'm gonna fuck you up, face down, ass up, motherfucker. How about that?
Fair warning. Maybe you should call the cops and let them know about me because I'm going to give you one.
Maybe you should call the cops and let me know about me.
Yeah. Leave this fucking place and don't come back. You understand?
JLR, with all the patience in the world, give him a patience award right there, okay? But I'm gonna fuck you up. Wow. See, he is rehabilitated, guys. See, JLR wasn't gonna fight him. He doesn't believe in violence. Like I said.
Understand? I'll pull away.
I like JLR.
Get the fuck out of here. I see you fucking around today. Anyway, I'm gonna fucking get you.
I can't. I would have had something to say to him. He zooms in on the license plate. I love it. I'm like, get ya. And then just when you thought it was over, this shit happens.
Have a fucking good day, motherfucker. You think I'm really fucking playing with you, huh? Huh? You think I'm fucking playing with you, huh? You think I'm fucking playing with you, huh, motherfucker? Your mom told me I'm gonna come for you. Dude, you have no respect for this fucking place. You're just a piece of shit YouTube motherfucker. Get the fuck out of here. How long do you think you're gonna last right now? I'm gonna make history over your fucking face, and when I do, I'm gonna smash you really fucking bad. Get the fuck out of here.
Wow.
So that man has been identified as Kirk Adams.
So that man has been identified. Anyways, gotta love it. Cheers, JLR. All right, it is 2:00 in Boise. 2:00 in Idaho, still hiding shit. 2 p.m. They've been hiding shit for 5 hours now. Even their lunch breaks are hidden. 2 p.m. in Boise. We go until 5. We ride until midnight. We ride until dusk. So it's 2 p.m. in Boise. Oh, 1:59. Solid. Way to go, Idaho. Fucking gems. Bunch of pussies. Whoops, was that a mic slip? Fuck no, it wasn't. That wasn't a mic slip. That's real raw dog shit right there. Oh no, Kirk just brings it out in me. I'll tell you what though. That motherfucker didn't come up to me and say he's gonna, what did he say? I'm gonna fuck you up. The fuck you what? Excuse me? I'm sorry, excuse me? Oh, how many people would have handled it like JLR though? Be honest. He was rehabilitated, guys. There's no way no one's gonna tell me that they're gonna fuck me up. Then I'm just gonna be like, no way. I'm gonna say, why'd you do it, Kirk? Let's see. We got an update on JLR situation though. Let's see. Breaking news. JLR oh. Murky, can you take a screenshot of that? I don't want to go through that whole portal. That portal can kiss my ass. I've seen that portal so many damn times. Idaho State Police hit me back because I just put a request in a couple days ago. Your request is going to take a couple extra days. I said, I bet it is. The shit I asked for is just out of this world. They're probably wondering why I asked for it. All right, let's get off of this. Other things at JLR, because, he was in Moscow. He was really big into, he was all over JLR, was all about, Sigma Chi, what the hell y'all doing over there?
That is interesting. That gets you a clear path from here, from this university. This probably could be for the residents that live over there to have access to the band field.
So here's JLR.
So this is the area right over there where 4 college students were brutally stabbed inside a home during the early morning hours of November 13th, 2022, around Sigma Chi, where...
So he was walking all over. Like, he started here at Sigma, and then he started walking. And where I want to show you. There we go.
See down in that field, there's lots of footprints. So people do cross over this field to get to locations. You can see footprints.
You can see footprints. I love it.
So it's a hill. Maybe they went sledding. Maybe somebody went sledding. They definitely sled down that hill.
They did go sledding.
All right, so you can park on this road. You can park on the left side, and you can park on the right side.
JLR was running a parallel investigation.
This is the...
So we get to, here. Look at this.
Right there. You can actually see the numbers. 1, 1, 2.
So here he's like in it, like,
You can see the house. Right there. You can actually see the numbers. 1, 1, 2, 2. From here. These vehicles are here, assuming they are Sigma Chi members.
Thank you.
See, so this is the Sigma Chi fraternity. This is where one of the victims, Ethan Chapin, went to. Xana was there for a party. The door's open.
The door's open. Go in, JLR. Come on. Oh, I would have went in. I would have totally went in.
I'm here.
I'm here. I love you, JLR. JLR.
They have
Why'd you do it?
EX. A lot of people are saying symbolism with Ethan and Xana. Sigma Chi. Actually have a, it's like a keypad to get in. Doesn't look like no one's there. And the president said there was no cameras. The president said there was no cameras. So we're going to keep moving. We're going to go to the next fraternity house to just show you all the fraternity. And then I'm going to go a little bit beyond that.
Beyond
to
it.
show you the... This looks like the fraternity of Alpha Gamma Rio. Alpha Gamma Rio. What does it say? ARP. We have the sign that says Vandal Strong.
Oh, shit. It's not open for me, Mercs.
All right, so there's 4 main fraternity houses on this road here. Actually 5 at the corner to get to the neighborhoods that meet here, right down, and there's Sigma Chi there. This place, I don't think so. They might do it. Towns east of here, 25 miles.
All right. Thank you, JLR. We love you. We appreciate your work. Moving along to, here is another one of my favorites. Not sure if you guys let's see, where is remember this. Okay. This is by far one of my top five JLR moments in Idaho4 history. And here it is.
I want to talk about Dylan Mortensen, right? So Dylan Mortensen, she's a mystery to me. And I'm sure she's a lot of mystery to all of you out there. Because I think she has key information out there that can blow this thing wide open, give great perspective, right? So early on, the police have said the two roommates, which is Dylan Mortensen and Bethany F., they are not involved. They're not involved. And I was dumbfounded a little bit by that because they were able to determine that very, very quickly. Considering that, you know, these stabbings occurred 4 a.m. and then we're hearing that the 911 call first came in at 11:58 a.m. So that's like a big, big gap.
Are you ready?
It's like an 8-hour gap. And supposedly Dylan and the other roommate, Bethany,
we'll check in and see if the portion has begun. The public portion of the hearing will begin shortly. Here we go. So if Hitler thinks he's going to troll me, I was prepared for your shit, Hitler. There you go. I was prepared to be bringing nothing but the content for fucking 9 hours if I had to. So here they said that this is ready. But you guys, in this JLR episode, which we'll go to, he shows Dylan Mortensen's messages with her and her dad. And he's like, this guy's a complete psycho. Oh, shit. Lana, when are those Is That Right t-shirts going to be on sale? Is that right? You know. So here, it's starting here shortly, guys. But we aren't going anywhere. Thank you. But since we're not going anywhere, you guys, I want you to see this part about Dylan, about her dad. Here it is. I'm sorry, but I just was like, this is priceless material. You can't get this anywhere else. JLR talking about Dylan's dad. And
questioning Dylan.
And here's why.
Even almost 3 hours later.
You know, so he's just talking about it, and then he's like, here.
Comes from. And then we will discuss. So Dylan Mortensen, one of the surviving roommates, she has a social media account and she has made posts.
The dad, just a further reminder of who is going to show up at the boys' door who messes with one of my daughters. 241 pounds of beef.
And she posted this text from her father. Comes from dad. Just a friendly reminder of with her dad.
Hi, Dylan. I probably said this before, but I'm saying it again. I want you to know that I would do anything for you and your sisters. You are an amazing daughter, and I am the luckiest dad in the world. I love you so much. There is nothing more important to me than you and your sisters. I will never let someone come between us again. I want you to know how loved you are, how blessed I am to have you in my life. I want you to have the best life possible. If you ever need anything, you let me know. A ride home, clothes, me to be at an event, get you out of trouble. Get you out of trouble. Food or just a hug.
On her social media account came from dad.
I am just a phone call away.
I've probably said this before. But
I will drop whatever I am doing to help you. Love, Dad. Okay. Now here's when after he reads that. You might not remember this day, or trip. It was a lot of fun. We used to travel a lot. We're going to start doing that again. I love you girls more than anyone or anything. Daddy's back, baby. Okay?
It seems like a guy that generally loves his daughter. But who is he? Who is Dylan's father? It's a big dude. And you see the kind of the joke, don't mess with my daughter, dudes, or you'll see me. And he's flexing, big dude and stuff like that. He's a big dude, But was he what I'm saying is was he talked to? Was he talked to by authorities? Was he ever at that house? Because if you see something, the last one I showed you, it seems like he's just getting back into her life. Well, where was he? Where was he? So who is the father? Who is Dylan's mother? I want to know more information about Dylan because, she could share with all of us where Murphy was that night. She can share every chain of event of what happened.
She's hammered.
People don't know, really, what time she got up and what she did, her and Bethany.
Look at that cock behind him. Is that a rooster?
What they did before they went upstairs
It
to
is.
find the bodies. And if this neighbor's saying...
Okay, anyways, you guys can go check it out yourselves. But do you remember these back in the day? I'm telling you. JLR investigates. Nothing but the hits. Nothing but the motherfucking hits. So let's go back to we are ready to begin. We're here with you guys. We are come on, baby. I came here for the facts. I came here for the facts, and I'll leave with a little bit of a chuckle every now and again. So was that a goose? I think it's a cock. So what do we got going on here? Is there a problem? The public portion of the hearing will begin shortly. So we think because there was there's probably here they take a recess, Tell me where Murphy was now. Last I checked, JLR was all in on Bryan Kohberger, why'd you do it? Just like Karen Reed, why'd you do it? Just like Richard Allen, why'd you do it? Well, everybody that JLR has been all in on doing it has turned to be innocent. So maybe JLR goes 3 for 3 here. He went to Delphi, Richard Allen, why'd you do it? Karen Reed, why'd you do it? And all that's coming out is these people are innocent. And so here he did it to JLR. And so, or JLR did it to Bryan. And so I'm thinking, man, JLR is just 0 for fucking 2. Let's make it 0 for 3, But I love JLR. I'm telling you. And clearly people do love him because when he first came out, he had, no subscribers. Now he has 360,000 subscribers. And I think I give him a couple bucks a month. I think I remember. I don't know if I earned it or if I bought it. I can't remember. But I supported him back in the beginning. And still to this day, because he's boots on the ground. He puts in the work. He goes places. You know what I'm saying? He's not just, and you could, like I said, you don't have to agree, but he's at least trying to go get us information. And then take the information, and if he puts a type of spin on it, well, spin it however you want in your head that you like it, whatever you take from it. But he's going and getting information. He would basically sacrifice himself. I thought the guy was going to die in the hurricane. Shit. So like I said, it's not about for me. I don't care about your opinion. Okay. I care about your work ethic. I care about you as a human. And if I could fuck with you on that type of a level. So yeah. Lawyer Lee, Andrea, I could totally fuck with them. Good ass people. Bob, good person. Even if I don't know you, I have no comment on you because I don't know you. Oh, thank you. Unique for sure. We love Unique. Yeah. Love JLR's raps. I've never seen JLR's rap video. You know what? I need to watch it. I have not watched it. See how it has her opinion there, and I love her, and she thinks differently. It doesn't mean like that I think differently of Hella. Everybody has their own opinions. But come on, the public portion of the hearing will begin shortly. Watch this. If they switch the card back, I'm gonna call back again. I'm gonna say, I think there's a glitch in your system. No, there's not. Thank you, Berkey. I'll check it out. There you go. Put that on a shirt. Me again. Thank you, Heather. I got your message too. I got messages coming from all over. Emails, texts. So there's rumors that this won't be public until tomorrow. I have no idea. Not Ian Harsh interview. That's a good one. I don't know why so many people got offended by that interview. That interview fucking rocks. They got the guy to fucking twirl his baton. Whatever you call it. How long is shortly? In Idaho, they don't understand the concept of timeline, so probably a long time. Not been here for a few weeks. Lots of new names. Yeah, we love it like that. All are welcome. I think the best thing about Ian Harsh was Bella snagged these videos. She's like, hey, I think Ian Harsh was arrested. I think there's some body cam out there. He said, oh, really? And she's like, I'm going to get it. She goes and gets these videos, and we were listening to this, and she's like, what the fuck? And she's like, what do you think about that interview? I was like, what the hell is this about? And she's like, what do you think about that cat comment? You want to come pet my cat? He's hitting on the cop. He's just dead. I was like, wow. I was like, because we didn't know him at the time, and I was like, is he being funny, or is that like, is he being serious? He's being dead serious. Like, do you want to come pet my cat? You want to come over and pet my cat? What? Yeah, that should have got him handcuffed. You know what I mean? He knew her, though. He knew her from school. So. People thought I was throwing Ian Harsh softball questions. I'm like, what do you want me to ask him? Hey, did you kill the 4 kids? Did you kill the 4 kids? What is he going to say? No. Just like when Nick McClellan got asked the question the other day from that fucking bimbo, Kendall, horrible. She asked him, do you think Richard Allen got a fair trial? What do you think he's going to say, Kendall? No. Dead. That's a softball. What kind of answer are you expecting? Why did you even ask that? You know, but Ian Harsh would laugh to ask him, hey, did you kill the 4 students? What? Kill them? You know what I mean? Like, hey, Ian, did you kill those 4 kids? My neighbors? Yeah, you know. So it was like watching the other day when we were watching the interview with Nick McClellan, and fucking Kendall asks, so do you think that Richard Allen got a fair trial? to the prosecutor. I don't know, Kendall, what did you think he was going to say? Caitlin Kendall? What a name, KK. All those KKs, look the fuck out for them. Wow, bitches. Mm-hmm. Mm-hmm. Yeah. And you guys, that was a line cutter. She cut and literally think about you sitting outside and waiting to get in there. And that good for nothing cut. And literally, I mean, we all got in, but there was a girl that didn't get in and who should have gotten in. And she took their spot. And I'm like, I love it because then here comes the defense and drops the motion. And I'm like, how'd that age well for you, girl? Yeah. She should have marched her fucking pretty little ass right the fuck back over there. Hey, Nick, we just got these motions. Can I interview you? That's what Baldwin is talking about when he's like, where's the true journalist? The people that ask the hard questions, the people that say, hey, why don't you turn over the discovery on time? Why did you wait 4 weeks, 4 months, however long it was? Why doesn't Kendall text her boy and say, hey, I'm coming back through because we have a lot more to talk about. And I want to at least be able to come out and say, we contacted the prosecutor's office and asked them for comment, and they said they have no comment. You know what I mean? You know, it's just, but that's that line cutter. And she was biased as fuck. You would have thought she was there for a fucking job interview. So whatever. But I felt bad because there was the person that should have gotten in instead of her didn't, right? And it's like, who the fuck do you think you are? And I think she took a lot of heat for it, and she should have. So kudos to all you people that, you know, are watching my live when I showed all that. And oh my God, we're here!
Are we ready to go live? All right, go ahead. Let me know when we're ready, Sandra. All right. We are back on the record in State v. Kohberger, CR 0124316665. We are now, I believe, streaming for the record. The defendant is present together with counsel, Ms. Taylor and Ms. Massoff. The state is present and represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. We are now going to hear argument from the parties on the Franks motions filed by the defense. That will include the Franks hearing that was held on the IGG issue, as well as the defense's proffer as to the rest of the Franks issues as to why the court should hold a hearing on those matters. We're holding an evidentiary hearing on those matters. Am I missing something we talked about?
Your Honor, I may have missed it, but I thought we were offering argument on suppression IGG.
Well, the suppression IGG, we can also argue that. I think it's wrapped up in the same issue. I thought we were going to Franks next.
I did not. I apologize.
No preference over here, Your Honor.
Well, do you want to argue suppression on IGG and then we can do the Franks? That's fine.
I would need 5 minutes to get my Franks items ready.
Let's do argument on the suppression of the IGG related matters, and then we can then hear the Frank stuff. That's fine. If that's what you're prepared to argue.
Thank you.
Go ahead.
Your Honor, our position is that the court should suppress the IGG identification and everything that flows from that. This is supported by Fourth Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required, none was given, and so this must be suppressed. Your Honor, I'd like to identify the 3 stages, and they are when Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample to Othram Laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pull in Pennsylvania, and there was no warrant for that trash pull either. All 3 of those stages of this case, there should have been a warrant and there wasn't, and this must be suppressed. Your Honor, for the purposes of the Fourth Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any to the contrary that say that's not the case. Your Honor, this is a situation where this identification was done in complete secret behind closed doors, and it's been continued to be a secret. And that should raise red flags for Your Honor about privacy interests that are at stake. The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search, and from there they did things that we have no idea what it is. That entire segment of this case is secret. We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist. We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not through the motion to compel process. This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a SNP to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know how. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Kohberger's DNA sample was uploaded into any of those databases, that his was, like, for example, his own DNA was one that was matched from the crime scene. Not asking whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Well, Your Honor, I don't have the JED.com file. I don't have,
You're not asserting that fact, correct?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases, because as the state has posited, that wasn't his DNA that was searched. At best, it was his ancestors.
Well, Your Honor, I am not sure why we're here if the state hasn't alleged that Bryan Kohberger's DNA was on the knife.
No, I'm not talking about the knife sheath DNA. I'm talking about what they tried to match it to.
Your Honor, I would answer it this way. The way that those databases work is looking for shared DNA. Those databases don't churn out a name and say this
I
is
have
your
a
suspect.
privacy interest against any of my relatives that might want to upload their DNA to one of those systems. I should be able to stop them from doing that because I share some DNA with them.
That's not the argument.
That is certainly not what I'm saying. What I am saying, Your Honor,
Thank you.
is if somebody takes your DNA and uploads it, I think you have a privacy interest in your own DNA.
But not necessarily in, let's say my DNA is taken lawfully. What privacy interest do I have in the search of the DNA of others?
That's a loaded question.
Why is it a loaded question? Isn't it a factual question?
Well, it is, Judge, but you're assuming that the DNA was taken lawfully, and our position.
I agree that part is an assumption. In my hypothetical, I said my DNA was taken lawfully. Why would I have standing to object to the search of other people's DNA simply because I might share some genetic information with them because they are distantly related to me?
That's not the argument.
Our position is that this work was not done lawfully, that it was unlawful, that there needed to be a warrant, that this was done outside of a warrant. And I'm not asserting on behalf of anybody else in this, any relative, anybody who might have been named or not named. This is about an identification process. It needed to be a lawful process. It wasn't a lawful process. It was in violation of Mr. Kohberger's rights. I don't know how he cannot.
How was it in violation of his
accused.
rights?
Excuse me?
How was it in violation of his rights?
Well, Your Honor, he's been in custody
You're
for
saying
2
that
years.
I understand your position, which frankly is not well supported in the law, that if hypothetically here, he went to this crime scene, committed these murders, and left DNA on a piece of evidence, that he now has the ability to object to that evidence being searched for identification purposes. There's no case that suggests that concludes that. And it seems to me to be an extreme position to take in light of the case law. And I'm trying to understand how you get there.
Well, I think Your Honor is asking me about things that I anticipated the state would argue, their abandonment theory. And I would remind the court that the Ross case said that abandonment is a knowing intentional leaving of something, for one thing. For the other thing, I think that the court is asking me to take a position where it feels like burden shifting to me.
No, I'm trying to understand the legal argument and how this is different from example from latent fingerprints.
Well, Your Honor, I think that things like latent fingerprints and like CODIS, there's statutes about CODIS in Idaho, about what's allowed in CODIS. This is a different search. This isn't an STR search. That's what happens in CODIS. This is a different search.
So I'm going now to, I'm sorry, the constitutionality of using the DNA that was allegedly on the knife sheath. And because I understand your argument is twofold. One, your client complains that a search was done of databases of other people to determine whether or not any of them might be related to the person who left the DNA on the knife sheath. That's thing one. Thing two is an objection to the law
He's
enforcement
arguing the state's case.
searching the DNA by testing it and getting a profile from the knife sheath without a warrant. My question goes to that latter point, understanding the basis for that, because I can't find any case law that would support that idea. That somehow a warrant would be needed for DNA left at a crime scene.
Well, I think in our briefing, Your Honor, that we cited the court to some cases.
I did, I think, one concurring opinion in a case that held otherwise.
Your Honor, I was going to talk to the court about third-party data, and I was going to talk to the court about the Davis case that talked about something that the police lawfully had and a subsequent test, the Skinner case, when there's something that's lawfully held, but there's a subsequent test. So those are the things that I want to talk about. Okay. Our first point is it was an illegal search. And this is if
the search,
the
which search?
Assumption.
Which search? It was illegal.
Well, first the snip at Att Warrant, then the snip at the FBI, and then the trash pool.
So you're talking about the DNA testing of the material left allegedly on the knife sheath.
I'm talking about the Idaho State Police Forensics Lab taking a piece of evidence given to them by Moscow Police Department, collected at the scene, developing a STR profile, uploading it into CODIS, and I think that's the King case that says that's fine. I know Idaho has statutes on CODIS, uploading it there and producing nothing. There are no results there. I'm talking about the next set of moves that are super secret that happen when there's a portion of the DNA taken and it's searched by Att Warrant to create a snip. And then when that doesn't produce anything, the FBI says, okay, here we go. Let's search the snip ourselves. That's what I'm talking about. Those are the problems. As far as asserting family
specific DNA tests done of the sample.
How does the sample double, you motherfucker?
Legitimate to illegitimate?
Yes, Your Honor, I think the Davis case is on point. If the court's theory that this is a lawful piece of evidence taken from the crime scene, the sheath.
Not my theory. I'm just trying to understand your position in light of the case law and in light of the state's arguments. I'm trying to find where the gristle is in this.
I'm adopting the court's hypothesis for this purpose, that the knife sheath was taken. I'm adopting it only for that purpose. And I'm relying on the Davis case that says subsequent searches need a warrant.
And remind me, Davis was the cell phone?
No, Davis was not the cell phone. Davis was blood, a sample with blood. The cell phone case is
Give me the
Carpenter.
site to that.
I'm sorry?
Can you give me the site to the Davis case?
I can. Give me 2 seconds. 2 seconds and glasses.
So the snip with Ortham did not produce anything. Then somehow the snip size doubled when FBI got it. The sample size. So Ortham tried.
My memory tends to be fact-based and not name-based, and so that's my liability.
Well, it's going to take me just a second. I apologize. I apologize. I wrote the name down, but not the site in my notes, but I know it's cited in our briefing. I can't remember what page. It is 690 F 3rd 226.
That's the Davis case.
All right.
Davis.
And so those are the 3 areas that we believe that there should have been a search warrant and there wasn't. There is an expectation of privacy in one's DNA that society is willing to recognize. And I think I'd talked to the court a little bit about the things that happened in this case that were super secret. I think we'd gotten to the point where we were talking, and this goes to recognizing an expectation of privacy when there's all of this secrecy surrounding it. We had gotten to the FBI where the SNP profile was twice as big as that from Othram. And then the FBI went into databases that violate the Department of Justice interim policy. You heard a lot about that Department of Justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. It says that they're not to go into databases that aren't allowed. And they did that. The court has that in another exhibit.
How's that a constitutional violation?
Your Honor, it goes to privacy.
Don't suppress for contractual violations or even statutory violations.
I'm not suggesting that we do that. I'm suggesting that that's information that's pertinent to this court in making a very important decision as to whether somebody's Fourth Amendment rights were violated, as well as Article 1, Section 17 of the Idaho Constitution. The purpose of offering that information is because there's a policy, so there's there's a recognized expectation of privacy in what's contained in a SNP at all. There has to be a warrant to search these types of things, and there wasn't. There would be no need to have any policy if nobody cared about this. The court heard about the different IGG databases that changed their rules in terms of use after a different case used IGG to solve it because people don't expect to have their DNA searched.
That was the point of my question about whether or not Mr. Kohberger's DNA was in any of those databases. In other words, did he submit his DNA and said, I don't want law enforcement to look at it?
Your Honor, I don't think that that's the way the question should be looked at. I think the question should be looked at in the way that we always look at warrantless searches.
Got to be a standing.
Your Honor, we're here because the state has alleged that a single piece of evidence ties Mr. Kohberger to this case. They've alleged that there's a knife sheath that has DNA that they allege matches Bryan Kohberger. He's now been incarcerated for 2 years, facing capital murder. I'm not sure, unless we're shifting the burden to me, what else I can say.
Well, you have a burden of showing that the items ought to be suppressed.
This is a warrantless search. There's no justification for this search.
Right. Assuming a warrant is required for this type of inquiry.
Well, Your Honor, we think it is. And we think it is based on case law, third-party doctrine case law. That's Carpenter. Thinking about cell phones, that's the Riley case. If you have a cell phone that gets taken at an arrest out of a car, a subsequent warrant to search the cell phone is required. So we think a warrant was required for these subsequent searches. And there was no warrant in this case. There's an expectation of privacy.
I struggle with, I struggle, to be frank, and where you're going to have to try to convince me, I guess, is I struggle with the idea that DNA left at a crime scene, that there's any expectation of privacy by someone who leaves DNA at a crime scene, that DNA can't be, as you say, searched without a warrant to establish identity.
Well, Your Honor, I don't think any of us can go out of our houses without leaving DNA all over the place.
Not go to a crime scene.
The question of how something gets somewhere, that's the subject of the trial. I think the Carpenter case is really instructive for the court here. And that case was about, it was about third party with cell towers. And there was a concurring opinion in that case. I think that's instructive. We leave DNA everywhere. If you carry a cell phone and it uses the towers, there can be a trail of where you went.
Everywhere?
I'm sorry?
Don't we leave fingerprints everywhere?
We do leave fingerprints everywhere, but I would say, Your Honor, that things like your movements, cell towers, the contents of your cell phone, those are really personal things. That's how you carry out your business. That's how you go. You drive your car to go to the doctor. Your cell phone's heading on those towers. DNA is even more personal than that. the tests are so different than they used to be now. It can pick up all kinds of information. It takes very little DNA. DNA lives on surfaces a lot longer than fingerprints live on surfaces. So without more, they're not much of an indication of anything. There's a warrant requirement to protect people from unreasonable searches. And that's what we're asserting here. There's so much information contained in your DNA, and you can't stop from shedding that when you go out of your house. None of us can. To be able to have that searched without a warrant could put anybody in jeopardy. There's no privacy left. If that's going to be the standard, you put it in public so it can be searched. That can't be the standard. That would erode the Fourth Amendment. Our position is that there is an expectation of privacy that society is willing to accept. Our position is that there's case law that supports this. Maybe not exactly directly on point, but the court talked about one of the cases that we cited that's similar. It's out of Washington. In that case, it keyed on whether the database was a voluntary, law enforcement can search this or not. In this situation, that's not the case. You know from the exhibit you have and from the testimony that you heard that the FBI went into 2 databases that they weren't permitted to search. So if the court wants to go clear to that extreme, and the court shouldn't, the court should look at the Fourth Amendment. The court should look at expectation of privacy. The court should look at the 3 places there was a warrant required and it wasn't given. But if the court wants to go all the way down to whether or not there was a database searched where the people consented to have their DNA searched, our case is different. The FBI went into 2 other databases and searched those. There was nothing else happening until that happened. And it's instructive, I think, and important for the court to think about how secretive this all was. We are months from trial, and we are learning things about how the government identified Bryan today in open court when we've asked for those things. There's a reason why there's so much secrecy. That's because there's a violation of privacy rights. That's why there's so much secrecy. Your Honor, this is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left or not. The IGG evidence in this case should absolutely be suppressed.
I suspect the state's going to raise an issue that you may need to respond to, but I'll let you respond to that if they do raise that issue.
I'll be prepared, Your Honor. Thank you.
Thank you, Your Honor.
Why should I permit evidence obtained potentially by searching databases that by its own policies, law enforcement said they wouldn't search?
So a couple points on that. First, even assuming that that's all correct and that they violated the terms,
seems to be the evidence.
The terms of service, Your Honor, don't affect the Fourth Amendment. The terms of service, and certainly Mr. Kohberger does not have standing to raise a violation of the terms of service. And even if he did, the remedy for the terms of service is not a violation of the Fourth Amendment. As we argued in our brief, the individuals, and as came out in testimony today, the individuals who are utilizing these databases, and we're talking about millions of them, are willingly sharing their information with each other, with millions of other people.
Isn't there a subset that says, but I don't want these people to look at it?
In some of the data,
the FBI, as I understand the evidence, then says, okay, we agree, we won't search those ones.
So I'll address that part, but on the database piece, the issue is that no one sharing this information with millions of other people could have a reasonable expectation of privacy. The test for that isn't, do they have a reasonable expectation of privacy against law enforcement? It's against the public writ large.
So for example, we cited in our brief 3 different cases where Idaho's appellate courts have found people have given up a reasonable expectation of privacy in information that was shared with a single company. And it was shared with that company just so they could get the service from that company. Here, we're talking about people sharing it not just with the company, but with millions of other people, because sharing it is the purpose of providing it to the database. So regardless of what the FBI did or didn't do in terms of violating the terms of service, no one has a reasonable expectation.
Is it different if they share it with the company and it's obtained by lawful process from that company versus going in the back window and taking it?
No, Your Honor, because right now what we're asking is not reasonableness of the search. Right now what we're asking is there even a reasonable expectation of privacy? And so the fact that no one has a reasonable expectation of privacy in those databases means that even if the FBI violated those terms of service, no one has a Fourth Amendment right to complain, and certainly Mr. Kohberger doesn't. He has not asserted factually or through evidence that he was a customer to one of these databases. And maybe that changes the case if he were, but he's not. He's not even claiming that. He's not even asserting it. Now, I do want to address the second part of the court's question about the FBI has indicated that they wouldn't do this. I believe that's a reference to the policy we've been discussing, the interim policy by the DOJ. I certainly do not speak for the Department of Justice. I do not work for the FBI. I'm speaking for the state of Idaho, but I can read a document, and if you look at the policy in footnote 1, it clearly says this interim policy does not impose any legal limitations on otherwise lawful investigative or prosecutorial activities or techniques utilized by the Department of Justice, or limit the prerogatives, choices, or decisions available to or made by the department in its discretion. In other words, their first problem is they're relying on a policy at all. The US Supreme Court has said policies do not equal Fourth Amendment violations. Their second problem is it's a circular argument. The policy doesn't say you cannot do any of these things. It's saying best case scenario, you're not going to do these things.
Well, if you were interpreting this as a matter of contract, wouldn't you have a problem in the sense that on the one hand it says don't do this, and on the other hand, you've got a more general sort of catch-all that says, but we're not really meaning anything we say.
No, I don't think there's a problem interpreting that at all. I think the problem is they are putting way too much weight on this policy as if it's somehow the law. And it's not. It's indicating, and we heard testimony today about best practices and what those mean. This is indicating best practices, but very clearly stating we are not limiting the Department of Justice to have to follow what's in this document as long as it's not limited by the law. And they're trying to use a violation of this policy or an alleged violation of this policy to say that they violated the law. It's circular reasoning. But despite all of that, the US Supreme Court has said a policy violation isn't sufficient. Even the Department of Justice, as powerful as they are, they don't get to rewrite the Fourth Amendment by changing this policy. Now, I do want to address, the defense is they're trying to pick and choose what they believe the searches are throughout this chain. And what they're leaving out repeatedly is where this DNA started. Where did the chain start? Well, it started at a quadruple homicide, at a crime scene. There is no case law anywhere that the state could find, and the defense has not cited any to suggest that there is a reasonable expectation of privacy in DNA found at a crime scene. And I want to talk about the Davis case, Your Honor, because it actually cuts against the defense. Davis is the case where it was a very unique set of facts. There was an investigation into a shooting. An officer went to the hospital, and when he went into the victim's room, he saw a bag of clothing. He seized that clothing under the plain view exception to the warrant requirement. So the clothing wasn't abandoned. This was an exception to the warrant requirement. Later on, this individual who was a victim now becomes a suspect, and they have this DNA and they test it. And the Fourth Circuit said, no, you can't do that. You can't take it because he's a victim and then later use it against him as a suspect. That is nothing at all like what we have here. And in fact, if this court looks at the district court opinion that was affirmed by the Fourth Circuit, it expressly states nothing about this holding is indicating that the government needs to get a search warrant for crime scene DNA. That does not support their position. The Achilles heel in their entire chain argument here is that there is no case anywhere that suggests that a DNA analysis restores a reasonable expectation of privacy. So in the Davis case, no one lost their reasonable expectation of privacy. It was seized pursuant to the Plainview Doctrine. The other case that they're relying on is that recent Supreme Court decision from Arizona. They attached it to their reply. That case is similar to Davis in that the DNA was collected from someone who consented to it under a statutory framework because they had to provide 2 vials of blood so it could be tested for alcohol and drugs. Again, that case would have come out differently had the 2 vials of blood been found at a quadruple homicide. That is a pretty big factor in deciding whether or not someone has a reasonable expectation of privacy. In Idaho, while this specific issue has not been addressed by the appellate courts have told us what to look for when you're talking about a reasonable expectation of privacy. And it's things like ownership, possession, control, ability to regulate access. Mr. Kohberger had none of those things with respect to the DNA on the knife sheath. We are talking about not just a crime scene, not just a murder scene. We're talking about a murder scene in a house to which he has asserted no connection whatsoever. 4 victims to which he has asserted no connection whatsoever. We're not just talking about his DNA happened to be found in, a dresser drawer or something. It was found on a knife sheath where 4 people were killed by a knife. This is as crime scene as it gets. And that's where the DNA was found. And they can't cite any case law whatsoever. And so they try and just ignore that and skip over it and say, well, let's just talk about the DNA analysis. The other problem they have, as this court questions indicated, is the analysis that was done in this case, as we heard the evidence today, is not something that revealed a bunch of private medical information. In fact, the defense's own expert, who is engaged in the same kinds of conduct as Othram in terms of developing these SNP profiles, said he had successfully developed hundreds of SNP profiles and never once learned medical information about any of those individuals. He testified that he has never even heard of a forensic investigative genetic genealogy case that was solved using medical information. And in fact, and I wrote this down when I asked him what he would need to do to learn medical information from those SNPs, he said, quote, "It would be a lot of research." So the defense is positing this question of, they're saying the court needs to ask itself, what could law enforcement do with the DNA? And then decide whether or not there's a violation of the Fourth Amendment. But that's not what the US Supreme Court says. In Maryland v. King, they were very clear when it comes to DNA, because the defense there was asserting the same argument. We have DNA can reveal a bunch of private medical information, and the US Supreme Court said, quote, "Even if non-coding alleles could provide some information, they are not in fact tested for that end." So the question under the Fourth Amendment is not what could law enforcement possibly do with this? The question is, what did they do? And in this case, there is no evidence whatsoever that they did anything to find out medical information about Mr. Kohberger. It was all related to ancestry and identity. And as the US Supreme Court said in King, there is no greater privacy interest in DNA than in fingerprints, so long as law enforcement is limiting its activities to identification. And that's what we have in this case, is identification. Now, the other problem that Mr. Kohberger has here is, in my view, at least, he's been a little bit wishy-washy on the DNA on the knife sheath itself. You don't get to claim Fourth Amendment standing and then just say, well, that may be my DNA, but I have no idea how it got there. Again, the Idaho Court of Appeals has held in a couple different cases that if someone, for example, in one of the cases denied the existence of a bag that had been thrown out of the window, and the court said, well, you can't have a reasonable expectation of privacy in a bag that you deny exists. This is a very similar thing. We have a defendant who is trying to get the best of both worlds. He's trying to say, well, it's not my DNA and the state can't prove that, but he's also trying to say that he has Fourth Amendment standing. And that is not how the Fourth Amendment works. Your Honor, I also wanted to respond to an argument that was made in the reply brief, since I didn't get a chance to do it in the briefing. And this has to do with the trash pull in Pennsylvania. And I'll just start by saying that the defense has offered no evidence whatsoever that would take the trash pull in this case outside of the Idaho Supreme Court's decisions in Donato and Paluzzi. Paluzzi is very recent, came out in the middle of the briefing, in fact, and rejected the exact arguments that are being pressed by the defense here. Obviously, this court is bound by that reasoning. When the state pointed that out in their response brief, in the reply, the defense made an assertion that this case is different because the documents the state has provided are not clear on where the garbage cans were located, and that maybe the officers went up onto the driveway instead of collecting them from the street.
Trash company collected
Correct. I'm sorry, Your Honor, I misspoke. The trash company collected them on behalf of the officers.
They just did the regular pickup, I thought. And
Correct.
pulled over after they got out of the neighborhood and said, here's what we grabbed.
Well, I do believe it was prearranged with the FBI for them to do that. But my point is just, I do think it's telling that they didn't provide the court with these documents that they believe are not clear. And I looked them up to make sure that they were. And in fact, there is an FBI report that was disclosed in discovery that details that the garbage cans were at the end of the driveway, at the end of the property. And at the end, it says, see video. And there was a video disclosed in discovery where you can see the officer's body cam as he drives by the house shortly before they look in the garbage cans. And they're in the exact place you would expect garbage cans to be when they're out for collection. So they, of course, have the burden of establishing a search. They haven't presented any evidence to that. It's not sufficient for them to stand up here and say, well, it's just not clear. Which brings me to my final point, and that is, Ms. Taylor continues to say there was a lot of secretive stuff happening in this case. That is not sufficient to satisfy their burden that there was a search, that someone had a reasonable expectation of privacy. When you have the burden, you have to present evidence. You don't get to just stand up and say, well, it was very secretive. I will note in this case, as the court may be familiar with it, as it's probably read back through the record, the defense in this case has gotten a lot more information than many defendants in other states who have, where there's been an IGG investigation, because the majority of courts have found this isn't really relevant information. It's just a tip. Now, it is what it is in this case, and we, of course, complied with all the court's orders and provided the information, but there's not a lot of information, not because it's secretive, but because it's just not our case. It's not what we're focused on. It's not the evidence we plan on using at trial. And yes, IGG was used in this case. And yes, it did point to the defendant. But the fact that that happened doesn't mean that there was a violation of the Fourth Amendment. Unless the court has any questions, we'd ask you to deny the motion to suppress.
If the FBI, in fact, violated the Fourth Amendment rights of Mr. Kohberger, you would agree the state is burdened by that?
Responsible, yeah.
It's a great way of putting it, Your Honor. Yes, the state would be burdened by that. Yes.
You called them in to help.
I'll start backwards. I will answer the court's question that the court posed to Mr. Nye. The state is burdened by what the FBI did here. Every action the FBI took in here, all of the secret actions that they took, show you that there is an expectation of privacy that society is willing to accept. They didn't want anybody to know what they're doing. It is interesting to hear that discovery requests and motions to compel and orders have been complied with when I've learned at least 3 new things in the course of preparing for this hearing and being at this hearing so far today. That's a surprise to me. So I wanted to say that, and I want to go back to the trash pool. And I want you to know, when you consider this, that that particular area had an ordinance that trash had.
Supreme Court reject that argument very recently.
Your Honor, they might have, but that ordinance isn't all. I was starting with the ordinance, that it has to be collected by a trash collector, that a certain trash collector, and that you have to put your trash out too. In that circumstance, the FBI worked with the trash collector and had them go just to get that trash and then take that trash somewhere else too. And those are some extra actions that the FBI took in this particular case that changed them.
How does that change the analysis?
Well, Your Honor, I think that it changes
The
the
expectation of privacy is lost when you put it in the trash can to be taken away per the Supreme Court's opinion, even if it's a well-regulated neighborhood by ordinance that says when and where you have to put your trash.
Well, Your Honor, I think that there is an expectation of privacy when you have to comply, you have to put your trash out in that particular manner.
Not the case.
Unless
you're saying the Supreme Court was wrong, the Idaho Supreme Court was wrong, and you're reserving that for a later higher appellate court, that's fine.
Your Honor, I may not always agree with the Idaho Supreme Court on everything.
But I have to follow what they say.
But I have to make a record when I don't agree.
I appreciate that. I'm just trying to make sure we're talking about the same thing.
And I have to distinguish the case as best I can as well. And I think it is different when you have the FBI telling the trash man what to do. So, I'll move on to something else.
The FBI telling the trash man.
Now where Mr. Nice started, that Department of Justice interim policy, and he read you the first footnote. And I would just direct the court to pages 6 and 7 in that. And that is that the FBI is not to search databases that they're not allowed to. In this case, the 2 of the 4 that they did. And the next page talks about the things that have to be kept in case there's a prosecution case. The prosecutor talked to you about, well, this is a tip. This is just a tip. It's like an informant. And it's thought of in this Department of Justice policy as more if they're told to keep things in case there's a prosecution case. And so that should be considered when you're considering the entire picture that we have here in light of the amount of secrecy that happened here. That takes it out of being a tip. It takes it out of being a lead in the case. I would remind the court, I'm sure the court knows pretty well when we're talking about confidential informants and that type of law, you have to have some reliability. And there should be a big question here about how reliable this is, how reliable whatever it was the FBI did to develop this profile with the rest of the secret things that they did in this case and their willingness to violate their own policy. Certainly not suggesting that this court create a new Fourth Amendment right based on violation of Department of Justice policy, but I'm saying you should look at that and consider that when you're thinking about what the FBI did here and how credible this informant was, how credible this lead was in this particular case. That's fair for you to consider just like you would in any other confidential informant type of case. I would like to distinguish what we have here with our subsequent search. I talked a lot about that before. I won't go too far on that. This is a second search and a third search if we're just focusing on the 2 SNP files. These are extra searches that happen after the initial search is done and the STR profile is developed and it goes into the CODIS database. This is completely different and a SNP is different. You heard a lot of testimony about how this is sort of new and evolving technology and the standards that apply are catching up and there's best practices. You heard a lot about that today. So I don't think we can just say, well, if CODIS is fine, this is fine. It's not the same at all. There is a ton of information. It's your whole genome that gets profiled. Maybe the SNP that uploads into MyHeritage, which it shouldn't have, maybe that SNP doesn't tell you certain things about a health profile, but the potentiality is there in the SNP profile. For $12, you can upload that profile and find out all kinds of personal health information. It's the potentiality of that. And that's the Carpenter case that talked about the potentiality of that. People have an absolute privacy interest in their health matters. Idaho has a couple of different laws on the books. It has the family DNA law on the books. And think about HIPAA. I mean, we all have to sign those forms every time we go to the doctor if we want anything released to our surgeon. Health matters are important. If you can upload one of these profiles for $12 and find out all kinds of information, How is that not a Fourth Amendment issue? That's what that SNP profile can do. And that was done twice without a warrant in this case. And there should have been a warrant. It violates Fourth Amendment rights, Article 1, Section 17 rights, and this must be suppressed.
Thank you. All right, the matter will be taken under advisement. Let's proceed with the Frank's argument on the IGG and the Frank's proffer more generally. Or did I get it wrong again?
Your Honor, I'm prepared to do that. I would request that the court maybe give me 5 minutes. I have different things.
We'll take 5.
Thank you.
Back in 5.
Welcome to the Transparency. If you're just joining us, hello. We've had 94 people spray love to everybody that's been here. Kay Miller, thank you so much. 20 gifted memberships to people. 10 gifted memberships from A to Z. Deborah, yes. Keep on keeping on. It's going to be all right. Welcome. Just wow. Just wow. When was it approved? In fact, it was a knife. It hasn't, yeah. I am surprised there are any documents at all since they never seem to exist or state does not have them. Again, here we are. For me, guys, we got some information. Ready? The information is that 100% the FBI uploaded. So first of all, the reason that Othram couldn't get anything is because they didn't upload when they did the snip or whatever, and they uploaded it, they got nothing. Now, is it that they got nothing when they uploaded it? It was just like, oh my God, this is so, like, this is going to take us, we don't have any hits. We don't have any of those 3,500 type of centimorg type of hits we're talking about. And like, this is good luck. We're going to have to wait till somebody in the family closer to him or this person starts uploading their shit. No, what we can do is we're going to do this. So it came out. Bloom said it. He said that they attempted to work on this and that they could. He put it out there. They couldn't get a hit. They didn't get a hit. Then all of a sudden, the FBI gets this SNP, the SNP, and somehow we heard it here for the first time. That SNP profile, the amount doubled somehow, and it's unaccounted for, and it's in the hands now of the FBI. So I have to go back and listen to see, is she saying that it doubled? Where did this more, like, what, huh? How does this double? And she's like, with no explanation. And then here, okay, the FBI has it, and then voila. They use the known loophole, and it's known by those so-called CC Moores of the worlds. Okay, Gabriel Vargas knows about it. All of these genealogists know about it, use it. They've used it. They talk about it. Okay, and their thing is like, yeah, we don't, do you want a murderer to go free, Lana? What do you think about that? I'm like, well, I think that whoever's investigating the case sucks if you have to violate our rights to catch people. Maybe you should get better, detectives. But no, I don't think there's ever, once you start violating our rights, then what is this world going to come to? Come on now. No. Old-fashioned detective work. Do the work. But here, the reliability of everything then just happened, and we're talking, so we find out for the first time that yes, then the FBI uploads it to 2 databases that it knowingly knows that it's not supposed to, okay? And then from uploading it to 2 of those databases that it was not supposed to, it was then able to build the supposed family tree that then links to Bryan. And so their argument is that, like I told you it would be, is that, well, nobody did anything illegal. I told you that. The FBI, if they went ahead and did that, that's what I thought they did. If they went ahead and they were shitbags, right? All right. And they uploaded it to knowing that they're violating their own DOJ interim policy. So why do we even have policies in place? So if they're willing to do that, they're willing to just do whatever. You guys not get that? If they're willing to do that, they don't give a fuck about policy and procedure. It doesn't fucking matter. So that's why I get so pissed when someone says, you don't even know what you're talking about. You don't even know procedure. Fuck your procedures. You don't follow them anyways. It doesn't matter if there's fucking procedures or policy, because you guys do whatever the fuck you want. And that's exactly what they did in this case. And then so here, you now want me to believe that you want me to believe the data that you guys are saying is going with this car? Fuck you. I don't believe you. I don't believe you. And it's going to come out that the data doesn't go with the phone. Because then that's when you get a railroad job. A railroad job is when, okay, here we have this guy, but we really need to get him. So we don't have enough. We got to make more. So, and that's where they made the more. They made the more with the cast drafts and the Elantra, this alleged Elantra that, okay, now it's going to be all the way from 2011, 2016. That's the more. That's the railroading. Okay. And now, do I believe, when you say it the way that Ann said it there at the end, do we have an interest in that? Do I think that the FBI can just yank our shit and then upload it and then get all our information from like having, fuck that. Are you kidding me? Yeah, when she puts it like that, I think that we have an interest. Like there needed to be a search warrant at the FBI having that SNP because of what you can get from it if you give it into the right hands of somebody and what they can pull from it. Because when you're talking about health, you're talking about the HIPAA. Yeah. When you actually talk about that, yeah. And so that's what I think, to me, is where the violation comes in. Yeah, somebody uploads their shit. You guys want to break policy. You're breaking your own policy. You're breaking your own policy. Then the question should be why? Why are there any policies in place then? We're going to just do whatever we want. The FBI is just going to do whatever they want. I think it's amazing. I think it's amazing that Bill Thompson, like we all thought, it came out right here. We all thought that Bill Thompson made the call to order up the IGG, and he did. He did, because Idaho State Police Lab, Forensics Lab, got the okay and got the work order up, and then it was sent over to Ortham, that's who they deal with to do their IGG stuff. You know who made that call? Bill motherfucking Thompson. That's what came out. Which I knew he did, because that's when he said that he knew so much more than we knew. He made that call. Then when they weren't going to violate any policies that they have, okay, send that shit to the FBI. I told you I wanted to know who made the call to get the FBI involved in that portion of it, because you're a piece of shit, because you knew that they would go ahead and do what they were about to go do with it. We're going to upload it. So here we have whoever worked on this, which they've redacted. We don't know who's worked on it. The FBI has redacted the names, right? But they're just such great Americans, that these two FBI agents violated their own interim policy and uploaded it to two databases they were not supposed to, and they did it, and I knew they did it, and today we fucking heard it. And you know what they say? The ends justifies the means. You know what I say? If you're so fucking good at your job, so that you just tell me that you're not good at your job then. And then you're over here saying, redact my name. Don't tell them that I did it. Cover for me. Cover for me. I'd be so fucking proud if I caught a quadruple killer. I'd be saying, where's my fucking parade, Moscow? Where's my reward? Fuck out of here. Policy, procedure, my fucking ass. I love it. Fuck all you liars. I love it. I love it. Because it doesn't matter what happens here. The truth, we're seeing it. And whether you want to ever believe, you believe whatever the fuck you want to believe. I'm reading it, I'm hearing it, and the FBI violated their own policy. And they do it all the time. Why do you think the FBI is being dismantled right now? I fucking love it. Love it. Ann Taylor said that we have 3 issues. We need to suppress everything because there was no warrants for several stages of this process. And the 3 stages are: number 1, that Idaho State Lab, there needed to be a warrant that should have been obtained when the SNP profile was obtained from the FBI or from Wortham and then given to the FBI. You're just passing shit out and around. Okay? That's not how tips evidence.
All right, let's take up Frank's.
Your Honor, I think on the court's bench there was a document placed, so
What?
it had initials to comply
thank you.
with the court's.
Appreciate it.
All right. Your Honor, the purpose we're here for today is to offer you a preliminary showing of why we should have a Frank's hearing. To do that, we will show you that in this circumstance, the affidavits that supported search warrants in this case had false information in them that was intentionally placed there. There was intentional omissions of information that are material and exculpatory to Mr. Kohberger, and without the false statements and with the added information in, probable cause on the warrants should not be found. Today, I'm asking you to listen to what we have to say, look at the exhibits that have been admitted, and I'll walk through those with you to talk about the 13 areas. And at the end of this hearing, we will have met the preliminary showing required in order to schedule a Frank's hearing and fully challenge this.
With the exception of the IGG, which I think we've already heard the evidence on. So
we did hear the evidence, Your Honor, and I will not repeat that evidence. I'll argue from that today.
my only point being that's not in the preliminary stage that all the other issues are on.
Okay. Well, I'll try to hit that as hard as I can then. Your Honor, in this case, there were a lot of search warrants. I'm going to draw the court's attention to those beginning on December 23rd. That day is important because it was just a few days prior to that for the first time ever, Bryan Kohberger's name came up in the course of this investigation. Your Honor wouldn't know that by reading the affidavits for probable cause. Nobody would know that. That's because that information is omitted from the affidavit. That information is something that you heard about this morning in testimony, that but for the FBI's work going into databases they shouldn't have been going into, violating their own policy, keeping no records, and doing this all behind the scenes in secret. That's the only way a name was produced. Prior to that time, the lead detective in the case had not heard the name Bryan Kohberger. He had not crossed their radar. That's nowhere in the affidavit, and that's important because that's intentionally withheld from the affidavit because of the work the FBI did, because the FBI went behind the scenes and did things that they shouldn't have been doing, because they searched databases that they shouldn't have been doing. We don't know what else they did wrong because everything else is a secret. We don't know what else they did wrong because there's no record kept. There's no process kept. We can't rebuild the process that they did to identify Mr. Kohberger. We can't do any of that because they kept no records, produced no records, and did this all behind closed doors, and it was withheld from the magistrate. Had the judge heard about that, signing probable cause, that would have been really important to understand we don't know this name. We heard it for the first time now, and we only know it because we violated our own policy to find that. That may have given the judge caution. It may have made the judge wonder what else are they doing behind the scenes. But that was withheld from the judge. That judge never got to know that. Let's talk about what the judge did get to know with that in mind, and that's a really important backdrop. These affidavits are a group effort. I think the court's heard a little bit about that, and if the court has some of the initial exhibits, the court will know, and I'm at D2. The court will know that this was a group effort. The FBI, the same FBI that went behind and violated their own policy to try to identify somebody, they were co-located with Moscow Police Department and working on these affidavits to present to the judge. The first warrant that gets anything related to Mr. Kohberger is, I refer to it as AT&T 1. It's on 12/23/22, and it's for 48 hours worth of records of Mr. Kohberger. And I want to go through that warrant with the court having in mind that the IGG was purposefully and intentionally withheld from the magistrate. And I want to talk about some of the other problems with that warrant. This probable cause affidavit talks about an interview they had where the person that was interviewed said that she heard things and saw things within her house. But what is written in the probable cause affidavit is seriously lacking in detail. It's wrong and it's false in many places. The way the affidavit reads, it says, this person stated she went to sleep on the second floor. She was awoken at 4 by what she stated sounded like one of the victims playing with the dog, which was on the 3rd floor. A short time later, she thought she heard one of the victims say something. That caveat, she thought she heard, is a problem. That's not at all what was said. This person was interviewed shortly after 911 was called in the afternoon of November 13th, 2022. And she was sure, I'm at Defendant's Exhibit 8A, page 281, lines 4 through 10, when this witness was sure that she heard this particular victim go down the stairs, go up the stairs, and then come running back down the stairs. That is not what's contained in this affidavit at all. That is repeated during this same interview a couple of different times at page 287. It's also repeated in a subsequent interview that same day. This is Defendant's Exhibit 8B. That's at page 313 and again at 320. I've got one more of these where this is repeated.
Woo! Let it all hang out, Annie, baby. Woo, woo, woo. Go in. Rock it.
It's repeated again in D8C as well. That is important because that's misleading to the judge. That waters down what was said, and that matters in the probable cause affidavit because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs, that's not what happened. That person was killed in the bed and never left the bed. And so the officers water that down because they know that fact is wrong, but they don't tell the magistrate that. They also don't tell the magistrate that this witness has claimed memory problems, that this witness has claimed that she's not sure what she heard or saw was real or whether it was at a dream, and that is contained in defendant's 8C, and that's going to be beginning at page 396, 398, 399, 403. There's further statements from that witness in that police interview that said that she had had too much to drink and couldn't remember. None of that is given to the magistrate. That is information that's withheld. That's credibility of the person telling law enforcement these things, and the magistrate had a right to know that whatever is laid out in here isn't exactly the way it was. That person had credibility issues, and she said things that were just absolutely untrue and couldn't have been true. Law enforcement knew that. That was intentionally withheld from the magistrate. That matters when we're talking about credibility and sets this whole thing into motion. Your Honor, the next part of the affidavit talks about what they have determined to be suspect vehicle number 1. And it trails a path of pieced together cameras. But what they don't tell the magistrate is that the camera near the residence, the 1112 King Road camera near 1122 King Road, you can't tell what kind of car it is. They don't tell the magistrate that that's an impossible car, that their expert can't make an identification off that. They don't tell the magistrate that this is pieced together from various other videos throughout the area. That's withheld from the magistrate. That's important information when you tell a magistrate, we found this car doing this thing and we know what it is that's around this particular area. The next issue is the year of the car. Law enforcement works with the FBI to determine the year of the car, and the FBI provides some possibilities after numerous submissions to them, and the court knows this and can read about this. This is going to be in D10. That's in D9. And finally, after several submissions, that's when the FBI IML says, I can make a car identification. The issue with that that's not disclosed to the magistrate is that car appears one time on one video and not any of the others that they try to say are the path. It's not, let me see if I can say this right. It's not following a consistent trail where the one camera that can identify the car where it appears again. It appears one time, and then what law enforcement did was they took several videos from all over the area and said, well, it's the same car and we have an identification. That's not all. The identification was most comfortably from that FBI agent to be a 2011 to 2013 Elantra. And that's what law enforcement relied on. The court has, it is D12, and it's the Be on the Lookout that was issued by Moscow Police Department, where they look for a 2011 to 13 Hyundai Elantra. And that's what they're looking for. And they don't tell the magistrate that's what they're looking for. They mislead the magistrate and let the magistrate believe that they have a clear view of this car making this loop. And that's just not what happened. It's pieced together and it doesn't make a whole lot of sense. Law enforcement in their affidavits talked about this dog barking, and they key some time. And they say, this is when something was happening inside this house. We can hear this dog barking. And they use the videotape to get a time off that, the surveillance tape from the neighborhood, the 1112 King. And so they've got this time, but they also have this video, this trail that they've picked out a time that something probably happened here. And they don't tell the magistrate that this dog that's barking continues on long after the car they're interested in has left the area and then abruptly stops. Your Honor, the dog was found the next day inside the house in a bedroom with an open door, where the other bedrooms that contained people that died, their bedroom doors were open, and this dog had not tracked any blood around. The dog had no blood on it whatsoever, but it was just sitting in an open room a day later. The magistrate is not informed about that either.
They put the dog back in there. Oh my God.
Then the police department goes through maneuvers to tell the magistrate that they did this investigation. They talk about a traffic stop, 2 traffic stops actually, and there's no connector in there. This is where the lack of the IGG becomes really important. If you know about the IGG, you know why that would be built. Otherwise, 2 random traffic stops months ago in pretty populated areas with a lot of college kids really doesn't add up to be an investigation. But those are put in there to try to bolster up this investigation and say it was something that it wasn't. Probably the worst part of that is relying on, after the BOLO went out for 2011 to 13 Elantra, then WSU, Washington State University officers find cars. They find one that's registered to Bryan Kohberger, parked at the apartments he lived in, but it was a 2015 Elantra, and so they don't really do much with it. But this is placed, that is placed in the affidavit like it was an investigative fact, and it wasn't. It was on the 20th of December when the detective, the lead detective, got a hold of WSU police and found out about that and said, oh, hey, you called this in. He didn't know about that before, but there's no context around that. That's just stacked in there like it creates probable cause when it doesn't. You know that's the case when you look at a couple of our exhibits. One is prior testimony from that same detective. And if you look at the messaging between the detective and the WSU police officer about the timing of that. So it's based on this false investigation trail, and it's based on statements that are completely out of context from somebody that they interviewed that are incorrect statements when you take the totality of the circumstances together, and statements that this person disclaimed a couple of days later because she wasn't sure what she remembered was real, and give that to the judge. If you add in the missing piece of IGG and what happened with that, and as a judge, you know you've got law enforcement willing to violate their own policy, and you know that you're not being told the full story about what a witness is saying, and you're being led down this path to say there's a real investigation when there wasn't a real investigation, you don't find probable cause on that.
If I find that the IGG was not unconstitutionally obtained, doesn't it just add to the probable cause?
No, no.
If it were to have been disclosed, it would have simply created more basis to suspect Mr. Kohberger.
Your Honor, if it had been disclosed, think about how that would read. We used a process to make an identification. This is a new technology. This is called investigative genetic genealogy, and we identified somebody. We did not keep any of our documentation because even though Department of Justice policy says we need to, we decided not to. Even though it says we can't go into certain databases, we really wanted to figure out who this was, so we just ignored that policy altogether. I don't know how a judge could find that credible. You don't even know how that happened. There is a great big question mark about how that happened. To Your Honor's point, you should find it unconstitutional. If you don't find it unconstitutional, it's a separate analysis. I appreciated being able to talk to the witness about that today, but it's a completely separate analysis. You're looking at integrity. You're looking at what a court can rely on to sign off on an affidavit or a search warrant. If an affidavit is presented to a judge and you know that the rules don't matter, that terms of use of a database don't matter, and that you're going to hide what you do, and that doesn't matter either, there's not a lot to rely on. If law enforcement came to the magistrate and said, we want to go search this house over here, and they said, we really think there's going to be evidence of a crime in there because we've got this confidential informant, and this confidential informant has provided a lead, but we need to tell you that we don't have real reason to trust this confidential informant because they won't tell us how they know that. They gave us a picture, but they won't tell us where they got it from or when they got it or what means they used. They threw away their camera. They threw away all the metadata. They won't tell us anything about that. And by the way, the confidential informant maybe has some integrity issues. A judge is not going to sign off on that. And then if you say, but to support that, I built this false look at a whole investigation here. I'm going to tell you these other things that I know that I had no idea about before my confidential informant was here. And these things don't add up anyway. There is not, in my view, a judge that's going to find probable cause because somebody got stopped by law enforcement. I think it was a seatbelt ticket months before.
The purpose of the submission of that was simply to identify the car that he drove and the fact it didn't have a license plate on the front.
That's not true. That's not true at all, Ann. Tell him.
It's otherwise connected to.
That's not true at all.
This is a car of interest.
No.
Defendant,
It was for his phone number.
Well, let's talk about that license plate for a second, though, because that's
Good job.
not something you can see from the videos.
Exactly.
That was testimony you heard today.
This motherfucker.
You can't see that from the video that the cops relied on here. So that bit about the license plate, that's something a little bit extra that happened after we have this IGG stuff. That wasn't known before. There was no video collected from WSU before. There was no communication with the officers at WSU before. So before the identification through IGG.
I'm just not tracking why that matters. Go ahead.
What are you talking? How did they get to Bryan?
This wasn't a real investigation. These are things that are put in there to make it look like an investigation happened, to say, don't look here at this big glaring thing that's missing, this whole piece about why we identified him. Don't look here. We don't want you to look here because this is ugly, this is dirty, and this isn't real. That's precisely why those things are placed in that PC affidavit like that. So based on that, the first warrant gets issued. It doesn't end there. This warrant is not good. There's too much missing information, false information, and information withheld from the magistrate here. But then the warrants just rely on one another. There are other things to add into later warrants as well. And so I want to go through some of those other things with you.
I would have changed my argument there a little bit if I was Ann, but hey, I mean, I'm not a lawyer.
I do want to comment on the affidavits being used by a variety of officers. I understand the collective knowledge doctrine, but that's not what is going on here. You have an affidavit that sometimes Moscow police attribute it to the person that really wrote it, but quite often it's just the name taken off, and who claims to have done the work is whoever signed the bottom of it, and it can't be the same. So it's not quite the same thing, and that matters as well. But let's talk about the second warrant. The second warrant is also AT&T. The first one comes in, and an hour later, they say they have all this data analyzed, and they say they now need 6 months worth of phone records for Bryan Kohberger's phone.
An hour later.
Acknowledge that his phone wasn't contained within the geofence. when they looked at the geofence. But this second warrant is important, and we're going to talk about minutes difference of time. In the first AT&T warrant, in that affidavit, the police officer talks about 2:42 a.m. that WSU cameras, because they start looking at WSU cameras after the IGG identification, they find a white car that they say is an Elantra at 2:42. So they get the phone records, and then it becomes 2:44 that they say Mr. Kohberger's leaving his residence, 2:44 a.m. And the place near Bishop Boulevard where one could turn to go to Moscow at 2:42 is inconsistent with 2:44, but they don't correct that. They don't correct that. They don't say that vehicle at 2:42 cannot have been the right white Elantra running around that night, because we now know it was at 2:44 a.m. They want to keep that in there because they want the car positioned like it's going to be going to Moscow. And that is really important with the misleading of the magistrate. When you look at 1A, that's the map we looked at earlier today, where there's the whole loop around, but there's a blue line as if pointing the car towards Moscow, and that's not what happened. They then report the phone stops reporting to the network at 2:47 a.m. And that's not right. We submitted their cell experts report that say the phone stops reporting at 2:54 a.m. We submitted 2 affidavits to you from our experts who have worked with the call detail records, and that's just not right. Don't get caught up in thinking 7 minutes don't matter here. We're talking about ground that can be covered in a vehicle in a short time. We're talking about 2 towns that are fairly close together. And so the way a car points when they go off a network matters a whole lot in this circumstance. That's not corrected in any of the affidavits. That's the part that's really exculpatory to Mr. Kohberger, is what direction, when the phone stops reporting to the network, what direction is the car traveling? And you can know that based on the cell towers, the handoffs from tower to tower as it tracks where a phone's going. The FBI knows how to do this. They chose not to do this. They chose to take a time 7 minutes before it really stopped reporting. And they chose to make a map that showed a direction that that phone wasn't traveling in, to create a false narrative for the magistrate to rely on to find probable cause.
Told you.
Your Honor, I draw the court's attention to D7 and 8. Those are the affidavits from the defense experts. Their CVs are in D28. Once the second AT&T warrant comes, then you end up with warrants for Mr. Kohberger's arrest. You end up with warrants for DNA samples to be taken, warrants for the search of his apartment, the search of his car, the search of his parents' house. Those are the warrants that are next implied in that. Here, what's added to that set of affidavits is the paragraph that talks about Mr. Kohberger's phone using a tower that provides service to 1122 King on a number of occasions. The PC affidavit says 12. Your Honor needs to take a look at, I believe it is D1B and C. That's an email from Nicholas Balance, and he's talking to the detective in Moscow about the dates that he says this thing happens. And then he puts those dates in his cast draft report and in his cast final report, and they don't match up. There are different dates on those, different times on those. But the really big deal about that is that it's misleading when you say the cell tower that also services this particular location. Moscow has, I think, 2 cell towers that service the town. Those cover places that one shops, places that one eats, places that one gets gas in Moscow. From the records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. You can know whether it's parked, looking at a particular place or not. Based on those records, we also provided the records just so the court would know there's a volume of records. I don't expect the court to decipher those records, but based on those records, they absolutely knew that Mr. Kohberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening, but they put it in there to make a connection that didn't exist. They put it in there so that the judge would think that this was the right person, and they shouldn't have done that. They knew that was incorrect. They also changed that quite a bit, performed a drive testing, and so there were other bits of data that kept coming in so that they would know that was untrue. Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible, has memory problems, and the judge never knows that, and we'll keep the IGG identification off to the side. But then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie to the magistrate. When you omit that kind of information, when you take that context out, you might as well say stalking, because that's what you're trying to say, and you know that's not true. This court can rely on our proffer in D1B and in the cast draft report and in the cast final report, because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that.
Mic drop.
We'll move forward to the set of warrants that come a little bit later in February, March, April. I'm talking about Amazon, Google, Apple, those kinds of warrants that come later. Here's what is left out of all of those warrants. The fact that Mr. Kohberger gets arrested, his apartment gets searched, his car gets searched, his car gets searched again, and his car gets searched again, and there's absolutely no connection between him and anybody from 1122 King. And what I mean by that is that there's no blood in his car. There's no he wasn't connected to that house, to the people in the house. Your Honor, I'm
Maybe I mistake me thinking of a different date for the AT&T. I thought not the cell tower stuff. Are you still talking about the cell tower stuff?
No, I mean, that stuff applies to every single warrant we have, because that was early.
I thought you transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
Your Honor, what I'm talking about.
Some other evidence that the defense can claim in cross-examination or their own case is exculpatory, but isn't the DNA connection in and of itself?
No,
cause to support
it's not in there. It's not. That's not even.
The DNA I'm talking about is the lack of DNA in Mr. Kohberger's car and the lack of DNA in his apartment, the lack of connection to the individuals.
What is that? Even if disclosed, preclude a finding of probable cause when there's a DNA match between the DNA in the sheath and Mr. Kohberger. Isn't that probable cause every day and twice on Sunday?
Not in this context. Not in this context, because of the IgG work. Because I mean, that's the ultimate question that will be before a jury. What does that mean, right? What does a knife sheath at a
He
scene
wants her to
mean?
argue
That's
her
gonna be the
case
ultimate
right now.
question.
He wants her to
You're-
argue her case. We're not arguing the fucking case. We're arguing fucking evidence. Get the fuck out of here. Don't argue the case, Ann.
A proof beyond a reasonable doubt standard. It's probable cause to think that this person might have done it. And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't close the book on anything on probable cause after that.
Well, I think it doesn't close the door on probable cause. I think when you know the other factual information that the magistrate should have known, I think that there's a lot of pause even at a probable cause level, Judge. This was information withheld from the magistrate, and I'm talking about, let's just go with the car. Let's just go with.
I understand the lack of evidence of DNA material or other victim-related material in the car and in his apartment as asserted, but I'm not sure how that precludes probable cause when there's a direct DNA match. There's plenty of reasons that that might be the case. And when a magistrate's looking at this, they have a direct DNA match to a person from a object associated, likely associated with a murder weapon. I have not yet a magistrate would not find that probable cause.
If the magistrate had the other facts, I think the magistrate would have some serious concerns and would not find probable cause. Your Honor, the vehicle, and I know the court knows what I'm going to say. There's not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's theory, right, with their videos that they've talked about, that they told the magistrate about, that this is the video, this is what matters. It parks at this certain time, it leaves at this certain time. If you want to go to that, there's about 13 minutes of time, right? 13 minutes between the last time you see the car and the next time you see the car on the video. And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart, the key fob is checked. There's no blood on any of that, none. The steering wheel, there's some kind of spray all over the interior of the car to check for it. There's no blood. I think that there's context that the magistrate should have known that's absolutely exculpatory to Mr. Kohberger, and it matters a whole lot.
I'm not saying it's not potentially exculpatory. I'm just saying I'm not sure how knowing that in light of a positive DNA connection would trump, would cause any magistrate to say, well, okay, I guess there's no probable cause here because you couldn't find other connection to forensic evidence. When there are other things in the affidavit or affidavits at that point that could explain that, including the use of covering clothing and covering gloves and all that could be put into a bag real quick on the way out that was in one of the affidavits. I guess, and I don't intend to argue with you about it. I understand your other arguments, but when you get to once they have the actual DNA.
So the woulda, shoulda, couldas?
DNA. It seems to me that it's an uphill battle to say there's not probable cause at that point.
Well, Your Honor should never get to that question, but I'm going to answer it for you. But you should never get to that question because you should have already found that AT&T 1 and AT&T 2 were terrible, and there's no probable cause for those, and they just build on each other. So you should find that the very first one lacked probable cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. Maybe
Well, I'm just not sure why it matters for a probable cause, but I think we're talking over each other, so I'll let you just go on.
Okay. I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway because you brought up blood DNA of an unknown individual that was found, I think, on the handrail.
Yes.
Doesn't that necessarily not exclude Mr. Kohberger? What it may do is suggest there might be a potential other person in addition involved if you assume that that blood was related to the victims and not some earlier event in the house.
If what the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheath, but there are all these other things that if I know about them matter. What's the other explanation? What's going on with this investigation? What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to ask that. She wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't given a chance to ask any of those questions. She didn't know that Bryan's car and the court's question, good question, what does that mean? Could it mean there's more than one person? The answer to that is, or it could mean it's not Bryan because his car's got nothing in it and there were only 13 minutes to do this. The magistrate didn't get to know that.
In fact, his DNA is still on the knife sheath, though. That's the problem, counsel, for probable cause purposes.
If that's the only thing she's told, I can see why she'd find probable cause. It's these other things that are withheld that create a context around it. I think the purpose of Frank's is to ask this very question, and this is a question. What do we want to do with our criminal justice system? Do we want to have one thing with no context around it when there's this other context that really matters?
Applying the Frank standard, which is even if you add that stuff, does that take away probable cause, counsel? And my problem is once you have a direct DNA tie to the defendant, for purposes of probable cause, this isn't for purposes of conviction, for purposes of probable cause, you have not explained to me why a reasonable magistrate, let alone any magistrate, wouldn't find probable cause there, even if they knew all those other facts. As to Mr. Kohberger, now, there may be, as you say, other people that creates concern or issues about that need to be investigated further. But I'm not sure that that diminishes the probable causes to Mr. Kohberger if his DNA is found on a knife she found on or near the victim who was stabbed with said alleged knife that would have been in said alleged sheath.
I think the most prominent question is how did that sheath get there? And I think when you ask that question, I think you can have DNA on an object. Boom! And I think when you ask that question, you know about all of these other things and you don't find probable cause because there are more questions than there are answers. And all of a sudden this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were, and it didn't exist, and Bryan's, that there's no other DNA in there other than an unknown male B that we know of for sure, an unknown male D outside. There's a lot of context there, and all of a sudden this one thing, the question of how is that there, is the question that the magistrate should have had. And then we come to all of the other things that we've talked about. We've come to what we relied on. One of the witnesses saying things that absolutely couldn't be true. One of the things that the witness who said these things that couldn't be true also admitted she didn't really know anything. You can't rely on that anymore, so you take that out. You know the identification to this sheath that maybe seems like it would be really good. You don't really even know how that happened, and you don't know how it got there. This isn't like DNA in blood on the wall from Mr. Kohberger. That's not there. That doesn't exist in this scene. You're talking about an item that the question of how should be, especially when you know about the other male DNA in the house, and especially when you know about the lack of DNA connections. There's also no connection between the people in the house and Mr. Kohberger based on their cell phones, based on social media accounts. There's just no connection. The magistrate wasn't aware of all of those factors when she was being asked to decide on probable cause. I don't think criminal justice means one piece of evidence out of the context of everything else is all you need. Context matters a whole lot.
Well, you're not suggesting the magistrate was told that there was DNA evidence found in Mr. Kohberger's car or in his apartment. The lack of inclusion also can be viewed as the implied of, they're obviously not telling me they found this, and they would have if they did.
I'm not 100% sure I followed. I'm not sure. Are you asking me why I think that's important as far as the Frank's purposes?
Well, for Frank's purposes, you are implying, I think, necessarily that
It's
police
about lies.
intentionally didn't tell the magistrate that they didn't find the lack of evidence in other places, the apartment, the car, etc. Right?
Yes, that's right.
They didn't tell the magistrate that there was evidence. This is a omission.
This is one of the omissions, yes. Yes, we have false statements and we have omissions both. It's not one thing in this case.
I was understanding completely.
Yeah, thank you for that. I wasn't following the question the court was asking. I think the other thing, I think I covered all on my proffer, Your Honor. Thank you. Sorry.
I think now, Mr. Nye, were you going to address the IGG Franks issue, or is Ms. Jennings going to cover all of it?
Your Honor, I think I'm going to cover all of it.
All right, go ahead.
Gonna attempt to.
Ashley Jennings, welcome to the game. Shake it for Ashley.
Good afternoon, Your Honor. As you're well aware, you have to make two separate inquiries for each of the claims that Ms. Taylor has brought before you. First, you have to decide today, has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits, and in our case, we're referring to the Exhibit A's, that were attached to each of the affidavits for probable cause. That they were the basis, which were the basis for multiple search warrant applications. That within those Exhibit A's, there were deliberate or recklessly false statements or omissions. This is a high burden, and this is a very high hurdle for them to jump over. Now, if you can answer yes to that, then and only then should we move on. And then ask the second question, does that even matter? Does that statement actually diminish the probable cause finding? It's only when the answer to both of those questions is yes, should you then even consider granting a Franks hearing. The motion for a Franks hearing is a serious allegation. The allegation is that law enforcement acted improperly, that they lied to the magistrate in order to secure the warrant. The statements have to be deliberate, reckless, false. That's the standard. Franks is not implicated by just simple mistakes or misunderstandings about the evidence or Scrivener's errors or even just negligence. As the court is well aware, this is serious. The defendant is alleging law enforcement lied to secure the probable cause in this case. And the state submits the defendant has failed to back up this claim, and they failed because they can't. Law enforcement submitted probable cause affidavits to the magistrate based on the information they had available to them at the time that the various applications were made. That's how it's supposed to work, and that's how it worked. The defendant has alleged 13 separate areas where they say there's a Franks violation. I'm going to go through those so that I make sure that I get through each of them in the same order that defendant addressed them in their motion and as the state addressed them in our response. And that starts with this idea of attacking Exhibit A. As the court knows, in Latah County, it's our practice, we submit an affidavit for probable cause. As I said, attached to that affidavit is what we call an Exhibit A. That Exhibit A is law enforcement officers' statements, laying out all the various facts known to them related to probable cause in order to support the issuance of a search warrant. In this case, Exhibit A, by the time we get to where we're challenging, was about 20 pages of facts for the magistrate to review. Essentially, the same Exhibit A was relied upon for the application of multiple warrants. This was a massive investigation. You heard testimony earlier today from Detective Payne. Multiple officers were involved in this investigation from multiple agencies. And they were doing briefings. For weeks at a time, they received 2 briefings a day with all the lead investigators in the same room receiving the same information. This information was then put into this Exhibit A for the basis of a probable cause affidavit for search warrants. A working document like this, with the most up-to-date information, was the best way to ensure the magistrate was getting the most complete and accurate information. And defendant wants to take issue with this process. But
what do I do if the affidavit is attached to Detective A's submission? Is it Detective A's affidavit, right? And there's for purposes of my question, a material reckless statement in there. But Detective A isn't the one that made it. It was another person on the team, let's say the cast member expert.
Well,
How does that affect the Frank's analysis as it relates to the affidavit submitted by Detective A?
I would say that Detective A would have to have reason to know that that was a materially reckless statement made by Detective B.
Even if the person that made the statement on the team knows that that statement going into the affidavit, that group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
I'll concede I think there's an issue there, but that's not what happened. I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so recklessly. And if they do so, then I agree that the court should take issue with that. But the cooperative nature of this investigation and this kind of group effort is allowed. As discussed more extensively in the state's response, we have several Idaho cases that support this. State v. Rubio, State v. Gomez, State v. Alger. And in our case, the probable cause affidavit, it wasn't as if the judge wasn't put on notice that this was exactly what was happening. The judge was put on notice. Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigations. Throughout the document, it makes references. I consulted with FBI Vehicle Specialist S.A. Imel. I consulted with FBI S.A. Balance regarding CAST. I consulted with FBI S.A. Hill regarding surveillance footage. It's very clear what the sources of the information were coming from. It could absolutely be reasonably inferred where the information was coming from. The magistrate was not at all misled regarding the sources of all the information. I'm gonna talk a little bit about this idea that there's some issue with who did the work in reference to Google. They claim that the CSLI work alleges Kohberger around the King Road residence. And this same claim is in Exhibit A signed by Detective Blaker. Well, this is inaccurate. The officer signing the affidavit did not claim to do the CAST work.
Did you mean AT&T?
Yes. They didn't claim to have gotten those records and put them in to their program to determine the approximate locations of the phone. That was done by Special Agent Balance. And the affidavit makes that clear. And defendant ignores the entire paragraph within Exhibit A that makes that clear. Quote, I consulted with an FBI special agent that's a certified member of CAST. This paragraph goes on to explain what CAST is, what CAST does, the experience that's involved, SA Balance's own experience. And then the
argument is that
law
they're
enforcement
wrong.
officer then states, from information provided by CAST, I was able to determine estimated locations for the 8458 phone. That's not claiming to have done the CSLI work, but instead is just a reflection. The work was done by Balance, investigators reviewed that, and then made some determinations of the approximate locations for that 8458 phone. And we're going to get into this in a little bit down because this comes up again. All about the cell phone. And we're just going to take we have two different opinions about what those records show. We have an expert who tells us, and that's what was relayed in the probable cause affidavit. And those opinions haven't changed. We differ on a few factual issues. I believe there are 3 towers that provide service to the Moscow area. Defendant is correct.
Here's my concern with you telling me that at this stage of things. Where in the record is that currently? Apart from anything you may have submitted after they filed the Frank's motion.
What specifically?
That there are 3 towers.
I believe
Remember,
I
we're at-
referenced
we're
it
at
in my
proper-
response.
Well, yeah, but that doesn't, if you give me evidence and I rely on that evidence, then I have to give them a full Frank's hearing. And so that's why I'm been very clear to say I'm looking at what the proffer is from the defense without evidence submitted by the state to determine whether they have met their threshold burden. And so I get concerned when you start telling me things that are not necessarily part of the evidence.
Understood. We can move past the number of towers. Here's what is in evidence, though, and based off of the PC affidavit, is that the phone was in the area for the tower that provides service to the 1122 residents. Still maintain that's true. Regardless, none of this has any bearing on the validity of the search warrant. Their argument is merely a clarification about which member did what work. And that doesn't matter to the ultimate determination for probable cause. Defendant then makes some allegations regarding an eyewitness statements related to DM. There's kind of 2 buckets of attacks here. The first bucket is that the defendant claims the magistrate was never informed that DM told law enforcement she, when shown a picture, didn't recognize the defendant.
She was shown a picture. Thank you.
It's clear from reading the probable cause affidavit that she's not going to recognize the defendant.
What relevance was the statements of DM that were included in the affidavit as to probable cause?
I cited those in my response throughout.
What were they?
Okay. I can tell you generally, consistently, she gave the same set of facts.
I understand the things that she said. Why was it important the magistrate know those things? In other words, are they going to who the ID of the perpetrator is? Are they going to establish a timeline of when the alleged or when the murders took place? Okay, so it's part ID as well?
I think that it goes to giving a general description of the person that she saw in the residence around the time that corroborates when we know these crimes occurred. Yes, a general description.
When we
is
know.
material and relevant. And that general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only a portion of their face showing and visible. This person was male, white. She heard a voice that was not something that she recognized. The person was a slim, skinny, lean build. And the person was taller than she is around 5'8". That's what's
5'8". 5'8".
It was that general description. And that general description did not change.
It's also important to establish the timeline.
It is. It's important to establish the timeline to know when that the timeline matched the vehicle surveillance of when a suspect vehicle is coming into the area of 11:22 and then leaves, as well as text communications of her relaying what she's observing during the same time period. And even if the state's wrong, that somehow there was some exculpatory relevance to some of her statements not being included in the probable cause affidavit, you can take all of it out and the magistrate would still have probable cause. The second issue defendant, the second kind of bucket that they take issue with DM, is about these other just statements that she gives during her interviews. The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well, the simple answer is investigators knew what she saw was real, and we know it wasn't a dream because they found the evidence discovered the next morning. Those statements didn't need to be included in the PC affidavit because they weren't exculpatory. They didn't support this idea that this didn't really happen, that somehow we got it wrong. Next, defendant attacks the vehicle identification. Well, this picture they're painting about how this happened just is simply not true. The magistrate was given a very detailed picture of the investigation at the time related to the white sedan, which was later determined to be a Hyundai Elantra. This was about 5 pages of the probable cause affidavit. The reality is, yeah, still images and video were provided to a vehicle specialist. Based on his review, he provided information to investigators that the suspect vehicle was likely a Hyundai Elantra. There was some discussion regarding what was the most appropriate year range, but at the specialist direction, he said that the year range to be focused on was 2011 to 2016. So Detective Payne reasonably relied on his expertise as a vehicle specialist and included that in his probable cause affidavit. And the court has in front of it the emails attached as exhibits that show that's exactly what occurred. And the defendant appears to argue that, well, the vehicle specialist shouldn't have relied on this video because they can't tell that that was a Hyundai Elantra. To them, it doesn't look like, I guess, a Hyundai Elantra. And the video that is clear, well, they take issue with that video because, and specifically, we're talking about 1125 Ridge Road, because they say, well, that can't be surveillance video of the white Elantra, even though it was caught on video about 0.3 miles from the crime scene, about 3 minutes right before when we see the suspect vehicle enter the area of the crime scene, which 0.3 and 3 minutes appear to be the amount of time it would take the vehicle to travel to the area of the crime scene. They say, well, that can't be the right video, because if it were, then the surveillance right up the street would have also caught this video. But we know that's not true. And that's been submitted to this court. Excuse me?
When was it submitted to this court?
Well, it was submitted through my response.
I was afraid that you were going to say.
It was submitted through my response, that their logic is flawed. And I can tell you, it has since been confirmed. I do not have, and it has been discovered to defense. We had Special Agent Hill confirm, and he discovered this as Bates 15990, which confirms that the surveillance camera that was set up to capture motion would not have captured the corner the defendant says must have been necessarily captured. Again, it doesn't matter. At the end of the day, the defendant's speculation about the route of travel and their differing opinion on it isn't the basis for a Franks hearing. There's no legal basis for second guessing a vehicle specialist's opinion. And they haven't made a substantial or a sufficient proffer for you to do that. Next, the briefing addresses the IgG issue. And
is it possible to tell from the affidavit what shots and what cameras were relied upon to make the identification?
I know that I don't know that you needed to. I don't know that all of that information had to be included.
That wasn't my question. My question is whether the affidavit describes the specific shots and cameras relied upon to make the identification.
No. It discusses that several surveillance videos were reviewed, that images were turned over to a vehicle specialist, and then that specialist made a determination. But no, we didn't walk through describing each and every still image or video to the magistrate. No, nor did we need to. Really, the IgG has been discussed extensively. I think the only real Franks issue is, should the IgG process, the fact that it was not included in the PC, is that the basis for a Franks hearing?
That's not what this is about.
But you heard testimony today that law enforcement received this tip and they made a strategic decision not to include it. They were told it's only a tip and that they should develop probable cause separately. And that's what they did. And at the end of the day, Your Honor has already kind of hit the nail on the head through your questioning of Ms. Taylor. At the end of the day, this information regarding IgG and the use of IgG is only inculpatory. And the non-reliance on the IgG information does not diminish probable cause. And the IgG information was confirmed through the STR testing. I can't wrap my head around any argument that IgG and STR testing would be exculpatory. Defendant makes kind kind of hay about the dog barking. And that I guess the magistrate should have been informed that a dog barked for 25 to 30 minutes. And this is just a reach for me. I'm still unclear how this is exculpatory. And again, this fact just does not diminish. Take all information related to the dog. It doesn't diminish probable cause. Circling back to the cell phones, at the end of the
25.
day, this is the proffer is their opinion of the evidence. That's not the basis for a Frank's hearing. We're relying on our expert's opinion. They disagree. And that is a dispute that should be had, and it should be had at trial. And I suspect it will. But it doesn't give you the basis to grant a Frank's hearing.
The audacity of this fucking broad.
Defendant next, the next area is the footprint. There was a footprint found outside of DM's bedroom. They claim that the inclusion of this was misleading. But again, there's nothing misleading about the statement. The statement says during the process of the crime scene, the investigators found a latent shoe print. It was located during the second processing. It came back using a presumptive blood test and showed the presence of cellular material. They let the judge know that it was outside the door to DM's bedroom, located on the second floor, and it's consistent with her statements. Yeah. The investigators provided the magistrate the information they had at the time of the investigation. Defendants' opinions about where the shoe print should have been located and it couldn't necessarily have been located there, again, that just doesn't rise to the level to warrant a Frank's hearing. Again, our case doesn't hinge on the identification of this shoe print. Neither did the PC affidavit. There was sufficient probable cause with or without this information. I'm going to address grand jury subpoenas. They didn't discuss it today, but it's addressed in their motion.
Yes, before you get to that, can you address the allegation that the cell phone data was, I guess, purposefully erroneous as to the time that the phone was no longer reporting, which then relates to the supposed position of travel?
Right. Well, I don't know that I completely wrap my head around the defendant's logic in this.
I have to, so help me out.
Well, I still don't understand.
I understand her statement and her argument. I'm trying to understand your response.
I guess what was reported was the information known at the time that the probable cause affidavit was given.
By
There's
Detective Payne? Or by the
the
cast member?
information that he was given from.
This goes to my first question about imputed erroneous statements. So I understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the cast specialist know that there was a misinterpretation or an erroneous report?
I don't think that you have before you a sufficient proffer that proves that the cast specialist submitted false information. Apparently, there's a difference in the handoffs of 7 minutes. At the end of the day, Okay. No, I don't think it's incredibly material.
Material, if you look at it in terms of where the phone was in that 7 minutes,
Well, it's material.
going a direction different than what your affidavit says it was going, isn't that material?
The direction of travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman. I mean, this assumption assumes that cars can't change direction of travel. We're assuming that then the same cell phone, which was then turned off, isn't then also tied to the evidence.
That's
We
exactly
do
what we're
have
saying.
Information to believe a white sedan tied to Mr. Kohberger is then found on surveillance.
She just
We're
choked.
not talking about 7 minutes. We're talking about 7 minutes at 2:50 in the morning, which is about an hour, approximately a little over an hour before the crimes occurred. I don't follow the logic that
You have the car on camera
this
at
7 minutes,
3:27.
an
It matters.
hour and 10 minutes prior proves that there's no way the defendant couldn't have traveled the 7 miles to Moscow, whether or not the car was pointed in a different direction or not. It's a leap for
You just told them that your PC is a lie. You just told them that.
Does that answer?
No.
Well, it's your answer. So
It's your answer. Haha. Yeah, bitch.
Let's say it was.
She wants to continue on.
Let's say that it was exculpatory. Let's say it was materially that it was false. It was recklessly included. It wasn't, but let's say it was. Well, the magistrate still had enough information before her to grant probable cause for the arrest. So we still don't get to a Franks hearing, even if you want to make that leap.
The University of Idaho graduate.
I can quickly go through grand jury subpoenas. At the end of the day, their desire still, this has come up several times throughout this process, their desire to see the actual grand jury subpoenas is not the basis for a Franks hearing. There's just simply no legal basis to support that idea. And there is nothing obtained that was obtained in violation of any of the defendant's constitutional rights. They say they needed to know the scope, but it is not clear to the state how that would have made any difference in the probable cause determination or why the magistrate would need to know that. Again, this just appears to be another attempt by the defendant to try to obtain these federal grand jury subpoenas. And I submit to you, Franks is not the proper avenue. We're going to go to lack of connection. I think this has already been addressed by Your Honor. At the end of the day, this fact just has no bearing on the probable cause determination. The investigators relayed the known information they had at the time, and timing is important. At the time of the application of most of the warrants, the evidence taken from the defendant and his vehicle was still being reviewed. We didn't know if there was a connection. Only a few warrants even fell outside of that. Apple, YouTube, Instagram, TikTok, PayPal, and Microsoft. However, even for those warrants, the state submits to you that fact's not necessarily exculpatory. The defendant's belongings and the vehicle were recovered approximately 6 weeks after the homicides. And that fact was known in the probable cause affidavit. It could be reasonably inferred. But to the extent the court believes that law enforcement should have included this information, again, I can accept that, but it's not enough to outweigh the balance of the information that was included that did establish probable cause. I submit to you the defendant has wholly failed to establish a single false statement or omission without which the magistrate would not have found probable cause. I ask that you deny their motion for a Franks hearing. Thank you.
Thank you for bombing. Okay, she's like, I thought you were gonna touch over. Wow, here we go. Come on, Ann. Come on, baby, don't let me down.
I'll try to do my part to make you, so that you can and avoid asking questions unless I'm truly stumped.
Before I get started on what I want to tell you, in response to what the state said and then my summary, I'm curious about the new police report that was talked about. I didn't see it in the submission given to Your Honor.
I've had such an avalanche, I can't think of what it is off my head. If it did, it certainly wouldn't be part of the analysis for the court in determining whether or not you've met your showing to have a Franks hearing.
Well, that's good because it occurred after my Franks briefing came. So I didn't get a chance to respond to that yet. All right, let's start with the grand jury subpoenas. And yeah, we wanted those in discovery. We didn't get those. We were told no a couple of different times. The issue with that is that at least one of the warrants was used, the returns from the grand jury subpoenas, it used the return from the grand jury subpoena to obtain information. And we don't have those, so we don't know the scope and parameters of that. So the magistrate relied on something that's not reviewable by us. And that's kind of gotten to be
Amazon.
Sorry?
Is that Amazon?
It is Amazon.
Boom.
And the return on the search warrant says that they already produced them pursuant to something else. And the affidavit says, we saw these things, so now give them to us in a search warrant. That just seems to be problematic to me. It's kind of the same thing that's laying on pretty thick here. You can't have it. We're not going to tell you about it, but don't worry, we didn't do anything wrong. And that's a problem. That's a theme of this case, and that's really a problem. So I think we should have a Franks hearing to explore what that really is about, if for nothing.
What's the omission or the misstatement that as it relates to the Amazon?
The date, Ann.
Warrant.
The omission is the FBI used the grand jury system and obtained this information outside of the warrant process. But for some reason, we need to come and get a warrant because nobody gets to. I have them in other cases, Judge. I don't know why they're withheld here. It makes me really suspicious.
Well, I mean, I guess from a Franks perspective, though, the question is there a material intentional misstatement or a reckless misstatement?
From Frank's perspective, was it material? Well, it was relied on to get the warrant, right?
It disclosed to the magistrate that this was the result of information given as a result of a federal grand jury.
It absolutely was.
What did they say that was not true, or what did they fail to disclose?
I think they failed to disclose the parameter around that grand jury subpoena.
How is that? Well, I understand. I promised I wouldn't slow you down, so I'm going to let you just go ahead.
Okay. I'll go backwards. The 7 minutes that's not disclosed, that's intentional, that's not given to the magistrate to make the decision. There are a lot of these things that are intentional withholdings and a lot of things that are deliberate. You heard a lot earlier today about the hours of meetings that took place and the decisions to keep certain things secret. So I think we've satisfied the prong of deliberate and intentional withholding from the magistrate or deliberate false statements to the magistrate on all of those areas. I want to talk only about a couple of other things. The credibility of the witness that they talked to, the one that they cited information from, that was relied on. That appears in these affidavits, and it's relied on after Mr. Kohberger's identified to say, well, he has bushy eyebrows, so this person has to be right. It's relied on when the police officers put into the affidavit the footprint that I didn't talk about on my first one. We gave the court the photographs of it. I'm happy to give the court these. That's a misleading statement to the court or to the magistrate that was asked for probable cause. This footprint is at the very edge of the door. It's a single footprint and it's not repeated throughout the house. So to act like that bolsters this witness is really important, especially in context of the misstatements of the witness. I want to go through these. I won't read them in their entirety to the court, but Your Honor asked the prosecutor what they were. And I counted up, and at the very first interview, remember the issue was whether or not one of the victims ran downstairs. And she didn't say it once. She said it 4 times in a row in the very first interview. And that just didn't happen. It just couldn't have happened. And that was not told. In fact, that statement was brushed over and withheld from the magistrate. About the memory issues in the second interview the same day, there are 2 references to not remembering. A couple of days later, there's the third interview, and there's references to not remembering, being drunk, a statement, I don't know any of it. Like half this stuff, I don't know if it's a dream or if it's real. That's at page 399.
Told you she was drunk.
At page 406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definite statements that were not given to the magistrate and in fact were brushed over. And credibility is really, really important when that person is relied on in the investigation. So let's talk about the vehicle. The court asked some questions about what the magistrate could see in the PC affidavit. The way it's laid out would cause one to think that the vehicle's identified on the camera near the house, and that's not so. It's not identifiable. The state's expert said it's not identifiable from that particular video. It's piecing together the other videos that they come up with something.
What's the evidence that law enforcement relied on the Ridge Road footage to identify the vehicle?
What did they rely on?
What's the evidence that they relied on Ridge Road, which you say doesn't show anything? What's the evidence they relied on that to ID the vehicle?
They relied on the Ridge Road camera, and you can see that in the emails from IMO and the other law enforcement officers when they say they have Paradise Creek Road, and then they say we finally got a good one, and it produced to us is the 1125 Ridge Road footage and photograph, and that's the only one that you can make a positive ID on the car.
Where is that in the record?
The 1125 Ridge Road. Well, it's in our discovery.
Or is it in the motion? And
I believe we put a picture of that in our motion. I can look at it's in my original memorandum. I think there's a picture of that. Let me grab that page for you.
I fucking love Ann Taylor, man. The whole damn team. We're gonna be throwing back shots, baby girl. Don't you worry. This is I don't even know what to say about this case right now. I don't even know what to say about this case. what a mess. What's up, Miss Pops, baby girl? Shake it. I just want to say thank you guys. You guys can be watching anywhere and you're choosing to watch here, right here. Truth and transparency.
And I believe it's on
Thank you.
page 17 of the amended memorandum.
That's just the photograph.
Yes.
But not the information that ties that to the Ridge Road camera.
Your Honor, it's tied by our argument based on our review of the discovery. I don't have an affidavit from any police officer saying it was that. I probably don't have an email other than the ones from Immel and that transaction that we did provide for the court, that was the video that the identification was made on. That, I'd love to know more about that as well, Your Honor.
Well, but that's not the standard.
I understand that. I understand that. I would refer the court to our exhibit with Agent Immel's communication. I believe that is going to be at D9, and then the pictures contained in the Frank's motion. Let me talk a little bit more about IGG, even though we've done that all day long today. I would remind the court that IGG doesn't identify a person. It suggests a family group, and an investigation can happen from there, but nothing happened until the IGG happened behind the scenes and in a closet. That brings me to talk about the intentionalness of this in an overview. And the court should look at the entire picture of what's happened. It's a long investigation. It's a complicated investigation, but you have law enforcement repeatedly meeting and you have FBI agents sprinkled in. And there are a lot of things that you've heard about today that are withheld, that are super secret, that nobody's going to talk about. And there's a lot of meetings that are happening, particularly around the IGG. That's a definite, we're not going to put that in there. But there's also the communication about the AT&T records, about what do those phone records mean? What does it mean when there's calls being handed off or phone tower reporting being handed off to track a vehicle? What does that mean? There's communication about that. There's review of the videos together. And what these things mean is that a partial picture was decided upon, a picture that left out a lot of detail, a picture that gave false statements to the magistrate to get probable cause to get that first AT&T warrant. That was, the officers went back and forth talking about what kind of statements to use. Statements were changed to be included in that, and definite decisions were made at that time. The decision was made to leave the witnesses' statements in as they were, even though there had been interview after interview after interview, and they knew those were incorrect. The decision was made to build a false investigation and leave out the super secret IGG part. And that decision was made based on the behavior of the agents and based on not wanting anybody to review what they did so that we could check their work and see if they did anything right. That just continued with decisions to leave things out in this case. Probable cause doesn't get determined by one little thing without context, especially when there's context of omitted information. That's why we have the opportunity for a Franks hearing, to ask for a Franks hearing and to offer information for your honor to rely on. It is imperative that there be integrity in the warrant process. There's a lot of power in going to a magistrate and having no attorney there, nobody to cross-examine, nobody to question. There's a lot of power in that to obtain a warrant. And there's a lot of danger when there's that much power too. To leave just a little out here, to add a little more here, and go get a warrant and then build everything that comes from that. And that's what happened here. Your Honor, we ask for a Frank's hearing to more fully explore these. The court can see this is a massive amount of information. The court has 1,000 pages. These aren't just pages that we made up. There's a lot going on here, and we need to have a hearing to fully explore this. Thank you.
Adjourn for today. I will DG under advisement. I will take the issue opinions on those forthwith. We will pick up tomorrow with trying to think. We're probably at the evidence on the motions to suppress tomorrow, correct?
Yes, Your Honor.
All right. I'll see you in the morning.
Boom. This is going to be so good, you guys. Thank you so much for joining. We've been live streaming for 8 hours and 44 minutes. 8 hours and 44 minutes. And I literally only got up from this chair, I think, twice. You know, I have a lot to say. I think I'll first start by saying,
you know, based on the kind of the judge pointing that out, like if there's additional evidence is necessary.
I'll first start by saying hi to Allie Bob. Yeah, I'll first start by saying that Ashley Jennings is absolutely off her fucking rocker. I think she just blew her fucking leg off in that hearing. I mean, whoops. But if you guys have been following this channel, everything that we said was going to happen has happened. A lot of people were part of that, you know. A lot of people have either emailed me or messaged me messages in here, and then we do the research. We go and try to get the goods to acting like 7 minutes doesn't matter. That just tells you how contradictory that they truly are. How long do they say it took to kill 4 people? To hear there is blood of another male. A male's blood is on the railing. Up and down the stairs like that railing. A male's blood that is not Bryan Kohberger. They're unknown male blood. How does blood get there? That's kind of bombshellish to hear that. To find out that the AT&T warrants 1 and 2 only separated by an hour. Wow, unbelievable. By the time that they got the warrant 1 back, they, an hour went in with the other one. We find out that the dog, you guys, the dog had no blood on it. The dog had no blood on it, and it was in an open room that none of the doors were closed. Remember, none of these doors, were closed. Where was the dog? 25 minutes after the vehicle goes away, for 25 to 30 minutes, a dog is barking straight for 25 to 30 minutes. Remember I asked you guys that? I said, you're going to sit here and tell me that these girls heard a dog, which they, I thought that Kaylee was just playing with the dog. Okay, why do you think that's so important to talk about that? Well, I don't know. The dog barked for 25 to 30 minutes straight, but it was after the vehicle had left. And so what? And if all this blood and the dog has no blood on it, the paws of the dog have no blood. Did they even truly check the dog? I mean, who knows? Dylan is texting people what she saw. And that's, excuse me? How could you sit here and say that she was frozen in a shock state? What are you talking about? And that's why she didn't call 911 for till noon the next day. This is just absurd. And then just to hear, I think Hippler is doing a little bit of like devil's advocate when he's asking something, because he would have read these briefs, right? And so he's already prepared for questions that he's going to ask, but he's asking things that's not even what this is about right now. And I'm not going to sit here and argue my case. I'm not here to argue my case. I'm here to argue what we're doing. And I can't believe Ashley Jennings just literally blew off her tits in that hearing. I mean, I think I could beat her pro se, and I have no problem saying that. And you can call me a cocky conceited prick. I don't give a shit. I know this case. I think I could have argued against her. Normally what happens when you get like Hippler, I think, is wrong. When all of these things, just because you get a name from IGG, let's say, and because like, oh, here, like the sheath is clearly planted. That's clearly what's going on here. And the question is who planted the sheath? All right. We're not sitting here saying that law enforcement did. All right. But if there's no fruits to anything else, how can you not argue that everything else doesn't lead to Bryan Kohberger? So why aren't we being good investigators to say, wait a second, man, how is nothing coming back with this dude? And here we have unknown male DNA in the house, and it's blood on the banister to go up and down the stairs, where somebody, according to Dylan, was running up and down the stairs, and that somebody was Kaylee. Kaylee was running up and down the stairs. Dylan said that the person that she saw was 5'8", skinny white male. Excuse me, but 5'8", skinny white male. If he was dressed all in black, he had a mask on. How do you know that wasn't a female? Oh, because I heard them talk. So now the person talked, the killer talked. Oh, don't worry. Is that the whole thing? Don't worry, I'm here to help you. I'm here to save you. Whatever that bullshit was. Bryan Kohberger is nowhere. Bryan Kohberger is a lot taller than 5'8", bushy eyebrows, and now we found out in this hearing that they also showed Dylan a picture of him, and she didn't recognize him, and that's why it's in the probable cause affidavit when it says that Dylan didn't recognize him, but it was just so misplaced. Like, then Ann said it best. Like, this whole narrative of how they got to him is just a complete lie. They didn't get to him by the WSU. Everything that I fucking said, Ann said it. I even think that I could have probably said some arguments better than Ann. And that's fine because she has to do all this shit. I mean, I would have argued that they were when he wants to talk about, well, once it was a match, it was a match. No. Hippler, every time that they were submitting a probable cause affidavit, it had all of those other lies in it. Okay. So, everything in February, it was building, because that's what you guys said. It just kept building off of it. So every time you're just turning in. And then I would have made an argument about Dawn Daniels. That's where I would have went with my Dawn Daniels argument, which would have been like, well, Your Honor, there is a woman that said, no, I'm not going to put in the probable cause about the IGG because should it be suppressed? Clearly, Dawn Daniels had a reason to think that it would be suppressed, or that it could be suppressed, and I don't want our search warrant to go with it. Well, why aren't we at Dawn Daniels had enough wherewithal, and so I would have used that in my argument. Maybe she did in all of her. We were just hearing a little bit of it, and I'm telling you, all of everything that I'm probably saying right now, Ann said, but literally to see Ashley Jennings trip and literally fall on her face for fucking 10 minutes. I loved it. I personally loved it. I think liars, the cream always rises to the top. It's always going to come out. And to hear that Ortham had it and that they couldn't get anything off the IGG, it's because they didn't cheat. And when I say cheat, it's just an easier word for cheaters to understand. There's a policy in place. So we couldn't make anything of this snip off of what we had. We couldn't do anything with it. There was nothing that came back. So the FBI takes it over, and then somehow the SMP doubles in size, and then the FBI, voila, here's the name Bryan Kohberger. And that's why I think it's even better to show that, there is something that Ann Taylor was saying the whole time. You should be questioning that sheath is, wait a second, guys. Come on. What's going on here? It looks like this is a frame job in a way, because we're doing our due diligence to check on this lead. It'd be no different if I told you that it was Bob. Bob Smith is who did it. Well, first of all, you want to know my reliability, and you'd want to say, okay, why are you saying Bob Smith did it? You got to give me something more than that, right? And then you would look into Bob Smith. You wouldn't just go and arrest Bob Smith, right? So when you start looking into Bob Smith and you start seeing, dude, there's like nothing, all the fruits, nothing's coming from it. And then you start wondering, wow, well, let's look into this tip, or like, and so if you do it in the term of like this sheath, well, God, you guys, these roommates are all over the place. They took so many hours to call. Maybe the real killer planted this knife sheath. Right? You're going to sit here and tell me out of 120 people that never came up in conversation, that knife sheath could have been placed or planted, whatever word you want to use. It definitely would have, especially if you're going 6 weeks and you don't have a killer. And nailed it with integrity. If you're willing to violate your own terms of service, what else are you willing to do? Everything was done in secret here. Okay. The FBI proved in this hearing that they violated their own terms of service. They uploaded Bryan's DNA or whatever is on this SMP like it was their own, paid $12 instead of going through the channels, and then used the loophole. And is what they said that they did. So they're admitting that they violated their own policy, can't show any of their work, refuse to show any of their work, refuse to show a receipt. Oh, and they say that we can't show a law enforcement receipt because we didn't pay for it that way. We didn't do it that way. And then so if they're willing to do that, okay, awesome. The state argued that, and said, Ashley Jennings says, well, that may be my DNA, but I don't know how it got there. Like the defense is trying to have two arguments. Me saying that maybe my DNA, I don't know how that changes my argument on that it's still a violation of everything. And the big violation to me would be that you're just passing along to different agencies, because how do we know? I don't know what. Then they talk about the trash. The FBI, we found out it was instructing the trash collectors how to get this trashed. So basically the FBI burdened the state. And that shouldn't be the state's burden then to overcome, since they fucked it up. Why is that going to be on us? Well, you guys called them in. I said that this was all going to come down to this whole confidential informant reliability type thing, and Touch DNA is not reliable, okay, as it is. So much so that Indiana doesn't use Touch DNA. So we found out today that Officer Payne lied when he said he found out about Bryan's name on December 19th, because in this hearing, it came out that the first time that you knew about Bryan was on December 23rd. They did not know about Bryan's name until December 23rd. So I don't know if that was a misspeak, but Payne testified that the first time he heard Bryan's name in the last hearing was on December 19th. Thought that was interesting. And so you just find out about somebody on December 23 and you arrest them on December 30th. And you're just able to, boom, go get all this stuff and do all this stuff. And all of your searches and where are the fruits? What are the returns? Okay. And then we find out the truth, which we've been saying here is the affidavits are a group effort, right? And so Judge Hippler says, well, who am I supposed to, like, who would get in trouble for this if it's a group? Everybody. You all played a part in it, especially if you guys were having meetings twice a day. You guys were being debriefed and briefed twice a day. So, I couldn't believe it. The interview, when Dylan was interviewed 4 or 5 different times, we found, drunk, doesn't know anything, heard her roommate, Kaylee, running up and down the stairs. You guys, just because I'm texting somebody about something, like when I get done with this and I text somebody about, oh my God, did you just see what happened on that hearing? The hearing happened, hours ago. But my text to that person, how are you gauging that that's just right when that would have happened? Think about it. Okay? If I say something and I put it in a text, unless I'm writing, it like, oh my God, what the fuck is going on? Do you guys hear that? I want to hear, because Ann Taylor said like the context around it. But to hear that Dylan wasn't in a frozen shock state and that she was texting whoever it was and saying about what she saw. Then we find out Dylan said that she thought that she heard somebody crying in the bathroom. Why did she think that somebody was crying in the bathroom? I have no idea. I don't know how 4 people are getting brutally stabbed to death and nobody's screaming. Dylan said that, that she was drunk, that she could have been dreaming. And then Ashley says, well, clearly she wasn't dreaming because look at there's a crime scene. Do you understand how easy it is for somebody to just tell somebody, hey, you're going to write this and write all of this stuff and say all of this stuff? And actually Dylan and those 2 girls be part of it now? I mean, this is unbelievable. So basically their argument is that in the probable cause affidavit, Payne knew what was said and he's watering it down. And then, so think about this. Bethany clearly has what Bethany has. And I can't wait because I don't think that she's not dumb. Like, I don't need to tell you certain things. And Hitler was asking for certain things. It's like, I'm not going to argue my case. Like and she said it. She's like, that would happen. Like, oh, you try to get me there. I'm not going to fall for that. She said that, but Ashley said that, well, we know what she said was true because the officers walked into that scene. So of course she wasn't dreaming. Of course she didn't, dreaming. Remember this whole thing? She opened up her bedroom door, came out, go back. Like, what is all of this? She says that I have memory problems. I have memory problems. Everybody was dead in beds. Okay. And, her to say that somebody was running down the stairs. And you guys know where her room is, right? Like, you're going to know if she says that Kaylee was running down the stairs, her room is right there. Her door's open. Doesn't she know what Kaylee looks like? So then think about the wounds on Kaylee. Okay. Kaylee was running down the stairs. Why would Kaylee be running down the stairs? Well, because Kaylee was trying to get away from whatever, you know what I'm saying? Her family thinks that Kaylee was trapped in that room. Well, DM is saying that DM saw Kaylee running down the stairs. Why would she think that Kaylee was running down the stairs? And she used the term running up and down the stairs. I know that there's ways that I could. The reason I know that it was Kaylee is I know what Kaylee's voice sounds like if I didn't see her or whatever. They said that the 1112 camera, and I know why this is probably why it hasn't surfaced, is that you can't make out the car. That their own expert says that camera we can't use that probably for our software, right? Again, I couldn't believe the dog barking. Couldn't believe it. The dog barked for 25 to 30 minutes. And I don't know if it was consecutively, after this alleged white car left. And that every single, the room, the dog was found and the door was open. In all the rooms where the victims were located, the doors were opened. And this dog didn't have any. And so then are they trying to, and Ashley Jennings doesn't think, she's like, we didn't think to have to tell them that the dog was barking for 25 minutes. No, what you made it seem like is that the dog scared the person and ran off or some shit like that. Who the fuck knows? But it's wrong. The geofencing, that's like the cell tower dumps, and Bryan's number was not in there. Then blown away by this, 242 and 244, they lied in the affidavit and left it at, because it would have fucked up their whole thing, leaving his residence. So, and when he shut off his phone, 7-minute difference, the way the car was facing. Ashley Jennings says it doesn't matter because can't cars change directions? Well, you do understand her argument there just literally solidified a Frank's hearing. Because you're basically saying that, yep, and that means that white car that's just circling or doing whatever it is, how do we even know it's the same vehicle? Just unreal. I cannot believe that she oral argued it. She just oral argued herself into allowing a Frank's. But that the 7 minutes doesn't matter. The 7 minutes doesn't matter. I think, and then she started losing herself because then she didn't know what she was saying. Because Ashley, the way that time works is if that would have started 7 minutes later, okay, then Bryan Kohberger can't be the white vehicle that you have at 3:26, in Moscow, because he'd be 7 minutes behind. Just think about it. It's just so stupid. Like, oh, Ashley. So, but she doesn't think that, any of that matters. That we have evidence that shows that the vehicle is facing a different way, and the way that it's reporting and handing off to networks, we have Bryan's car going this way, out of Pullman, right? But you have Bryan's car going this way. And Ansar just says they relied on a false narrative. The magistrate relied on a false narrative. The cast wasn't. They made it seem like Bryan Kohberger was stalking. He wasn't stalking. He never been to that house. Doesn't know them. That they offered, the proffer was about the hands off and the patterns, and that it's exculpatory. Bryan is somewhere else at the time that they say that this crime happened, right? He's never been at that house. The phone records show that those patterns, the phone records show it all. Then here comes Ashley, and she's like, you know what, Your Honor, they got to show a substantial preliminary showing. It's such a high burden. Well, we got you, girl. You're going to get us there. She said that the 20 pages of the PCA is of facts. God, it's 20 pages worth of facts. It doesn't matter that it's just all facts, though. Okay. Those officers were doing briefs 2 times per day. Well, then you think that you guys would be communicating it like perfectly. She said the defense takes umbrage with the fact that the way that the PCA was used as a working document, and they would just like, at the end of that day, somebody would just add another paragraph to whatever it is that they learned and found out. That's just wild to me. That's just crazy. You know how many things that's all they found out is 20 pages worth of facts? Somebody was just like writing in like, here, we're going to go with this little paragraph today. We found out a new name. The guy that did the surveillance, looking at the cameras, that would be Hill, Special Agent Hill. Jennings messed up and said 3 towers, and then Hitler was really concerned about that. Oh shit. DM, we found out DM was shown a picture of Bryan Kohberger. A picture how? Like a 6-pack? And you just show him, hey, do you know this kid? Remember I told you guys that? I was like, and that's where that whole little statement. DM said that she didn't know him. And so that's when we just assumed that that's when the killer left. Because DM said that she didn't recognize the guy. But that line, that's DM saying she didn't recognize him when a picture was shown to him. Fuck. DM said that she believed it was a white male, 5'8", heard his voice. He was slim, skinny, lean, built, 5'8", and that she was texting, and told this to people. Told people about a masked man in her house, I guess. You don't know what these text messages say, but when you put the text messages together with the timestamps of these text messages and DMs just saying what's going on, and that for some reason she didn't call 911 for, and that was never brought up. It was never brought up with Your Honor. I think a big portion that we're missing here is that if she's text messaging about what she's seeing, why didn't she call 911? Or did she reach out to people instead of calling 911 and ask people to come over? And they're like, we're not coming over. We're passed out. We're drunk. We'll come over in the morning. What do you mean? Like, I cannot wait to hear about this tomorrow. Unreal. Just unbelievable. The 1125 Ridge Road camera is 0.3 miles, which is 3 minutes, Ashley says. And then, fuck shit, I don't know. There's a corner house area, and then that's where the defense is like, well, why isn't it on that camera? Basically alluding to the fact that, well, if it's not on that camera, remember they said the killer didn't travel this way because we were looking at cameras that didn't have things, so we're excluding that. Just wild. She's like, we were told that, she said, we were told not to include the IGG and to develop probable cause separately. Okay. And that's what they did, because the IGG just inculpates him. And it's just like, what are you talking about? The IGG is a lead, Ashley. It's like anything, right? And then you're supposed to build a case. And if you would have been building a case, okay, you would have kept coming across roadblock and roadblock and roadblock, kind of like you did. And so maybe Hitler's just playing dumb, but build a case. Develop your probable cause separately. Here's us giving you this. And guess what? It separately doesn't build it. It doesn't build it. And if Megan Marshall wants to lie and say that, yeah, if I would have been... Ann says it best. You heard it here first, though. I said they made that PCA to design to say that they found Bryan Kohberger in November by the WSU guys. That's the way that it reads, and that's why the magistrates going on this narrative, this fairy tale narrative. That's not how they got to him. So that's a lie. Okay. And Ashley Jennings doesn't want to touch on that. Ashley Jennings says, or I'm sorry, Ann then comes back and says, oh, no, Ashley Jennings says that the IgG was confirmed by STR testing. So I just can't wrap my head around how this is not what Ann Taylor can't understand, what she can't get. That has nothing to do with the probable cause that you elicited from building and doing your, investigating. Because if you're not using it, then build a case without it. And they lied to get probable cause. And that's what I don't understand why Hippler's even talking about it, because IgG wasn't used. So stop talking about it and exclude IgG, okay? Because they didn't use it to develop probable cause. So with this shit that they are presenting here, was it enough to get probable cause? And was it true? And was it true? And the answer is, well, maybe it was enough to get probable cause, but was it true? And the answer is no to that portion. No, the shit that they put forward wasn't true. God, I mean, is that such a hard argument? Like, it's just there. I felt Ann struggled with that part though, because it was just like, set the IgG aside. This is about the PCA. Focus on the PCA. And so Hippler, on what you're trying to tell this court or ask me about is, well, at the end of the day, the garbage that they obtained matched the parent, blah, blah, blah. Okay, take out everything of the PCA then. Why not just go with that? Why not just go with that? If you think none of this other shit matters, then why don't you just go obtain this guy Bryan Kohberger's DNA, because the FBI gave us the name Bryan Kohberger, and so we went and obtained his dad's garbage because he was there thinking that we would come across his DNA. Well, we came across the parents, and then it said that it was that was the biological father of the sheath, and then just arrest him. Right? Because my question to the courts would have been, well, would that be enough? Would you issue probable cause for what I just said? The FBI gave us the name Bryan Kohberger. We realized that Bryan had already left for winter break. So we took our happy asses down to Pennsylvania, lifted the parents' trash. Then we had them tested against the sheath, right? The DNA on the sheath, but not the DNA that's on the banister that has blood on it. And then realized it's the parent of whoever's blood this is, or what's on the sheath. And so there you go, done. Isn't that all that would be needed according to Hippler, right? That's basically what he's saying. Wild. To this day, they were not able to get any of the grand jury subpoenas, which is what led law enforcement to get, for them to go and get things. They got the information from, the feds. And at the end of the day, no fruits came back. No, the state didn't drop any bombs on us. Like Ann Taylor was dropping some bombs in there. The state, what did Ashley Jennings tell us that we didn't know? That we were just like, damn, I didn't know that. Holy shit, wow. Holy shit, wow. Nothing. Then Ashley Jennings slips and falls over. I told you guys, the 7 minutes wrong way, facing the wrong way people change car directions all the time. Blowing up literally her own shit. Blowing up her own argument. The 242 to 244 cast specialist knows it was wrong. The connection, she said, after he was arrested, we got the YouTube, the TikTok, the Microsoft, the Google, his car, and guess what? Nothing came back, right? What came back? And Taylor gets back up there and she said that, you know, this whole Amazon stuff is the FBI outside of warrants, and like that's where that stuff came from. She said that this timeline that they want to put this all on matters, the 7 minutes matters. It was intentional that they misled the tribunal. The bushy eyebrows, it all went to this timeline. It all went to the ID. It all went to, this is when you're saying the time of the crime happened and that you're putting my client there at that time. I still don't know why they're not talking about the fact that how are you passing off the one car for the other car? I don't understand why that argument has not been made. How can you claim that a car over on WSU's campus is the same car that's over here, 20 minutes away on that campus? Why? How are you saying that the one car there is the one car there? I just blows my mind. About fell out of my chair. You guys saw it when they talked about the footprint. It's at the edge of the door. It's at the edge of the door, and it's one, and it just has nothing to do with anything. Answer wanted us to be reminded that IGG does not ID a person; it identifies a group, a family. Then she said there was intentional. The recklessness was intentional, and here's my overview. They were having meetings twice per day. They knew what they did with the AT&T stuff didn't match. They were reviewing these videos together. The integrity of this whole thing is all fucked up, and you have to stop it, Judge. The power in obtaining warrants with what police officers can do, it requires integrity. Okay, because there's so much power in going and obtaining these warrants. And that is why a Franks hearing is needed and necessary. Because the recklessness, the intentional recklessness, and the lack of integrity in this investigation. The power that the police have, that law enforcement, the government has right now. And with that, she submitted. Thank you. 9 hours and 21 minutes. I got to go. I love you all. We had 108 people or multiple people at some point submit on the either Cash App. Again, I got another one coming in here, so I want to say those people's names. You guys are amazing. You guys have been here, for a lot of this. So, again, let's see. I want to thank all the mods. I mean, shit. They're awesome. The mods are just awesome. Gray Pubes. Got to give him a shout out. Jonathan Lee Riches. Anybody that I talked about on the channel. Everybody that's been covering this case. But 108 people, just thank you so much. They believe that the blood on the hand railing was possibly someone from the outside the house. I mean, it's blood. It's not. It's blood. It's unknown male DNA. Blood in a house. It's all bloody, and we don't care about it. The only thing between the two crime scenes was Dylan's latent shoe print. I don't know. I don't even think about it. Super sticker. Thank you so much. $20. Silva. Thank you. Lana Superstar. Oh, the mods are fabulous. And I didn't even have it was just running nonstop. So they were probably thank you so much, WB. Wonderful. You look wonderful tonight. I'm going to have to edit the hell out of this. The judge is not looking at any documents. She states he is just sitting there leaning into his hands. Yeah, he was, I guess. I don't know what to say about it. Tomorrow, we're going to be back at it remember, we have a whole another day tomorrow because now we get to hear about all of each warrant. You guys, we're just getting warmed up. We're just getting warmed up. Oh, Miss Potts, member for 23 months. Love you so much. This is all absolute crazy. It is. And anybody that says that this is fucking normal, okay, go fucking roll some more fucking whatever it is that you're doing. What about the white undercover cop car that was driving around that area? Yep. I submitted that as a tip. Storm to answer $10. Demand why the hell they did not do any testing on the other 3 DNAs. I know if I was a parent, I would be. Hippler basically said, well, basically all that you're saying here is that Bryan Kohberger just didn't do this alone. Oh my God. No wonder why law enforcement lied about Bryan Kohberger saying, did you guys arrest anybody else? I mean, this is just absolute disgusting. I can't wait for it tomorrow. Fucking can't wait. This is sick. Fuck everybody. Bye-bye. Craziness. Nothing makes me happier than Lana's reactions. Yeah. It could have been worse, guys. You could have been watching News Nation or some shit. I think I got everybody right. Truth Seeker, 22 months. And then everybody that was buying memberships for everybody. I know that Kay Miller did it. I know that A to Z did it. A lot of you guys did it. Thank you guys so much. Appreciate you guys. Much love. Whew. All right, over and out. Same time tomorrow. So I'll go live at 10:40 a.m., which is, I'll go live 10:40 a.m. Eastern Standard Time, which is 8:40 a.m. their time. They go live at 9, and it's all, it is all public. Whew. All right. Peace. Stay safe. Good night. Thank you. Hella. Thank you. Oh, wait. One last ring.